Day. This forum seeks to be a forum for dialogue and opinion sharing in order to better understand the special mechanisms of the Commission, you know, as well as to enrich discussions on the thematic priorities of these mechanisms. Uh, Yesterday, we had the opportunity of discussing, of having rich discussions on the following themes: human rights as a development imperative of sustainable development imperative. The second was to align ODA and investment on social and economic rights. And then we also heard about the promotion and the protection of the right to health. Thereafter, we had a session on inclusiveness in development, and the sixth session was postponed to today. So today we're going to start with the respect of life and human dignity for harmonious and inclusive development. So this panel will focus on the protection of life of individuals and protection against torture, exploitation, and cruel and degrading treatment, which will be an additional asset for development. When the population is sound and resilient and protected, they are better equipped to actively contribute to the progress of their country. This panel will be chaired by the Honorable Commissioner Atem SIM, with the participation of Honorable Commissioner Idris Sasso, Honorable Lucia Dos Passos, the third Vice President of the Pan-African Parliament, Mr. Alan Ngari, Human Rights Watch, and that will be followed by a Q&A. Thank you very much, and I'm going to give the floor now to Honorable Commissioner Atem SIM. Good morning, ladies and gentlemen. So we're going to start the sixth panel of our forum, which will focus on the sub-theme, the respect for life and human dignity for harmonious and inclusive development. So I have the honor this morning to discuss this theme with you in the company of Commissioner Idris Sasso, Mr. Alan Gari to my left, and then Madam Lucia Dos Passos will join us via virtually. She's a third Vice President of PAP. Now I think it is somewhat difficult for me to the theme of torture is difficult to align with sustainable development, but we have found areas for discussion, and among these four topics, so these four trusts and themes, the first is the respect for life and human dignity as a bedrock for sustainable development, the protection of human rights and degrading treatment are principles that are non-negotiable for international law, and their guarantees are indispensable for a favorable development, favorable environment. So a society does not protect its citizens against exploitation and violence cannot aspire to real progress. And secondly, I could place the theme of security and the resilience of the population and health as a prerequisite for development, because a population that is not protected in its dignity and its physical and mental health, its population will not be able to actively participate to development. A pacified populations where there is no violence can have access to effective justice mechanism. It strengthens the confidence of the citizens in developing the country. The third topic is the fight against impunity and the strengthening of the rule of law. The prevention of the right to life uh, hinges on solid institutions and control mechanisms and an independent judicial system. A very popular sociologist said that justice is the bedrock for development. The fight against impunity for the serious violations such as torture and so forth are necessary to re-establish confidence and prevent abuses. The fourth topic is the integrated approach of human rights in human policy and the right to life. They have to be part of all strategies in education, health, education, employer, and justice. And the respect of these rights create, contribute to Agenda 2063 of the African Union. We need to also point out that there are cases in our countries, especially where development is based on mining and extraction. We deal with companies that mistreat workers, where the respect for human dignity is not often established. So I wanted to point that out under the sub-theme of today. So without further ado, I'm going to give the floor to Honorable Commissioner Idrissa So, who's going to talk to us about one of these sub-themes. Thank you, Honorable Commissioner Tem. Thank you for giving me the floor to contribute to this panel. But first, I'd like to express my greetings to all those who are taking part in this morning session. In your preliminary remarks, you try to draw a link between the right to the protection of life and the right to development. There is no right to development if the life is not protected. I think if you look at the Charter, the African Charter on Human and People's Rights, it clearly states that the preeminence of the right to life is primordial. There's no debate about that. In this morning's discussion, I like to establish the link between the right to the protection, the protection to life, and the context of combating terrorism. Honorable Chair. the state also has to do everything to prevent attacks or uh, punishment from the defense forces and defense and security forces. For example, in the Sahel, it is important in the fight against terrorism. We have witnessed mass killings that has really shocked public opinion, like what happened in Besogo and recently in Solenzo in Burkina Faso. All these are violations of the rights of citizens to the protection of human life, whereas legal instruments oblige state to protect citizens against all these attacks. We saw the defense and security forces that attack civilians as reprisals just because they're reproaching them for being in touch with terrorist groups. And in my opinion, that is against international law and against all standards ensuing from the legal instruments developed by the African Union and more specifically by the African Commission on Human and People's Rights. But in addition to these rights to protect civilians, the states are also obliged to deal with the root causes of terrorism. That's another method of protecting the right to life, because terrorism has root causes, and I think our commission has adopted the observations formulated by the Peace and Security Council during its 456th meeting, where it stated that the states have to deal with the root causes, the lack of rule of law, injustice in the distribution of resources, social exclusion, and all these issues have to be properly addressed by the state to effectively fight against terrorism. More, there is also the need for cooperation. States need to collaborate among themselves to fight against terrorism in order to better preserve the right to life of the population. And to this end, there are positive obligations and negative obligations. For as far as positive obligations, states need to pool their efforts to prevent and fight against violent extremism and terrorism by exchanging and sharing information, cooperating uh, on the on the military standpoint to respect international and humanitarian law. There's also negative obligations. States have to refrain from supporting terrorist activities in other states. They shouldn't allow their territories to be used as rare bases for terrorist activities. They also have to refrain from providing any kind of support, be it logistic, financial, to terrorist activities in order to destabilize other states. So you see that these obligation to cooperate is very important and is very clearly from the legal instrument that the guidelines on human rights to fight against terrorism. There's also another obligation, which in my opinion, is very important. The obligation to respect the rights of all the belligerents fighting against terrorism. When I talk, what I mean by that is the people who are even suspected or arrested in this case. It's difficult to say because states have the obligation to fight against terrorism, but they also have to respect the human rights. When I was saying, I actually have in mind an answer that was provided by a head of state, and we actually reproached him for people who haven't treated well those who are arrested for terrorism charges, and said that we are the ones who are terrorists. We are not terrorists. This means that states have obligation towards terrorists, human rights. And the guidelines actually clearly stated this. I said people arrested uh, for terrorist activities need to be treated in accordance with national and international law. So they have to benefit from all the for guarantees of fair trial. So it's an obligation as incumbent on states to respect. So there's also another that really interested me in these guidelines is that there's a role left to the civil society to play, and this guideline provides the possibility to civil society to question the organs or call on the AU organs about the protection of citizens uh, on the consequences of terrorism. So this is shared responsibility both on the state and the civil society in strengthening the protection of the right to life of citizens in the context of the fight against terrorism. So, Mr. Chair, I would also like to say something regarding the death penalty, which you, as you're well aware, is another component of the right to life. The death penalty is one of the most difficult issues that we are trying to address today in our respective mandates. You see, the legal framework, the African Charter on Human and People's Rights, does not really specifically talk about the death penalty. We talk about death penalty through provisions of Article 4 of the right to life, and Article 5 talks about the right not to be tortured or to be subjected to degrading or cruel treatment. This doesn't mean that the death penalty is absent in our legal framework. There have been so many resolutions, soft laws, that have been developed by the Commission calling on the state to exercise moratorium on the death penalty. To describe the situation, the trend is of abolishing the death penalty is increasing on the continent. The statistics that we have show that Africa is tending towards abolishing the death penalty. Just about a dozen that. Well, if you allow me to talk about the challenges that we face at this level, so the states, in the context of violent extremism, they don't want to abolish the death penalty because public opinion cannot understand that at the time that we're dealing with issues and challenges related to terrorism and violent extremism, it's difficult for them to convince them about accepting the death penalty. So maintaining death penalty is not a guarantee for a greater security. So the strategy that we have today in the African Commission on Human and People's Rights regarding this death penalty, our objective is still clear: universal abolishing of the death penalty. We have cultural and religious reference that we cannot ignore and that we shouldn't ignore. So to these states that have decided to maintain the death penalty, we're simply requesting that there should be a solid moratorium. That is the request and the doctrine of the African Commission as stated the general observation number 3, and this is in accordance with the doctrine in the International Pact on Civil and Political Rights. So I think time is of the essence, and we don't want to go any further. So we'll discuss the rest in the upcoming discussions. Thank you, Honorable Chair. Is Madam Vice President online? Honorable Lucia, is she online?
Yes, she is. Good morning to everyone. Please feel greeted. I have no os microfones na sala. My reflections on this topic on the Pan African Parliament aims at ensuring.
Just leave it, or else you might be interrupting. See,
This is a moral, legal, political demand enshrined in the African Charter of Human and People's Rights, as well as in the Agenda 2063 of the African Union, which outlines Africa's aspirations for a future where the first aspiration refers to a prosperous Africa based on inclusive growth and sustainable development. This growth will only be truly inclusive if it respects and promotes the dignity of all African citizens, irrespective of their origin, gender, social condition, or capacity. Article 4 of the African Charter of the Human People's Rights on the right to life provides that the human being is inviolable. All human beings are entitled to life and physical and moral integrity. No one can be arbitrarily deprived of this right. Article 5 of the same Charter on the Respect on Human Dignity states that all individuals are entitled to respect for their dignity, human dignity, and the recognition of their legal personality. All forms of exploitation and degradation of the human being, namely slavery, trafficking in persons, torture, both physical and moral, and cruel, unhuman, or degrading treatment are forbidden. These principles are also enshrined in the Universal Declaration of Human Rights and in the Constitution of many African states. But beyond the text, human dignity implies that everyone is treated as an end in itself and not as a means. This also implies the protection of life against all sorts of forms of violence, equitable access to fundamental rights such as health, education, justice, and the recognition of every individual regardless of its social, ethnic, religious, or gender status. Dear participants, ladies and gentlemen, a society that is inclusive and respectful of human rights and human dignity will create the conditions for their inclusive development, inclusive and harmonious development, because when life and dignity are protected, social peace reigns. And then we'll have less violation of rights, less unconstitutional governments, less civil war and terrorism. On the other hand, the violation of dignity, such as corruption, discrimination, state violence, and social exclusion, weaken cohesion and hinder progress. Today, despite the efforts of the African Union, armed conflicts, terrorist violence, military coups, human trafficking, forced migration, and unhuman conditions of detention, degrading treatment, and the marginalization of people with disabilities and minorities are phenomena that put to the test our continent in fulfilling its commitments on the respect for human rights. And we do need to call a spade because we are witnessing a, res- a resurgence of conflict in our continent. And we can highlight the issues such as psychological violence, which is one of the worst forms of torture a human being can be subjected to. And we now see uncertainty with the growing conflicts in Africa. When we have a country that borders a country facing a humanitarian crisis, our situation becomes that of uncertainty. We witness a psychological and emotional suffering which is faceless. And people with this uncertainty now start thinking, what if tomorrow will continue with my normal status, or will I be stateless or refugees? So we cannot produce statistics of all of this, and these are phenomena that are marking the life of a whole generation, especially our children. It's easy to present statistics and numbers of refugees and stateless people. But those who are living without emotional dignity, we do not have these stats because these people have an invisible face, and which end oftentimes in a silent death of depression and will eventually cause physical death in certain cases. We need to reverse this situation by strongly investing in the awareness of our communities, particularly our children, our youth, and women. Also invest on human rights. We should use all forms of communication to inform, educate, to train people on human rights, which is an essential asset that cannot be negotiated. And therefore, I present some recommendations that can be developed to allow an inclusive development in our countries. First, to strengthen the human rights protection mechanisms at national and regional level through the effective enforcement of the instruments adopted by the African Union. Educate for dignity from a very early age in schools, in households, and in the media. Severely punish the violations of human rights, even when these are committed by the state. Systematically include the vulnerable groups in our development policies, and above all, place the human being at the center of our economic strategies. We should not be afraid to discuss the issues. Our continent is facing one of its worst moments in terms of the respect for human life, with the unconstitutional government, civil wars. We should together face these challenges, the Pan African Parliament and the Banjul Commission. We should leverage our synergies, strengthen partnerships, and work together for the well being of the African people. If we need to develop model laws, which the Pan African Parliament has been adopting throughout the years, including those on people with disability, and we're now working on a model law on gender equality. This is to shield our continent against torture and other flagrant forms of violation of human rights. Honorable Chairperson of the Commission and Commissioners, we should be firm. The Pan African Parliament and its President, Chief Charambira, and all its members from the 54 member states, we are indeed firm in this struggle, and you should and must count on us, because this is our responsibility to be the voice of the African people. And this voice can be expressed by the production of model laws. And we also should leverage artificial intelligence and technologies to educate our populations to the protection of their rights. Thank you for your attention.
Thank you, Madam Vice President, for your presentation on the theme of the day. It's my pleasure now to give the floor to my neighbor to the left, Alan Gary, who talks about the experience of Human Rights Watch, and he has worked in several organizations on human rights, transitional justice, and in other areas. So without any further ado,
Honorable Commissioners, distinguished panelists, ladies and gentlemen, thank you for the opportunity presented to us to address this important panel on the fundamental right to life and human dignity, which are foundational principles for harmonious, inclusive development across the African continent. At Human Rights Watch, we document and advocate for the protection of basic human rights across the world, including in all African countries. Our research consistently shows that where life and dignity are violated through unlawful killings, torture, exploitation, or inhuman treatment, development falters. Conversely, protecting people's rights creates the conditions for peace, stability, and progress. I'd like to focus my brief remarks on three main points. The first is protection from state violence, and let me pause here and just acknowledge and fully associate with the comments and the presentation by Commissioner So as it related to terrorism and violent extremism in African countries and the threat to life that civilians face as a result of these terrorist groups, but also non-state groups. I will focus mostly on state violence as a first pillar in my discussion, and secondly, accountability for abuses, and finally, an inclusive development that respects human dignity. So on to the first point on protection from state violence and arbitrary deprivation of life. Across the continent, many citizens face threats not from foreign adversaries, but from their own security forces. In countries such as Sudan, in South Sudan, in Nigeria, the Democratic Republic of Congo, Human Rights Watch has documented systematic abuses by military and police units. And this include, like I'd mentioned earlier, extrajudicial killings, executions, including those of protesters in expressing themselves to the freedom of expression and assembly, and enforced disappearances has been also a marked feature in terms of state violence, but torture in detention, including beatings, sexual violence, and electric shocks. For instance, and this was prior to the conflict that is unfortunately unfolding in Sudan, during the pro-democracy protests, hundreds of peaceful demonstrators were killed by security forces. In Nigeria, the notorious abuses by the now disbanded SARS police unit prompted widespread calls for reform, but accountability has remained elusive. I will also mention that in Nigeria, for example, in support of the presentation by Commissioner So, the fact that Boko Haram has perpetrated violence on citizens in the northeastern side has been something that has completely robbed off citizens in that region of their life, but also dignity. But the responses by the state, which have been excessive, security forces which have been excessive, have also robbed citizens of their lives, their dignity, and other rights as well. The state violence not only violates the right to life, but it sends a chilling message that citizens' dignity is expendable, it erodes public trust, and it weakens social cohesion. My second point is on ending torture, cruel and inhuman or degrading treatment. Torture is still used in many countries to silence dissent, punish opposition, or extract confessions. From notorious prisons, and Human Rights Watch recently documented the Korotoro detention facility just outside of N'Djamena, survivors described harrowing conditions And this is actually prevalent in a number of detention and prison facilities across the continent. Overcrowding, beatings, mock executions, and denial of medical care. The use of torture is often shrouded in secrecy, but its effects are visible in the fear, trauma, despair it causes. And this undermines national unity and mental health on a large scale. And I think the component of mental health is something that we need to be really alive to, that these violations really tend to cause to destabilize the mental health of many, not just those who are victims, but those that are around them through vicarious trauma, etc. And in this regard, we are urging the Commission to press African states to ratify and implement the optional protocol to the Convention Against Torture, but also that states would establish independent national preventative mechanisms against torture, and finally to ensure access to lawyers, families, and medical care for all detainees. And we did some research in northern Nigeria, where Boko Haram, or suspects of terrorism offenses allied to Boko Haram, were held in detention facilities, but their access to the lawyers, their access to medical facilities was curtailed by the state, and they were held in detention facilities that are run by the military. The third and final point is development must be grounded in human rights and dignity. Sustainable development is not just about infrastructure or economic indicators. It is about whether people, especially the most marginalized, can live with dignity. In many regions across Africa, in Mali, in the DRC, and in Tanzania, our investigations found that development projects often involve powerful companies, have led to forced evictions without adequate compensation, child labor and dangerous working conditions, violent crackdowns on communities who resist. We also see how gender-based violence, especially during conflict or displacement, continues to threaten to a secondary concern, even though protecting women and girls is essential to the well-being of entire societies. For development to truly be inclusive, it must protect people from abuse, it must provide justice for victims, it must center the victims in processes on justice, it must also empower communities to shape their own futures. So this is where the concepts around transitional justice in its entirety, and not just selection by certain states on what pillars of transitional justice they should take, but the entirety of transitional justice in a holistic manner will ensure that this development is then attainable to citizens in Africa. And I suppose the final reflections that I will make, Commissioner Hatem, will relate to a welcoming of this commission to focus on life and dignity as a bedrock for development, and this panel is really testament to that. And to advance these goals, we are recommending to the commission, one, to strengthen follow-up mechanisms on implementation of past resolutions and decisions relating to torture and killings. Second, we are also encouraging states that are present here in the room to establish independent oversight and police and security forces, particularly in the context of counterterrorism operations. And finally, to engage development partners and private sector actors to ensure that economic growth respects human rights. Above all, we must reject the idea and the notion or the false choice between security and rights, or between development and dignity. A truly prosperous Africa will only engage when all people, regardless of class, gender, age, or status, are protected, respected, and empowered. Thank you for your attention.
Thanks a lot. Thanks. Merci beaucoup, Monsieur Alain, pour cet exposé exhaustif.
Alain, for this exhaustive presentation. We're used to it when we deal with Human Rights Watch. We will now open the floor. Let's begin with the state representatives. I see the representative of Sahrawi. Please, you have the floor.
Est-ce qu'on peut aider Monsieur l'ambassadeur pour avoir un micro?
Merci beaucoup, monsieur le modérateur, de me donner la parole. Merci aussi à tous les panélistes qui ont tous été très clairs dans le diagnostic de cette question. Maintenant, ma réflexion porte sur le cas des violations des droits de l'homme qui sont exercées, par exemple, dans des zones occupées, comme le cas du Sahara occidental, ou dans des zones où il y a des puissances étrangères qui s'introduisent et s'ingèrent dans des pays africains. Bien sûr, vous savez pourquoi, pour...
Why? It's for the exploitation of natural resources or to cause confusion in these areas. The question is, what can the African Commission on Human and People's Rights mechanism do in dealing with such dangerous situations, and especially to pave the way and give visibility to victims of such situations who are quite often civilians, and what can this mechanism do to exert pressure on our African organ for decision making so that they should make these stakeholders responsible, these stakeholders who violate the rights of our citizens. Thank you. Thank you for your question, Mr. Ambassador. I am still calling for members of our states. Is there anyone else who would like to take the floor? I see the DRC. And I don't see quite well. There's someone else. Then there's also South Sudan. DRC before South Sudan. Mr. Advisor, you have the floor. Thank you for giving me the floor. I would like to react to what has been said about the DRC, that the population is threatened by security forces. What they say does not really tally with the reality. There's a difference which should be made between the former regime and the current regime of President Tshisekedi. Since he came to power, efforts have been made towards respecting the rights of citizens as enshrined in the Constitution. The security forces currently in DRC do not threaten the civilian population. So there are practices which date back to the former regime, but which we continue to blame on the current regime. There's a constant and real effort which is being made in the DRC now to respect human rights. So what has been said dates back to the former regime and not in the current regime, which has humanized even the security services. Today, officials of security services have the duty to humanize their services and prohibit torture within their services. Furthermore, President Tshisekedi has close all those areas where they were arresting and remanding people in custody in security services. That was in the past regime and not in the current regime that such prisons existed. So follow the speeches of the current president. He stands for the respect and protection of human rights as guaranteed in the Constitution. I thank you.
I would want to know how the Human Rights Watch get their information, because the methodology sometimes they adopt is on they get their information from third parties and not directly from even the victims that they're alleged to have been their right been violated. So I have, from my work within the human rights files, I have seen this been done in South Sudan, the UNOMIS Human Rights Division and sometimes the Commission on Human Rights in South Sudan doing the same mechanism of reporting. When we verify the information, they are not facts. So I want to know, how did you got all this information of the violation of human rights in South Sudan and the extrajudicial killing that you are talking about? Thank you.
Merci. Est-ce que vous m'entendez? Non. Merci, Monsieur l'ambassadeur.
Thank you, Ambassador. I'll give the floor to the representative of Cape Verde.
Thank you, Chair, a team. I would like to first of all commend all the panelists for the presentations. The presentation by Commissioner Saw, the representative of Human Rights Watch, and also by the third Vice President of PAP. My friend and representative and MP Lucia Duspos. I would like to quickly make 3 points. The first one has to do with one important aspect that was during the intervention of Commissioner Saw and the representative of Human Rights Watch. It has to do the difficult management of the tension that exists between the objective of ensuring to citizens the essential good, which is security, and on the other side, respect human rights of those perpetrating or performing terrorist activities, who in the ruling of law, there should be respect for the human rights and defense, because as Commissioner Saw said, if we don't ensure the defense, respecting the right for defense of those of the implicators, we are behaving like them, or even worse. And this is a very challenging, it's a difficult challenge that we have. And that takes me to the representative of Human Rights Watch regarding the recommendation, so that mechanisms are created to supervise the police activities. This is a proposal that we agree has Cape Verde with great satisfaction, because this is something that we lack. And our government thinks that adopting such a mechanism can help us to strengthen our community, because here about the police and security forces. Reality continent, but I would like to share about good practice countries that can be used as my third point. I talk about 2 points. One has cooperation. The result of that cooperation related to declaration of moratoriums, the application of the death penalty, and share with those who are not aware of this reality that in the Portuguese-speaking countries, we abolish the in our criminal codes in our countries, and this was a result of years of strong interaction between member countries. Result of the death penalty in our countries, and we congratulate ourselves on the result of this operation. To the importance of so mentioned about and agree with his position about this subject. Thank you.
Thank you for your attention, for enlightening us. I'm still checking in the room. Is there any country which would like to take the floor? NGOs, national human rights institutions? The NGOs seem to be getting tired. I don't see anyone else second the floor, so I'll give back the microphone to my colleague, Honorable Commissioner So. Thank you very much, Chair. Can you hear me? Thank you, Chair. I would very briefly like to respond to the questions put to me. The very first attempt would be in relation to the brilliant contribution made by the Ambassador of Verde in relation to the balance that we should find between ensuring security of the citizens and the obligation to respect the rights. You know, a principle which we are defending in the African Commission on Human Rights, that is, the principle we are defending is that rights guaranteed under the Charter should be implemented and applied in all circumstances. And what stems from that is the fight against terrorism. And no other context should be used as pretext to go beyond the fundamental rights. So it behoves on all the states which are facing security problems to ensure that in the fight against terrorism, the preservation of the rights of the population, fundamental rights should be respected. And when I say fundamental rights should be respected, it's in regard to this, civilians and the persons who are involved in this. That is the reality. Not long ago, I was on a mission to Chad. The authorities allowed us to go in and see the prisons. Within the framework of this visit, I met persons who were detained within the fight against terrorism. That's the area of Boko Haram. They were detained in prison. And when I had conversations with the authorities, they know that they're imprisoned, and this proves that they did not follow extrajudicial procedure. But we shouldn't stop at that. And that is a responsibility of the state. The state should ensure that they are given human treatment in prison within their remand in custody, but there should also be fair trial. And that is our objective. As I said a while ago, states cannot use the same weapons as terrorists because we know the law and we shouldn't go beyond the law. And these are obligations which stem from our international conventions. We cannot use terrorist methods against people themselves in this situation. You also talk about, I can't hear the microphone itself. I think they should change this microphone. So you talk about the abolition of the death penalty. So I wanted to use this opportunity to congratulate your country for abolishing the death penalty and to congratulate Zimbabwe, which has not just abolished but accepted the non-optional protocol on the International Covenant on Political Rights on the death penalty. It's a difficult issue, I said a while ago, especially as states security problems, because quite often they don't understand how they can go in favor of abolition. They are facing security problems, but there's no direct link between the application of the penalty and the guarantee and the security. And it has not been proven that in states where the death penalty has been abolished, crime wave has increased spontaneously. So we continue to advocate to states to go in favor of abolition of the death penalty. As a result of this security crisis, the people question moratorium, which is already taking place in some countries. The proof is what is happening in the DRC, where there is a moratorium which has lasted for more than 10 years. It's been questioned, and it is indeed for our office. We have written to express this concern. And there's also the desire to reintroduce the death penalty in some countries where it had not even been abolished. So we have experienced different positions. As I would like to call to states to stand in abolition of the death penalty. For countries which have not yet done so, to suspend the death penalty and activate the moratorium. That's what I had to say. Thank you. Thank you, Honorable Commissioner. Would the Vice President want to take the floor? Be connected. So I give you the floor for your final comments. You have the floor.
Thank you. No direct question was addressed to me, but I would like to emphasize what Commissioner has called the Commission to work together. The Parliament Commission on Human Rights and Justice that has this mandate, and the fact that in the Parliament we have representatives from political parties, from member states, from opposition, and which allows us to have transparency sharing information. For example, what from DRC mentioned, I think we can clarify this situation with a report that was presented by our Commission on Human Rights together with Commissioner from Banjul, and we had a joint visits to, we can have joint missions to these countries like Mali that are facing these situations. Why do I say this? Because we don't have any commitment with the ruling parties, but with the population, and we will be sharing a report of the situation faced in prisons by the refugees, by the population, and also report what are the measures that the government are implementing. So this is makes us the voice of African people to talk about the people defending the right to human life and dignity. So we believe this a call to strengthen the partnership between the Parliament and Banjul Commission so that we have joint missions and assess the situation and present reports at the continental level. Thank you.
Thank you, Madam Vice President. Comments.
All the states that I think it's important to recognize where development has happened, where reform has taken place, and join obviously a civil society and where made to address rights violations. But I think the point of this panel was to actually draw the parallels between the violations of the right to life, the violation of other violations, dignity, and connect them and link them to development issues. So there still subsists, just because things have changed, and if there are violations that happened in a previous regime, for example, then it means that there are survivors, there are victims who will still need support of this for them. There will be from the state in order for them to address. That's the whole process that we encourage, that states will take into the victims and survivors of harms and violations that have happened in the past. Our methodology as Human Rights Watch, we employ a whole range of mechanisms. We directly engage with victims, hear from them directly. They tell us the sorts of violations that they have experienced. Our responsibility is to document these violations with a hope that we are able to convince states that they should turn victims and address their concerns. Whether victims say that they have been abused or their rights violated by states, I think it is important for us to recognize that the primary responsibility to protect the rights of citizens is with the state. And when they say they're not being protected, then obligation to ensure this is remedied. And I want to thank the ambassador from Cabo Verde for his intervention. I think the that making around oversight and accountability that is quite relevant for the continent. Commissioner So has spoken extensively around the counterterrorism context and how in that context we need security forces, military forces, police and others to have in fighting violence done within the confines law. Two wrongs do not make a right, as the violent extremist groups or the terrorist groups it's not. And in terms of good practices, and this is actually a practice that has come from documents that has come from within the context of the global counterterrorism, is there are good practice documents, and one specifically around and accountability in the context of with a focus is focused mainly in counterterrorism context. This can be transposed to other areas as well. The point is that the mechanism should be part of that mechanism, how that mechanism should operate, their mandate. I think such documents really is that the ambassador was asking that we point to. So I encourage states on these good practice documents. Thank you.
Merci beaucoup.
Thank you very much, friend, for all the presentations you've made. So then, this discussion, I see that established between of and aspect of life and development. I like to make a comment. The respect and treatment, unfortunately, the practice against medical only in situations of conflict killed in our country to education. I'm calling on these people to protect lives. So concerning what was said by the representative of the Republic of Sawa Arab Republic, Sudan, understand that they are concerned to identify and provide answers. We have taken note, and the in charge of your countries have also take note, and this discussion can continue on that item throughout the state of rule of law in the continent. It's not the subject of current discussion. Without further ado, we are really lagging behind, and I'll to my colleague for the next panel. Watch.
And the right to development. To moderate the back. Also, Excellency, of Eritrea. Kiso Alpha Hassan, Cabo. Monitoring. Dr. Kennedy. Eugene Zwatini.
Historical and contemporary interface with the rest of the world, while it is one of the poorest continents in both GDP and human development terms. Even strikingly, as the background study on extractive industries, environment and human rights highlighted, the natural resource endowment of rather than. Thus, McCartan, Humphreys, Jeffrey Sachs, and Joseph Stiglitz out, and I quote, despite the prospects of wealth and opportunity accompany the discovery and extraction of oil, impede rather than further balanced and sustainable development. Although this is a huge subject, aims to what conception and form of development does Article 22 of the African Charter demand? Advancing the dilute Africa despite its vast natural and human resources endowment. And finally, Article 22 of the Charter, read with other provisions of the Charter, Article 21 and 24, necessitate for the development trajectory of the continent. Commissioner, yeah.
For my chair, industries, and also in my capacity as the chair of the Indigenous, who exposed by extractive industries. Professor Wangari Maathai, the lead winner, said that Africa is rich. It is the people who are poor. I don't know whether we agree with this statement and how long we want to continue being poor. So I have presenters here that are going to be of the reflections on the questions that have just been posed. Thank you for me. We know that a lot of read thrillers, very best-selling novels about Africa's challenge of being poor, yet it's rich. And we know scholars that have spent a lot of work. But Jeffrey Sachs spent considerable time on this. So, answer the questions that have been asked. I have speakers here with me, some online. With me here is Barrett of the Embassy of Eritrea. Welcome, Ambassador. We're pleased to have you speaking to us for. Also have Madame Bakisu Sindabo, who will be joining us online. He is at the African Free Trade Secretariat in Ghana. So she's getting 10 minutes online to give us Miss Agnes Abajuni, rights, who is going to be splitting her time with someone from an indigenous community, the Batwa community, who are going to share their experiences on a new concept that has come up that is called forest vision. And I hope he's going to on that concept so that we know what we are talking about, and then when the case study is shared with us, we can understand. Then after that, we'll have Dr. Kennedy who will be sharing with us a positive experience for fortress conservation from Namibia. Welcome. And then lastly, we have our own Eugene, who is going to share with us his reflections on this topic. We don't have much time, so what I'll do is I'm going to give to share with us reflection on this topic. Ambassador, floor.
Thank you, moderator, for the opportunity. This is the first opportunity for us and my delegation to participate in the special mechanism of the ACHPR. Really prepared to make this intervention, but once to do so, we accepted. So I'll try to be on sharing my reflection and actually also to express my attention to the quality of the discussion that we witnessed yesterday and today, curiosity, and even it goes to the extent of critical reflection on that of the Commission. It's really encouraging when we go through the African Charter that it contains many important provisions on the development that is for discussion. Actually, the SHP was then adopted. It was a time when African countries were pushing for a fairer and equal treatment at the international level. Is that African countries pushing for the new international order in the United Nations. Even though through time this headed from our discussion and reflection, at that time it had very critical provisions as indicated in the paper 22, 23, 24 also contain this. So what prevented countries from reaching the level of development? We can address it from multiple angles, but it's important to underline that the right to development is not just a single, it's a right that enables other rights in order to ensure the right to health, food, education, justice, equality. It all requires sustained effort, long effort, huge investment. It can even take generations. We start it and other generations will finish it. So the right to development is a very important right that should be given adequate attention. When we talk about why Africa did not make inroads in those, I think the right to development also requires peace and security. You cannot have development if there is no peace. Countries that are fighting, especially before the 60s, for self-determination, they had other priorities. Even now, we talk, there are multiple areas of conflict in our continent. So to make sustained investment, to mobilize our resources and human resources, it requires peace and stability. And also, it needs any corporation that has created any sustainable service or product need to have strengths. Fragility doesn't go hand in hand with development. So in order to ensure right to development, we need to have strong states, resilient nations, and development-oriented governments. At least in our case, in Eritrea, the way we look at development is it's an exercise that should be based on our capacity, that is self-reliance. Self-reliance doesn't mean isolation. We primarily use our resources and engage with our partners or neighbors, friends, in order to fulfill short gap. And it also means owning one's development agenda. It's only one a community can develop, a society can develop through, first and foremost, through its activities. And in terms of implementation, it requires mobilization of popular participation of the people. And the end result should be divided equally among the population. That is social justice, what yesterday our Tunisian colleague was telling us, and also we can call it equity. So, but there is an international element as well. Africa joined the international system from an equal perspective. It was subject for colonization, trade in human beings, later who became slaves, for them slave trade, but us, it was sale of human beings. So, and later on, after independence as well, our resources are not traded fairly. We don't get our money's worth. So this is history, but it has not been completely erased from reality. Even at present, our engagement with the external world is not equal. So this has to be taken into account. Just to give some examples of why Africa has not developed, any cursory reading of UN or AU documents will show us every year, especially the last couple of years, we have around $89 billion of IFF flowing illicitly from Africa. Africa pays around 163 billion to services debt, while the ODA that flows is around 42 billion. So you can see the level of negative outflow or inflow. Remittance payment, which could have benefited Africa, also requires a huge amount of tax. So Africa also pays a lot to address climate change, the effects of climate change, which it has not played any part in creating. So in order to point out some of the recommendations, in order for Africa to make progress, internally it's imperative to have peace and security, strong states, durable nations, development-oriented government, as we were saying, and internationally to end the exploitation of Africa and ensure that Africa benefits primarily from its resources, be it raw materials, and also for us to engage in value addition. We should not continue to export jobs by exporting raw materials. And we should also strive to create equal partnership based on mutual interest and mutual benefits. And as a continent, we need to put the right to development as the center of the human rights discourse. And now we try to point out in our international statement that the international system is going through change. So the change that comes, the system that comes, should not just be another system that will treat us, again, unfairly. So we have to strive to make it a fair system. So in terms of, since we are now in the African Commission on Human and People's Rights, I think, and the other part of the African human rights architecture, it's important that to emphasize the elements with the Charter dealing with development, the right to development are upheld, are highlighted. And the implementation of this depend on peace and security, so we need to see more activity from the African Commission on ensuring peace and security in our continent in order for states to have the ability to mobilize the resources. They need the agenda, the development agenda at the center. So we need to see more, especially when it comes to collective rights that would enable us. So I think the Commission should also play its part in advocating for a just international system that benefits Africa and for the end of exploitation of our resources and the overhaul of the system that would lead to a more equal and just international system. I thank you.
Thank you very much, Ambassador Binam. I think you have set the stage for us. Strong states, value addition, peace and security, and equal rights in the international system, as well as emphasizing on the right to development is properly entrenched in the Charter, Article 21, 22, and 24. I now thank you and give the floor to our next presenter, who is online. Madam Kabo, are you online?
Oui, je suis en ligne.
Okay, over to you.
Je veux bien, merci. Merci beaucoup, j'ai dû éteindre le...
I put off the video because I have connectivity issues. Can you hear me? Can you hear me? Can you hear me? I think there's a connectivity issue. When I turn on my video, I don't seem to hear you. Anyway, thank you very much. Thank you, Madam Commissioner. We'd like to thank the African Commission on Human and People's Rights for this obtained invitation. It's not the first to take part in this second joint forum for special mechanisms. Now, to discuss the theme that I was requested to do, that is explain what the AFCFTA is doing to develop the African peoples. So I'd like to say where we are from, what AFCFTA is from. As you know, the AFCFTA was a project, but now it's a reality. It's a major project of the African Union that aspires to develop a common market. So this project has become a reality, and this common market was established on the continent. It seeks to boost intra-African trade for more than 7%, because as you know, how do I put this now? The research that was conducted just shows that the African states do not trade among each other. Hence the development of AFCFTA among others. So AFCFTA seeks to boost African trade for more than 70%, and to take more than 30 million people out of extreme poverty. The agreement was signed and it is enforced. 54 states out of the 55 that have signed the agreement establishing AFCFTA, only Eritrea has not signed. We have 8 party states, state party. We have 48 that have ratified. So, in light of what I've just said, we can see that the AFCFTA is one of the legal instruments in Africa which will leave a trace in the history of economic integration on the African continent. Like I was saying, the main objective is to strengthen economic relations among African states by developing a market that is broad, thanks to the development of some adequate infrastructure, and of course the reduction or the elimination of tariff barriers and non-tariff barriers into trade and investment. Having said this, what what has the ATF done? You know, we are still at an stage of infancy. We have started negotiations. We have several protocols that have annexed to the a framework agreement to establish the AFCFTA. We are now trying to implement all what the state parties and non-state parties have negotiated. Like I said earlier, in the preamble, the agreement to establish the AFCFTA mentioned sustainable development and the protection of human rights. Hence, the African state decided to take into account the aspirations enshrined in Agenda 2063. In these aspirations, seek to develop a continental market with a free of persons, capital, goods, and services that are essential in strengthening economic integration. In the preamble, you also have the promotion of agricultural development, food security, industrialization, and structural transformation of Africa's economic. In the same preamble still, member states of the African Union recognize the importance of international security, democracy, human rights, rule of law, and gender equality, the development of international trade and economic cooperation. Even if we do not have a protocol that specifically deals with the issues of human rights, and even if we do not, even in the text that have been developed, issues of human rights were not specifically mentioned, but taking into account the resolution of the 2023, we have the protocol of the second phase of negotiations, because we've had the first phase and the second phase, which have taken into account the aspect of protecting and promoting the development of African peoples. I'm going to mention, because I only have 10 minutes, I'm going to mention two protocols to respect this commitment in the preamble. The Secretariat in relation with state parties and non-state parties. Non-state parties, because we have a decision of the heads of states that requires inclusiveness. Now, with the participation of member states of the African Union, the Secretariat, the state developed and negotiated two protocols. The protocol on women and young people in trade, and the protocol on investment. These two protocols contain provisions that guarantee the promotion of economic development of African people. And the protocol on women and young people was negotiated with the main objective of promoting sustainable economic and social development, gender equality, and structural transformation of state parties. So that's the objective of this protocol on young women and young people in trade. Now, the protocol that directly relates to sustainable development in Africa is that which deals with investment, where sustainable development is one of the major objectives. So this protocol develops part 4 of the protocol, made up of 7 articles, Article 24 to 30, that deals specifically with issues relating to development. So among other things, issues that were discussed under this part, we have the right that recognizes to each state party to the right to take regulatory provisions so that investments have to be compatible with development, sustainable development objectives. That is under Article 24. So many measures that are targeted under Article 24. We have the second aspects that feature under this, the respect of minimal standards of the protection of consumers. That's provided under Article 27, with a series of measures that have to be to be taken and developed by state parties. We also have the promotion and the facilitation by each state party of investments that support the mitigation and adaptation of climate change. So climate change was also taken into account by the Protocol on Investment, and under Article 26 with a series of measures to be taken. We also have Article 27 that enables each state party the right to establish its own level of protection regarding public health. So all that I'm mentioning falls under the respect of human rights. Also is also in line with the promotion of economic development of the African peoples. Under Article 28 rather, the right to each state party to introduce measures to promote national development, including local content, in order to achieve the Sustainable Development Goals. There again, in order to take into account this national development and the local content, several measures were envisaged and adopted by state parties. We also have the possibility for each state party to develop national policies to guide investors in developing human capacities. When investors to each state party, the protocol on investment applies, but the possibility was given to each state party to legislate the measures contained in the protocol to make laws and guide investors in developing human capacities. That is under Article 29 with a series of measures. And finally, we have Article 30 of the Protocol on Investment that deals with the right of state parties to facilitate the technology transfer, be it intra-regional or international transfer, using various methods in accordance with the rules and regulations of each state party. We have what is provided under the protocol, but this part gives more rights to state parties to make laws in order to develop sustainable development. So the protocol was adopted by heads of states and government, and we are in the process of ratifying it. It hasn't been implemented yet, but the Secretariat is working in hand in glove with these state parties and non-state parties, like I said, for due to inclusiveness, to make it effective. When I talk about the agreement, I'm talking about framework agreement setting up the AFCFT and all the practices that have been annexed, the annexes and the appendices. Now, to implement all these aspects, like I said when I started, the agreement to establish AFCFT is in its implementation phase. It's true that the Secretariat was developed, but we have taken time to finalize negotiations, and we negotiated and adopted other protocols. That's what the heads of state requested. We have finished, but it is high time we started dealing with the real issues, which is the start of trade among African states. It's true that the states negotiated this agreement, but it will be implemented by private individuals, so to speak, be it traders, investors, and so forth. So it, like the previous speaker said, we need peace and security in Africa to be able to implement this major project of the AFCFT. We also need efficiency, or effectiveness of the free movement of goods and persons in order to better manage the content of this agreement. I'm going to end here, maybe give further details during the Q&A. Thank you very much.
Take note of your opening remarks that ACFTA is no longer a project but a reality. What a refreshing statement. We also take note that 48 member states have ratified this document and that 54 member states have signed. And we have our brother from Eritrea here. I'm sure from here he's going to Asmara to make sure we get the 55th signature. What a timely intervention at this moment. I think your presentation has created awareness on the ACFTA, but I think more than everything else, we would like to see a closer engagement on making sure that human rights issues are mainstreamed in the work of the ACFTA. We have taken certain resolutions, including the resolution 615 of 2024, of making sure that our people are able to use local languages at cross-border, which is a human rights issue also. And we think your office is going to be working with us closely in making sure that we mainstream human rights issues in the ACFTA. So thank you very much for that presentation. Now we come back to the floor and call Agnes Kabadi of Minority Rights and give you 10 minutes, which I think you share with Richard Badosa. I think you'll be a bit generous on that, but just get started and see how far we can go. Thank you.
Thank you so much, Commissioner Lisa, and all protocol observed. I'm so honored to be here and to bring to you the discussion for today, which I'm sharing with my brother here, Richard from DRC. As we present today discussion around extractives and development of the African continent, we are not forgetting our rich diversity, the ecological diversity which takes on also our people in their diversity. And we bring to you the indigenous peoples who are part and stewards of the rich diversity we have, and the reason that development cannot be fully achieved if we leave them behind. So our discussion today, which I will leave to Richard, is going to look at the role, the presence and the status of indigenous people within the context of development and the protection of our environment. Thank you.
Merci beaucoup. Honorable Président de la Commission, honorable commissaire, Excellences représentants des États, représentants des organisations africaines internationales. Pour cette sixième journée, le titre de notre exposé porte sur la reconnaissance des droits des autochtones est essentielle pour parvenir au développement durable et à la conservation en Afrique. Les peuples autochtones et les communautés forestières de l'Afrique sont reconnus comme gardiennes ancestrales des forêts et détentrices des savoirs traditionnels uniques. Ce forum sur le mécanisme spécial reconnaît le rôle vital des peuples autochtones et les communautés forestières dans la préservation des écosystèmes et le droit de participer pleinement aux décisions qui affectent leur vie,
which concern their lives and their future. At a time when Africa wants to conciliate social justice and economic growth, our presentation advocates for the rights of indigenous peoples and forest communities in Africa strengthen their autonomy and their voice in the development strategy. We have noticed that African lands are rich in biodiversity and in the culture of the people, including indigenous persons and minorities who have lived in interdependence with this rich ecological biodiversity for centuries, with recognition of its sustainability. States which meet the socioeconomic needs are a driving force in the exploitation of natural resources through the physical infrastructure development, mining infrastructure, and other major investments. They thereby draw local and international investments which have an impact on indigenous persons. Demographic population growth and biodiversity, as well as the need for land for development, has exerted pressure on indigenous lands, forests, humid zones, etc. The urgent need and commitment of states to prevent the loss of biodiversity and the harmful effects of climate change, which stems from this on the environment. The population try to orient their legal framework on conservation. The status of indigenous persons and their role in development and conservation is always on notice. The relevance of the problem in relation to the theme of the panel: there's a problem between equity and development needs. The protection of loss of biodiversity and losses of indigenous persons who are the oldest in Africa. Their culture, their language, their means of subsistence taken in vast politics which does not include them and does not recognize them, and they are not included in the planning. States continue to ignore minority indigenous persons and communities, and states which adopt conservation models consider them rather as an obstacle and not as a solution. In certain cases, there's violent expulsion. They're expelled from their territory without any consultation and without any plans to reinstall them somewhere else where they could have a means of subsistence. Investment, management, and use of land in forest communities, notably in the land of indigenous persons, continue to threaten the existence of these marginalized persons and who are not even served at all. They have no access to economic, social, and cultural rights, the health, education, and financial inclusion. The key point is that the indigenous persons and marginalized persons are threatened by conservatory efforts, which continues to consider them as a danger and not as part of the solution for the sustainable preservation of the loss of biodiversity. I would cite the fortress conservation, which is found in several African states, especially in the DRC Congo. Human-centered development and sustainable development should take into consideration indigenous persons and other communities who are marginalized. States which have made effort to recognize the rights of indigenous persons cannot ensure that these rights are respected, to the extent that violent and forced expulsions continues without any inhibition. There's also the issue of intellectual property. For instance, the Ogiek people, whose decisions in their favor have not been implemented. Recommendations: states must exploit, state must use conservation models which are inclusive and should not continue with colonial fortresses which indeed erode the role of indigenous persons as guarantors of the conservation, taking into consideration their knowledge in the area. When states conceive strategies for conservation and development, they should efficiently include an approach founded on human rights, including free consent, and they should also take into consideration other communities whose rights and duties must be respected. States must recognize and respect the rights and dignities as well as the subsistence of indigenous persons as being important for sustainable development and conservation. States should be encouraged to ratify and apply Convention 169 as well as the UN Declaration on Indigenous Persons for states which are yet to do so. They should issue collective land titles to indigenous territories, because we cannot talk of development without access to land. The state should compensate or pay reparations to communities and indigenous communities which are affected by the fortress conservation policy. They should create local councils for indigenous persons where they would apply public policies. They should be working towards a green climate, and which would be in the favor of these communities. They should prevent violations of human rights and access to justice, and there should be other remedies which will include historical representation for intellectual property rights. To conclude, decision makers in Africa, regional level and at the state level, cannot continue to consider the Maasai, the Ogek, the Benet in Uganda, the Batwa, and others, and other indigenous groups of the region, of the Great Lakes region. All indigenous communities, as a matter of fact, continue to be marginalized and left on their own in terms of development, and they continue to ignore their existence. We need to rethink development. We need to rethink development models and conservation models, and no one should be set aside. The balance between prosperity and equity in Africa can only be possible when indigenous rights are respected through symbiotic relationships, and this will be a just and fair solution to the problem. So without indigenous populations, the forest will die. Without the forest, Africa will die, and I thank you.
This year, actually late last year, I was involved in a caucus with indigenous people, and they told me that nature is their supermarket and the forest is their pharmacy. And I think this presentation brings these points home. We have been reminded that indigenous people are the custodians of our forests and of our biodiversity, and that they are people who are forest communities. We have also been reminded that development is exerting pressure on indigenous territories, and the models that we are using expel our people or remove them, extract them from their own territories to pave way for development. So the question is this the right model? The concept of fortress conservation, I think, is a new concept to some of us. I think next time we should have a full presentation on fortress conservation. But what is it? In simple terms, it is a model that our governments are using to remove the people who have been living in the forest and with the wild animals all their lives, and bringing experts from far who come with new ideas of conservation and breeding of new animals in the forest. And these are the things we are talking about. So I want to thank the presenter for highlighting these issues, and I hope that you will be able to expound on this concept at question time, because member states are here and they need to know how best they can be able to come up with the right models for sustainable development. I now go to our next speaker, who is also online, Dr. Kennedy Karisop, who will be sharing a positive example of this concept of fortress conservation in Namibia. Kennedy, you have the floor.
Thank you, Commissioner. I just want to establish if I'm audible and if you're able to hear me.
We can hear you, we can see you.
Thank you. Thank you to the Commissioner and also to the Secretariat for the invitation to participate in this second Joint Special Procedure Mechanism Forum. As has been introduced, my name is Kennedy Karisep. I'm based in the School of Law. And in my short presentation on this panel, I just want to share what I would describe as a positive experience when it comes to forestry conservation. In the context of Namibia, we don't call it forestry conservation. We rather use the terminology that is called community-based nature conservation. And so what I want to briefly share with you is just Namibia's experience with community-based nature conservation and trade in Africa, and then just as a lesson from the context of Namibia. Of course, conservation requires, and of course environmental protection requires, amongst others, that there should be inclusion of communities, and especially indigenous or local communities that form part of the biological and ecosystems within which they live. And in the case of Namibia, what the government has tried is to introduce what we call the community nature-based nature conservation system. And it is a system that is actually aimed at having a brighter or broader network of different stakeholders in nature conservation. And the primary stakeholders really are the community firstly, but also the state, and of course, traditional communities, as well as support groups that the state brings into play that supports the community in its efforts of nature conservation. But in doing so, the government has also provided a legal framework that governs this process of community-based nature conservation. In the case of Namibia, the Namibian Constitution explicitly provides that the state should take active measures to promote the welfare of the people through the maintenance of ecosystems, essential ecological processes and biological diversity of Namibia, as well as the use of natural resources on a sustainable basis, constitutionally 95 of the Namibian Constitution. Government has also done the Environmental Management Act of 2007 for some principles of environmental management. And two of those principles explicitly speak to the idea of community involvement in natural resource management, as well as sharing or benefit sharing that may arise out of the use of natural resources. Very interestingly, in that legislation, the government also provides for the participation of all interested and affected parties to promote or to be involved in processes of decision-making as far as natural resource use is concerned. The third legislation that the government has introduced is what we call the Nature Conservation Ordinance Amendment Act of 1996. And in terms of that legislation, the government in 1996 formally introduced this notion and practice of community nature-based conservation. What it provides for in section 24 of that legislation is a structure in which the government tries to involve community members that finds themselves in communal land that is prone to forestry areas, that is prone to wildlife and so forth, and to provide for communities within those communities that live in those kinds of setups to establish committees that will help and assist government in the preservation and management as well as use of the natural resources within those areas. So what that particular piece of legislation then did was to establish certain areas that are called conservation areas. And those conservation areas are areas in which the communities live together with wildlife as well as natural resources. And the understanding with the development of these conservancies is that the members of those conservancies be part of the process of conservation, be part of the process of management, but also be part of the process of decision-making as far as wildlife and natural resources in those particular areas is concerned. So what that in principle means is when there are extractive industries and when there is need for extraction in those conservancy areas, the communities concerned that are forming part of those conservancies must be part of the decision-making process in that particular extractive process. It also means that in the environmental impact assessment processes, those communities that form part of those conservancies must also be consulted in the process of those environmental impact assessments. So the community-based nature conservancy is really based on the idea that people living with wildlife and natural resources should be the rightful custodians and therefore be involved in the management, conservation, and application of those wildlife and natural resources. It is not a self-stated process, or communities have to apply to government to establish a conservancy. And in the process of that application, they need to establish certain things. One, they need to submit a constitution which outlines the powers of that particular community. In other words, in terms of that constitution, they must establish a committee, or chairperson, treasurer, and secretary, which will be the management committee of that particular constituency. In that application, we must also submit to the government a conservation plan that clearly demonstrates certain things. One of them, how are the resources, the wildlife going to be protected? How is the benefits in those particular wildlife and natural resources going to be beneficial to the particular community? But also demonstrate gender mainstreaming. In other words, what portion of women and marginalized people are going to benefit from the establishment of that particular conservancy. If it is approved and a conservancy established, a particular area is demarcated and declared, the government gazette as a conservancy area, which is an area that is under the protection of a law, under the custodianship of the community in place, with the custodianship shareholding with the state, as well as the Wildlife Council, the traditional community that may form part of that particular conservancy area. So the stakeholders that will be involved in that community-based nature conservation is the state, is the Wildlife Council, which is an extension of the state, which is a subcommittee or council established by the state that advises the minister responsible for the environment on all conservancy issues, but also the Conservancy Committee, which represents the community that forms part of that particular conservancy, and very important also the traditional authority or the traditional communities that form part of that particular. So those are the four main stakeholders that are involved. One of the things that the government has tried in trying to empower also these conservancy areas and these communities that establishes those conservancy areas is to provide them with skills and support. And so there are also working groups. There is also what we call the Association of Community-Based Nature Conservation, which is a network of environmental NGOs that provides different kinds of training and support alongside government to assist those communities that find themselves in those conservancy areas. Currently, the government has registered 86 conservancies, 2 community associations, and has declared 58.8% of its communal land as conservancy land. So quite a lump sum of people benefit from these community-based approaches to nature conservation. In the 86 conservancy areas that have been declared, 998 people, according to available statistics, are employed. And part of what these conservancies do is not just to employ these people as reservists and as conservators in the conservancy areas, but also when there are tourism establishments like lodges within those conservancy areas, those community members are given the priority to benefit from those tourism activities within those conservancy areas. Like I've mentioned, an important part of the conservancy project is the issue of gender mainstreaming, and for that purpose, the government has enacted a gender policy which nationally applies but also applies to those conservancy areas. From the 86 conservancies that have been established, currently 11% of those conservancies are headed by female chairpersons. 33% female representation is seen in those conservancy areas. And then, of course, in the management committees, there is also a prediction that 33% are at least women or persons that come from marginalized communities. The specific interventions that the community-based nature conservation projects undertake, the 86 that have been registered, are a lot of conservation activities, but the main ones is what we also call the wildlife and nature resources corridors, which are demarcated areas that the state tries to out the tourists and local people. So there are certain corridors that are established within those conservation areas that are regarded as safe spaces for wildlife, and is regarded as safe spaces for natural resources, and also safe spaces for cultural and heritage sites within those conservancy areas. Because it is the natural resources, it is the cultural heritage and sightseeing within those areas that makes them attractive areas for tourism. And so there is that important need to ensure that there are safe spaces created within those conservancy areas so to ensure sustainable use of the resources within those spaces. All community-based areas, those conservation areas, as part of the application, is required to have a conservation. And of course, there they demonstrate how are they going to assist in the safeguarding of those natural spaces. And of course, one of the things that most of these communities have to do is to show through their indigenous knowledge systems of the areas in which they work, how they're going to use or integrate those indigenous knowledge systems of the spaces of the geographical area that they find themselves in. So those conservation plans are also important. Firstly, because they come directly from the communities themselves, but also it supports government efforts in the conservation of wildlife and natural resources within those particular areas. One of the other interventions that is there is what we call the human wildlife conflict register, because these conservancy areas themselves are not also exempt from human wildlife conflict. And so as part of monitoring and as part of the conservation efforts, the conservancy areas and the conservancy communities are required to maintain wildlife human-wildlife conflict register, where they collect data as to the type of wildlife that is within the areas, the type of predators that are within those areas, what are the measures they are taking to ensure that there is no minimal wildlife-human conflict interaction within the places that they find themselves. But also meteorological measures as part of their conservancy areas. These conservancy areas or the communities must also ensure that they predict, keep up with the weather patterns in those spaces, and also supplement government's efforts and databases in those areas.
Kennedy would like to request you to wind up very quickly because we have no time left out of the 10 minutes.
I will do so. And then, of course, the extraction, the conservancy areas or the communities that find themselves within those areas do have a right of hunting and so forth within those areas. But it is not unlimited and unregulated because they themselves must also apply for permits, concession rights and so forth from government if they want to make use of the wildlife and natural resources that they find themselves in those conservancy areas. One of the other things also that is not restricted to conservancy areas is also this concept and practice of environmental courts that the country is now involving in as an effort to protect wildlife and natural resources. So there's now a specialized court system in place to also supplement the work and efforts of conservancy areas in the protection of wildlife and natural resources. Thank you for the time.
Yeah, thank you very much for that presentation. Maybe we could ask you to send the presentation to us so that we can capture some of the important things you have raised. We were having challenges following you, and I think the best thing is for you to forward the presentation to us. Now, the last speaker is our own Eugene Zotilini. So we can ask you to at least spend 8 minutes in your analysis in bringing this paradox home. So the floor is yours, Eugene.
Thank you, Madam Moderator, Honorable Commissioner Lita, and good afternoon to everyone in attendance. I'll just speak briefly to the 3 questions that the panel has been situated on, starting from where Ambassador Benyam left off on the characterization of the international economic order as the very foundation for this discussion. Just like what His Excellency has said, I think it's trite at this point that the international economic order is inherently a colonial relic by its nature of being part of the international rules-based system, which is a direct remnant of the post-Second World War system. And I think that's where our understanding of the right to development from an African continental perspective ought to come from. And I'll explain in a bit how it's necessarily rooted in that philosophy of restoring power to Africans and restoring the ontological density of the continent within that entire system. But importantly, there's a couple of examples that I would like to give on the nature of the international economic order and why it's inherently exploitative and why it's inherently colonial. The first is on the system of economic liberalization, which resulted in crippling debt for the vast majority of the developing world, not just in the African continent, but in the so-called global south as a whole. The second one would be on investment laws that necessarily prioritize procedural violations, such as expropriation, how expropriation is conducted, but choose to ignore substantive issues such as who owns the property to begin with. Trade rules that expect vastly developed countries to trade at the same level using uniform rules with countries that are significantly less developed. All of those are examples of a system that does not serve the interests of the African continent, especially within its history of exploitation and its history of colonization, and therefore cannot contribute to a development that is conceived in the African Charter. But I want to immediately proceed to how then do we conceptualize development within the African Charter, specifically taking into account that kind of historicity. And it's important in that regard to revisit where the idea of a right to development in the African Charter comes from. It specifically came from His Excellency President Senghor, who called for language on development to speak directly to the position that Africa found itself in. And a lot of that philosophy is adequately captured in the preamble of the Charter, where the African Charter establishes a very cogent decolonial praxis, which is that the achievement of human and people's rights in Africa should be directly linked to the eradication of colonialism, to the eradication of imperialism, to the eradication of Zionism, and to the, it even goes on to say, to the elimination of foreign military bases. And therefore, conceptualization of development can therefore not be exclusively economic. It's economics. And I'll speak on that. With that perspective in mind, but not just the right to development as an exclusive provision, also its entirety. Principle of the African Charter is the rights and of is right 20. It's right next to Article 24. All are people's rights. Development from an African perspective is inherently communal, inherently collective. People's right. It's individualistic conceptualization because of the position of Africa and because of those values for Africa. There are a number of consequences for this. First one is then we read the African Charter collectively to positively benefit Africans. The African has done a great job in asking this question, providing answers to this question. I refer to the background study on which asks specific questions on the interpretation of Article 21, which provides the right for the exploitation of economic resources, and Article 24 recognizes the right to a safe and healthy environment. This goes to the usual issue of resources and how Africa interacts with other members of the international economic order with its natural resources. We have a history of inherently exploitative resource contracts which do not benefit Africans, which benefit almost exclusively the purchasers who are in the Western world. So inherently, our focus should be on how best we exploit our resources in a way that benefits the people of Africa in the way that the African Charter is conceptualized. There are a couple of implications here. The first one is transparency. Natural resource contracts should inherently be transparent because there shouldn't be anything to hide. Because those resource contracts should be for the benefit of the people. The people should definitely know what is being sold to who, when, and for how much money. The second one is consultation, because the resources are a sovereign asset of the people. The people should have a say on where is going what, where are the proceeds of those resources going, how do communities who are within proximity of these resources going to benefit. The third one is on grievance mechanisms. Where there are disputes between the investor and the state, there should be fair and equitable means to resolve those disputes that do not disproportionately benefit the investors, which is what currently obtains under status quo, where the investor is king. And that's, again, one of the examples of the international economic order and its disproportionate apportioning of power in that investment dynamic. There are other implications, as I wrap up, that speak to how our handling of our natural resources can maximize the enjoyment of Africans to their right to development. As the international economic order is tilting, just like what His Excellency Ambassador Penyam said, the African continent has to begin to imagine a new rules-based trade system, one that does not involve other actors that were previously involved. And that means, for example, we need to start thinking about creating a self-serving market within our continent, which, as you know, is something that is already happening, but should no doubt be expedited, because as the rules-based trade system is slowly dissipating, the certainty that we previously enjoyed, we don't enjoy anymore. So we should begin to think about how to move resources within our continent, to move capital within our continent, to move data within our continent without having to depend on external actors with exploitative interests. But secondly, as we develop our own continental trade system, there are obviously some legal obligations that are incumbent on parties, which our sister from the AFCTA just spoke on a few minutes ago. I think this would be a unique opportunity to really encourage state parties to expedite their obligations under the AFCTA. The operationalization of continental market becomes a reality. The second thing would be to really improve labor conditions within the continent. I think yesterday there was a lot of reference to brain drain as being one of the significant contributors to issues of development in Africa. As long as people in Africa do not feel comfortable with the conditions that they will consistently leave the continent and contribute to those that they feel can take care of them. So because of the way that is structured, development is not just about the economic consensus, it's also about the well-being of the individuals and the well-being of the community, which are able to work in a fair and work environment. Finally, I would like to speak on the issue of, as I conclude, something was done by His Excellency Benyam, obligations that are incumbent on African countries in the just transition. Because of the of our emissions, we cannot be expected the also deliberately ask that any climate negotiations be specifically rooted in climate justice. That means we demand technology transfers. That means we demand climate financing. That means we demand debt cancellation. This is a conversation that is already going on globally, but we can continue to build on this as we reconceptualize the right to development from a perspective that enables Africa to challenge the unfair international economic order and to promote the interests of the people. Thank you so much, Commissioner Lita.
Thank you, Zatilini, for that. I know we pressed you on time. We don't have much time for discussion, but I will allow any member state that would like to make an intervention and request them to just ask questions, very brief. So the floor is open for member states. Oh, the chair is asking for the floor.
Yes, it should be just to say, in the interest of time, because we are running after time, if we can allow to one member state, one NGO, and one NHRI, not for the debate, just for contribution if necessary, because we are running after. We are behind the time now. The participants, they have to have a tea break, and we have other panels are waiting. Please, thank you.
Okay. Apparently, no member state asking for the floor. Where? Oh, okay. Please make it very brief. 1 minute. Cop Vade, and then the NHR, do we have? And then NGO, do we have? So we only have one intervention from Cape Verde.
Muito obrigado, senhora moderadora. Eu nem vou precisar de minuto.
Madam Moderator, I will not take a minute. I would like to react to the greetings extended to me by Commissioner Saw in the previous session, and give an important precision. It has to do with the death penalty. Within the Portuguese-speaking countries in Africa, we celebrate the fact that we do not have the death penalty in any of our countries today. In Cape Verde, there's never been a death penalty, fortunately. And today, there's no death penalty in the Portuguese-speaking country space, given the collaboration between all member states, and which has led to the abolition of the death penalty in the last country where it did exist. And because it is a very positive information to the sister country of the Equatorial Guinea, allow me to mention the name of the country, because we do celebrate this fact. Thank you.
شكرا جزيلا المفوضة الموقرة ليثا على إدارة هذه الجلسة، والشكر موصول كذلك للمتدخلين. والآن فقط اسمحوا لنا
session. Now allow me to announce for a tea break for 20 minutes, so the participants can have a break for 20 minutes, hoping that we will come back to the hall at 10 after 12. Thank you very much.
Même si je ne travaille pas sur le territoire, sur l'opération
Oui. J'ai un projet de la déclaration. Oui. J'essaie de l'écrire progressivement. Attendez. Les préoccupations et les recommandations seulement. Préoccupations et recommandations seulement. Ça va, je vous remercie. Et il est là.
My name is Harry Obucheobe. I'm a lawyer, a director with the National Human Rights Commission of Nigeria, and I head the Department of Economic, Social, and Cultural Rights. It's a pleasure to be part of this very important initiative of the African Commission to bring together stakeholders to discuss on how to actualize the mandate of the Commission and also provide a platform for the different stakeholders to connect with a view to promoting and entrenching the culture of human rights in Africa. For me, it's been a phenomenal experience, and I believe that going back home, there will be a lot of changes in the way I view my work as a human rights advocate and a human rights worker.
No, according to the chairs,
African Human Rights Commission for this opportunity.
26, okay.
I gave the list to the ambassador, 26 or 31. Okay. Now chair is coming to me and I asked the chair, but the chair, no, we've sent the letter. He told me no. I told him, but I gave you people the list. You didn't act.
It was not 26 to 31.
No, I have to
it was options given.
No,
so
I gave you.
We're not given the first.
Because I negotiated it with the ambassador, remember? I negotiated with the ambassador. The only good thing about chair is he wants us to go earlier. So I have to call the ambassador.
So now should communicate 26 to 31? Should we communicate 26 to 31?
No, I had given that, but chair came to me and said we change it to 24. We arrived 25th. 25th, we leave on 29. 25th, 26th, 27th, 28th, 29. We arrive on 25th, 26th, 27th, 28th, 29. So we leave on 30, but chair did go even there.
So now we should wait for the...
Not we wait, let's do this
Should we
now.
confirm these dates?
Is the letter ready?
The letter is ready, you just want to put the dates and
Because
the
there is
composition.
this one, and also you have to, for the August, you have to put a paragraph. For the August.
For the August?
You know, in their note about, they said that they are willing to...
The forum.
To host the forum, yeah.
Voices, and especially in a context where the current situation worldwide is not that positive on democratic trends. So we build upon the continental norms and treaties approved by member states and their obligations or lack of obligations to report against, to be committed towards those treaties. And for us as a partner, again, we stand always ready to support those human rights and the governance organs. We have a privileged relation with the Commission, with the court in Arusha, the Commission in Banjul, the APRM, the PAP, the Committee of the Child, the AGA Secretariat in Addis Abeba, the Political and Peace and Security Department at the African Union Commission, and it's a common agreement that governance and human rights are strictly interconnected with peace and security dimension, especially when it comes to conflict prevention, conflict resolution, and investing in the soft power, though could be a bit more lengthy, but in the end of the day is more effective and efficient to prevent conflicts. Thank you.
My name is Faiza Badmos Busari. I'm the Regional Program Manager at CHPR Network, the Strategic Initiative for Women in the Horn of Africa. This joint forum has been very, informative, educative, and has provided a platform for, good discussion and good engagement across all levels. The past 3 days have involved, looking at different types of the AU instruments, looking at the reporting mechanism, and really trying to get, good recommendations on how we can intervene or get state parties to be more committed, or what the AU can do better. A key recommendation for me, and one of the things that stood out of this meeting, was the need to engage, grassroots, between the AU and the grassroots, the increased engagement among both parties. It's important that their voices are heard, and it's important that their voices are heard at the places that matter. So I think going out of this, state parties should consider engaging them when drafting reports, state reports, and then also CSO engaging them, in the process of submitting reports as well. Thank you.
Merci. Je m'appelle Julien Gandour, je suis le directeur des droits humains au ministère de la Justice du Sénégal. Alors, cette session, ce forum que nous organisons, que la Commission africaine des droits de l'homme et des peuples organise ici au Sénégal pour 3 jours, c'est un forum de réflexion sur les droits de l'homme en Afrique pour voir comment les experts qui se sont rassemblés ici peuvent voir les voies et moyens d'améliorer la situation des droits de l'homme en Afrique. Il s'agit d'un forum qui concerne les différents mécanismes qui sont instaurés par la Commission africaine des droits de l'homme, qui promeuvent les droits de l'homme en Afrique, qui protègent les droits de l'homme en Afrique. Donc, il était très utile aujourd'hui de réunir une rencontre de ce genre pour essayer de voir l'expertise africaine, comment elle peut contribuer à améliorer la situation en Afrique. Et le Sénégal est très content de l'accueillir dans son territoire. Je vous remercie.
My name is Chiriche Osei. I'm head of programs at the African Union Economic, Social and Cultural Council, ECOSOC. And I'm really happy to be here representing ECOSOC at this important forum. I think one of the key takeaways is really how important it is to take the whole African Union human rights infrastructure, including the soft law, to the people. So there's more popular understanding. People know at the community level the existence and relevance of these instruments and how it applies to their day-to-day life. So we have an opportunity here to really strengthen our partnership with the Commission working together to as many of the young people as possible together to understand the overall framework that governs human rights on the continent. Thank you.
La population. Okay.
Je suis professeur Hajar Geldish, je suis la conseillère juridique de l'Union africaine. J'ai le grand honneur et le plaisir de participer à ce premier forum sur les mécanismes spéciaux de la commission de Banjul. Je les félicite pour cette belle initiative, pour avoir ramené autour de la table des personnes qui sont de backgrounds différents, à la fois des académiques, à la fois des organes de l'Union africaine, à la fois des défenseurs des droits humains en Afrique, mais aussi les États membres. Nous avons fait l'état des lieux, des instruments, qu'est-ce qui n'a pas été ratifié encore pour pouvoir encourager les États à le faire. On avait mis en exergue le rôle de l'éducation, le rôle de la société civile, le rôle des associations, le rôle de la femme et de la jeunesse. Et on a fini par mettre en exergue pas seulement que les défis, mais surtout les solutions, les recommandations, comment aller de l'avant. Nous pensons que par rapport aux recommandations, il faudra peut-être dans les prochains forums se focaliser sur un seul aspect des droits humains. C'est vrai que les droits humains, c'est notre affaire à tous, mais il est important aussi de se focaliser sur un seul vecteur, un seul secteur, pour pouvoir bien le prendre en main. Mais en tout cas, ça a été une véritable réussite. J'ai personnellement beaucoup appris dans ce forum. Je vous souhaite beaucoup de succès dans l'avenir. Merci.
Chers délégués, chers collègues, chers invités, je suis Atem Essayem, président du comité pour la prévention de la torture depuis l'année 2017. C'est avec une grande émotion que nous commémorons aujourd'hui le 20e anniversaire du Comité pour la prévention de la torture en Afrique et le 40e anniversaire de la Convention des Nations Unies contre la torture et les autres peines ou traitements cruels, inhumains ou dégradants, l'UNCAT. En tant que président du Comité pour la prévention de la torture en Afrique, c'est avec humilité que je saisis l'occasion de m'adresser à vous et de réaffirmer notre engagement inébranlable en faveur de la prévention de la torture et des mauvais traitements sur notre continent. Aujourd'hui, je suis fier de souligner l'importance de l'observation générale numéro 4 sur le droit à réparation des victimes de la torture et autres peines ou traitements cruels, inhumains ou dégradants, adopté en 2017. Ce document historique fournit des orientations cruciales pour garantir la justice et les réparations aux victimes en reconnaissant leur dignité et leur droit à réparation. En outre, je tiens à souligner l'importance des règles d'Abidjan sur l'établissement et le fonctionnement des mécanismes d'alerte et de rapport à la Commission africaine des droits de l'homme et des peuples sur la situation de torture et autres peines ou traitements cruels, inhumains ou dégradants. Ces règles constituent un outil essentiel dans nos efforts collectifs pour renforcer les mécanismes de responsabilisation et prévenir la torture dans toute l'Afrique. Alors que nous commémorons ces anniversaires, nous devons également redoubler d'efforts pour renforcer l'état de droit et promouvoir les droits de l'homme sur notre continent. Grâce au plaidoyer pour renforcement des capacités et à la collaboration avec les gouvernements et la société civile, nous pouvons œuvrer à l'éradication de la torture sous toutes ses formes. Permettez-moi de partager avec vous une réflexion personnelle. Cette route que nous avons parcourue n'a pas été facile. C'est un honneur pour moi de continuer l'œuvre entamée par mes prédécesseurs qui avaient en charge ce comité. Les défis sont grands, sont multiples, sont difficiles et n'ont jamais été faciles à relever. Je voudrais prendre un moment pour rappeler et saluer la mémoire de feu Jean-Baptiste Nirongero, un collègue vénéré qui a joué un rôle essentiel dans la rédaction des lignes directrices de Robben Island. Son héritage continuera à nous inspirer dans notre quête de justice et de dignité pour tous. Je tiens à exprimer ma profonde gratitude à tous ceux qui ont contribué au succès du Comité pour la prévention de la torture en Afrique au cours des 2 dernières décennies. Votre dévouement, votre passion et votre engagement nous inspirent à œuvrer pour un monde meilleur et plus juste. Je vous remercie.
Saudações aos estimados delegados, colegas e amigos. O meu nome é Maria Teresa Manuela. Sou relatora especial para as prisões, condições de detenção e policiamento em África e também membro do Comitê para a Prevenção da Tortura em África. Ao reunirmos-nos hoje aqui para celebrar momentos importantes na jornada rumo aos direitos humanos e à dignidade, é com profunda honra que me dirijo a vós como membro do Comitê para a Prevenção da Tortura em África. Ao longo das últimas 2 décadas, o CPTA tem estado na vanguarda da proteção dos direitos dos detidos em todo o mundo e no continente africano. Através do seu empenhamento inabalável na prevenção da tortura e na garantia de condições de detenção humanas, o CPTA tem desempenhado um papel essencial na promoção de uma cultura de respeito pelos direitos humanos nos sistemas prisionais. Do mesmo modo, a Convenção contra a Tortura é um farol de esperança e justiça, servindo de norma universal contra a tortura e outras formas de maus tratos. Durante 4 décadas, proporcionou um quadro para os Estados cumprirem as suas obrigações e responsabilizarem os autores de atos de tortura. No entanto, apesar dos progressos registrados, temos de reconhecer que ainda há muito a fazer. Demasiadas pessoas em África continuam a sofrer tratamento desumano nos centros de detenção, desde a sobrelotação aos cuidados de saúde inadequados, da violência à falta de acesso à representação legal. Os desafios são muito e complexos. Como relatora especial para as prisões e condições de detenção e policiamento em África, estou empenhada em trabalhar incansavelmente com os governos, as organizações da sociedade civil e os parceiros internacionais para resolver estas questões prementes. Temos de trabalhar no sentido da plena aplicação das diretrizes de Robben Island e de outros instrumentos relevantes, garantindo que todas as pessoas privadas de liberdade sejam tratadas com dignidade e respeito. Além disso, temos de redobrar os nossos esforços para erradicar a tortura em todas as suas formas e responsabilizar os seus atores. Isto exige não só uma reforma legislativa, mas também uma mudança nas atitudes sociais no sentido de uma tolerância zero em relação à tortura e aos maus tratos. Em conclusão, reafirmemos o nosso empenhamento na nobre causa da promoção e proteção dos direitos de todos os indivíduos, incluindo os que se encontram em situação de detenção. Juntos podemos construir um futuro em que todas as pessoas sejam tratadas com dignidade e sem exceção. Muito obrigada.
Bonjour, je m'appelle Idrissa Sow. Je suis président du groupe de travail sur la peine de mort, les exécutions extrajudiciaires, sommaires ou arbitraires et les disparitions forcées en Afrique. Je suis également vice-président du comité pour la prévention de la torture en Afrique. C'est pour moi un profond honneur de m'adresser à vous en cette occasion mémorable. Aujourd'hui, alors que nous célébrons le 20e anniversaire du comité pour la prévention de la torture en Afrique et le 40e anniversaire de la Convention des Nations Unies contre la torture et autres peines ou traitements cruels, inhumains ou dégradants, c'est pour nous une grande opportunité de jeter un regard sur les étapes franchies et d'exprimer par la même occasion notre engagement renouvelé à relever les défis dans la noble cause de l'éradication de la torture sous toutes ses formes. Des progrès significatifs ont été réalisés dans nos efforts pour lutter contre la torture et défendre les droits de l'homme. Nous avons noté la mise en place de mécanismes nationaux de prévention dans plusieurs États africains, assurant une surveillance cruciale des lieux de détention et renforçant ainsi les mécanismes de responsabilisation. De plus, notre attention est portée sur le développement de la législation et des modèles visant à criminaliser la torture et à jeter les bases de réformes législatives promouvant l'interdiction et la prévention de la torture. Cependant, notre travail est loin d'être terminé. Nous devons continuer à plaider en faveur de la ratification de la Convention des Nations Unies contre la torture, ainsi que du protocole facultatif se rapportant à cette convention et aux autres peines ou traitements cruels, inhumains ou dégradants par tous les États africains. Ces instruments sont des outils essentiels de notre point de vue dans l'arsenal destiné à combattre la torture et à garantir la protection des droits des détenus. De plus, la mise en œuvre des instruments de soft law relatifs à la torture, tels que les lignes directrices de Robben Island, reste pour nous une grande priorité. Nous sommes convaincus qu'en travaillant en étroite collaboration avec les États et les organisations de la société civile, nous pouvons promouvoir l'incorporation de ces lignes directrices dans la législation nationale et les pratiques en renforçant ainsi les protections qui sont dues aux détenus et en prévenant la torture. En regardant vers l'avenir, notre comité est résolument engagé à jouer un rôle de leader dans la lutte contre la torture. Cela implique des engagements plus étroits avec les États et les organisations de la société civile pour garantir que les voix des victimes soient entendues et que leurs droits soient respectés. En favorisant le dialogue et la coopération, nous pouvons développer des stratégies innovantes pour relever les défis émergents et promouvoir la responsabilité des auteurs de torture. Je vous remercie pour votre aimable attention.
Congratulations and happy birthday to the Committee for the Prevention of Torture in Africa, the CPTA, on the occasion of its 20th anniversary. My name is Barbara Bernat. I'm the Secretary General of the Association for the Prevention of Torture, APT, an international non-governmental human rights organization based in Geneva, Switzerland, working worldwide to prevent torture. And we were closely associated to the CPTA from the beginning. Let me mention here 3 highlights. First, cooperation. It started back when the APT proposed to the African Commission at its 28th ordinary session to organize a joint workshop for the effective implementation of Article 5 of the African Charter on Human Rights, prohibiting all forms of torture and ill treatment. This workshop took place in February 2002 in Robben Island, and it drafted concrete guidelines on the prohibition and prevention of torture in Africa, the so-called Robben Island Guidelines. The guidelines were adopted via resolution by the African Commission in 2002. This resolution also establishes a follow-up committee to support their implementation composed of commissioners, the APT, and experts. It met for the first time in 2004 and was later renamed the CPTA. But behind institutions, there are persons. And my second highlight is paying tribute to one person who played a key role in this journey, my former colleague and friend, Jean-Baptiste Nizulu-Beho, who so sadly passed away last November. He was one of the drafters of the Robben Island Guidelines, and he was also in the first meeting of the CPTA and was a member until 2019 when he retired. And we are also celebrating his legacy here today. The third highlight is the key role of the CPTA in implementing the vision of torture prevention in Africa enshrined in the Robben Island Guidelines. For example, on the first hours of detention, it mentions the importance of basic safeguards such as access to lawyers, and these safeguards are now integrated in the principles on effective interviewing for investigations and information gathering known as the Mendes Principles. The CPTA has been a leading actor on the promotion of the Mendes Principles in Africa. Thanks to the CPTA, there is a standalone resolution adopted by the African Commission in 2022, welcoming the Mendes Principles and calling on states to implement them. And the CPTA is also now leading on the implementation of the Mendes Principles and is organizing the first sub-regional workshop to discuss the Mendes Principles with police officers of Southern Africa in June this year. Prevention of torture and ill treatment is an ongoing task, but also a shared responsibility. Together, we can prevent torture.
ميمونة السيد رئيسة اللجنة الجهوية لحقوق الإنسان بجهة الداخلة وادي الذهب. نحن اليوم نشارك في الملتقى الأول للآليات الخاصة بحقوق الإنسان كمجلس وطني لحقوق الإنسان، باعتباره مؤسسة وطنية تعنى بحماية والنهوض بثقافة حقوق الإنسان على المستوى الوطني وعلى المستوى كذلك الدولي. إذن باعتباره كذلك آلية تساهم بمعية مجموعة من الشركاء في التتبع تنزيل السياسات العمومية ومدى ملائمتها مع التشريعات الوطنية وكذلك المواثيق الدولية. الملتقى يشكل فرصة يعني فريدة من نوعها من أجل تبادل التجارب من طرف كل الفاعلين في مجال حقوق الإنسان من مختلف دول القارة الإفريقية، وهو كذلك يشكل فرصة للترافع عن قضايا حقوق الإنسان إما على المستوى الجهوي الوطني أو الدولي.
Maximilienne Gombe, c'est mon nom. Je suis la directrice exécutive du réseau des défenseurs des droits humains en Afrique centrale, le RIDAC. On couvre 8 pays de l'Afrique centrale, en dehors du Burundi et du Rwanda. Alors, pour nous, la Commission africaine des droits de l'homme et des peuples, c'est un instrument efficace pour la protection et la promotion des droits humains qui a donné un espace, n'est-ce pas, aux OSC, aux ONG. Et nous sommes très, très, très fiers aujourd'hui d'être là pour le premier forum. Ce que nous recommandons, c'est que les États partis donnent un peu plus de moyens, rendent la Commission indépendante, un peu plus de moyens financiers, parce que sans moyens financiers, il n'est pas possible de continuer, n'est-ce pas, d'aller dans toute l'Afrique pour promouvoir et protéger les droits humains. Merci.
My name is Wangeshi Grace Kahuria. I'm the Executive Director of the Independent Medical Legal Unit, which is a national civil society organization based in Kenya. I am attending the first joint session of the African Commission on Peoples and Human Rights, and it is indeed a great opportunity for the Commission, for civil society, for governments to sit and talk around issues pertaining to human rights and the status of human rights in Africa. I do want to acknowledge that this has been a great space to share our thoughts, to share our experiences, to share and articulate issues around the status of human rights in Africa. Now, what I'm taking home is the importance of leveraging on the different mandates of the different levels of governance within the Africa Commission, but also the relationship between civil society, the academia, and the Commission. Of great importance is a convening space that the Commission brings, the fact that it is able to gather all of us from Africa to a session where we can discuss without fear, we can discuss without any form of intimidation, we can discuss from the realities of the organizations and the spaces that we serve. And we do realize that the provisions of the different international instruments, the different protocols provide for us the legal impetus on how to manage, to monitor, to report on human rights in Africa. Now, coming from Kenya, I really are delighted that Kenya is one of the countries that has submitted its reports, the state reports on human rights, and I think that is a fundamental, that's fundamental progress that the country has made. However, it's not just about submission of reports, it's about articulation of human rights in the country. IMLU is an organization that focuses on issues around torture, on issues around the right to picket, the right to assembly, the right to association, the right to expression. And from our work and from the conversations that we've had, from the monitoring that we have had, we note that this is a space that requires a lot more work. And so the question is, how do we get the support of the Commission to make sure that these issues are brought to the fore and to the light of the country so that commitments are made to address this issue? And so this is an important space, and I do want to appreciate that a lot of progress has been realized, and we can take it forth in the next session.
I'm Eric Mundia, Policy and Advocacy Manager at ACHPR Africa Alliance. We work to support women reproductive health rights in Africa. This session has been very good. It's the first joint session of the ACHPR. It has been an incredible 3 days sharing with the commissioners, with other stakeholders, state parties, and like-minded CSOs. This has been a position of reflection on what needs to be done, what are the next steps, and also to look back at some of the great strides that we have made. We hope to see you next time in the next session where we shall share more and also deliberate on how to make African people's human rights situation better. Thank you.
I am Honorable Faramawi from the Kenyan National Assembly. I attended the African Commission for Human and People's Rights conference in Dakar, Senegal. It's important for us to face some of these challenges of the modern days as a continent together. It's very important that the continent that moves together. We don't want to get into a situation in which certain parts or regions of the continent make leaps and strides in attaining human and people's rights, and certain parts also suffering the scourges of the extreme violations of their basic human and people's rights. So I think this conference was very good, and we have agreed on a number of things. And one of it is to domesticate the Commission's work so that they work with the very grassroots-based people, the rural folks. This does not have to become an elitist kind of a body where people meet only in capital cities and where lawyers, engineers, and doctors are the ones who contribute. It's important for them to understand the problems, the human rights problems, and the peoples in the very, simple and very humble rural settings. It's also important that Africa wakes up to the realization that we have historical injustices that were done to us. Injustices in the form of slavery, colonization, and neo-colonization, the extraction and exploitation of the raw minerals and resources of the African continent. And the people who are responsible for that are known. It's the first world. They must be able to prepare themselves for reparations as well as compensation. Thank you.
Yes, my name is Dr. Isaac Annan. I represent the Parliament of Ghana. In terms of what I can say about the forum so far, I can say it's been very, very insightful. It has been cross-fertilization of ideas from various organizations, including state and non-state actors. In terms of the mandate or the work of the Commission, I think basically as a commission that promotes and protects human rights, it has become clear that it needs to do more in terms of trying to deepen the knowledge of various actors or various stakeholders in terms of human rights, promotion and protection, by making sure that the various countries that form the commission, the member states, in terms of their legal education and education to judicial officers, especially judges, are deepened so that it will enhance the promotion and protective mandate of the Commission.
Welcome to the Gambia, home of the African Commission on Human and People's Rights.
Bem-vindos à Gâmbia, sede da Comissão Africana dos Direitos Humanos e dos Povos.
Bienvenue en Gambie, siège de la Commission africaine des droits de l'homme et des peuples.
مرحبا بكم في غامبيا، البلد المضيف للجنة الإفريقية لحقوق الإنسان والشعوب.
dal leen ci jàmm fii ci Gambia dëkkuwaay kuréel bu yor ciru doomu adama ci Afrika. One Africa, one voice, your rights, human rights, our collective responsibility. Welcome to the Gambia, home of the African Commission on Human and People's Rights.
Bem-vindos à Gâmbia, sede da Comissão Africana dos Direitos Humanos e dos Povos.
Bienvenue en Gambie, siège de la Commission africaine des droits de l'homme et des peuples.
مرحبا بكم في غامبيا، البلد المضيف للجنة الإفريقية لحقوق الإنسان والشعوب.
dal leen ci jàmm fii ci Gambia dëkkuwaay kuréel bu yore cëru doomu adama ci Afrika. One Africa, one voice, your rights, human rights, our collective responsibility. Welcome to the Gambia, home of the African Commission on Human and People's Rights.
Bem-vindos à Gâmbia, sede da Comissão Africana dos Direitos Humanos e dos Povos.
Bienvenue en Gambie, siège de la Commission africaine des droits de l'homme et des peuples.
مرحبا بكم في غامبيا، البلد المضيف للجنة الإفريقية لحقوق الإنسان والشعوب.
dal leen ci jàmm fii ci Gambia dëkkuwaay kuréel bu yore cëru doomu adama ci Afrika. One Africa, one voice, your rights, human rights, our collective responsibility. Welcome to the Gambia, home of the African Commission on Human and People's Rights.
Bem-vindos à Gâmbia, sede da Comissão Africana dos Direitos Humanos e dos Povos.
Bienvenue en Gambie, siège de la Commission africaine des droits de l'homme et des peuples.
مرحبا بكم في غامبيا، البلد المضيف للجنة الإفريقية لحقوق الإنسان والشعوب.
dal leen ci jàmm fii ci Gambia dëkkuwaay kuréel bu yore cëru doomu adama ci Afrika. One Africa, one voice, your rights, human rights, our collective responsibility. Welcome to the Gambia, home of the African Commission on Human and People's Rights.
Bem-vindos à Gâmbia, sede da Comissão Africana dos Direitos Humanos e dos Povos.
Bienvenue en Gambie, siège de la Commission africaine des droits de l'homme et des peuples.
مرحبا بكم في غامبيا، البلد المضيف للجنة الإفريقية لحقوق الإنسان والشعوب.
dal leen ci jàmm fii ci Gambia dëkkuwaay kuréel bu yore cëru doomu adama ci Afrika. One Africa, one voice, your rights, human rights, our collective responsibility. Welcome to the Gambia, home of the African Commission on Human and People's Rights.
Bem-vindos à Gâmbia, sede da Comissão Africana dos Direitos Humanos e dos Povos.
Bienvenue en Gambie, siège de la Commission africaine des droits de l'homme et des peuples.
مرحبا بكم في غامبيا، البلد المضيف للجنة الإفريقية لحقوق الإنسان والشعوب.
dal leen ci jàmm fii ci Gambia dëkkuwaay kuréel bu yore cëru doomu adama ci Afrika. One
Allô,
Africa,
allô.
one voice, your rights.
Honorable commissaire, Excellences, chers participants, la deuxième édition du
The second edition of special mechanisms is going on, and we're going to continue with session 8 with a very important theme, that is justice as a pillar of sustainability, the role of courts in advancing human rights and development goals. It will be moderated by Commissioner Remy Lumbu, and the focus will be on independence of justice. Let me call the different speakers. There is Justice Malik Sow, Honorable Judge Ajayi from the African Court on Human and People's Rights, Mr. Abdul Malik Bello of ACHPR, the Gambia, Mr. Joseph Bikanda, Defenders, good morning and welcome. So, we'll begin this very important session on justice and sustainability, and in particular the role of courts in advancing human rights and development goals. This panel focuses on fair and timely justice as an important ingredient for sustainable development, citing investors, assurance of timely and fair decisions, how corruption disrupts the process of court, hence negatively impacting development of individuals, nations, etc. So I'll give the floor to the Honorable Chair, Remy Lubungo. I thank you. Thank you very much. Thank you. I would like to welcome all of you after this coffee break, you members of the panel who indeed made the honor of taking part at this 8th session on justice as a pillar of sustainability. Through this panel, I would like to consider with the members of the panel the role of courts and tribunals in the promotion of human rights and advancing human rights and development goals. Before I begin with this moderation, permit me to, by way of introduction, state, perhaps after what the ambassador said a while ago, say a word on what we call sustainable development. When we look at development objective goals of the United Nations, which have a lot of things in common with the Agenda 2063 of the African Union, we can indeed make findings, and it's indeed relating to human rights. Because so when you look at the UN development objectives, you'll find notions such as the fight against poverty, hunger, which is related to poverty, poverty which is related to well-being, hunger. There are notions like health, education, gender equality, which may not necessarily be civil or political or socioeconomic or cultural rights, but it's a general principle which is found in conventions. So there's human rights which have been put there for equality without any discrimination. There's gender balance, and there could be many other reasons. So you'll find development objectives access to water, clean water, and you can consider all of this as human rights because there are instruments which protect human rights and give individuals or communities the right to water, the right to energy. You also find in these development objective goals, in conjunction with the 2063 agenda, issues relating to employment, issues relating to climate change, which is in relation to the right to environment. You'll find notions on the sustainable consumption, the protection of flora and fauna, which represent an area in the field of human rights as well. And there's also partnerships. So you also see under Development 16, there's justice and peace, and that's what this panel is trying to create, and that is a nexus between peace, development, and human rights. I would like to state that the African Charter on Human and People's Rights considers this issue as crucial under Article 16 of the Charter. There should be the right to justice and fair trial, for which the African Commission has guidelines, Article 26, which is a legal basis which we could mobilize for this panel, which also deals with the right to independence of justice. That's why the African Commission for some time has tried to have not a special mechanism, but a focal point which deals with the independence of the judiciary to deal with this issue. And I would want to say that with the help of some partners, including the Center for Human Rights of the University of Pretoria, the Commission says that we should have guidelines to issues relating to judicial independence. Lastly, I would like to draw your attention, because on the objective of development number 7, the African Union is aware, and the president of Tanzania, Samia Suluhu Hassan, for some time has been promoting some international law which is at the embryonic stage, but which will take on board the international law on clean energies. This was considered, she was considered as a champion of this area, because she is promoting for the benefit of our mothers, our daughters, our sisters, to use renewable energy in the preparation of food which you and I will eat in our homes every day. In that regard, at the last Assembly of Heads of State of the African Union, a declaration was adopted by heads of state and government of the African Union on the use of what we call clean cooking, that is preparing food using renewable energy. So this session will last for exactly 1 hour and 15 minutes. Everything on board, and I want everything to take place within 1 hour and 15 minutes. Will not hesitate to stop the session when the time is ripe. So to enable you all to prepare the afternoon, so it's a pleasure for me within this context to invite an elder, a former magistrate on retirement, but who is still serving the Republic of Senegal, that is Justice Malik Sow, who has made us the honor of coming here to take part in this activity. he will take the floor on this issue on justice as a pillar to sustainability in the promotion of human rights and objective of attaining development. I know magistrates are people of rigor. When you give them 10 minutes, they can use 9.99 minutes and give you back the microphone for the deliberations to continue. Honorable Judge, do you authorize me to give you the floor so that you can set the ball rolling? Yes, Chair. I would like to start by thanking you for giving me the floor, and to thank you also, you and all the members of the Commission, for inviting me to take part in this forum. I thought I was going to speak for 15 minutes, but if you say I should speak for 10 minutes, I'll try to do so. Justice compiled with development and the promotion of human rights and development objectives is indeed an old topic. It's very vast and complex, but it is still current. That is why it is difficult to treat it exhaustively in all these different aspects. And that is why in this exercise, I've chosen to lay emphasis on certain principles and fundamental criteria which contribute to the improvement of justice, which can play its role fully for the respect of human dignity and in favor of economic and social development. Adherent of law and principles constitute priorities which are incumbent on each state. But in the globalized world in which we live, and in a geopolitical context which is uncertain, where there are all sorts of threats and conflicts emerging from anywhere, the emergence of the judicial system in dealing with these conflicts is indeed an inevitable situation. In this report, justice, which is independent and impartial, is indeed the basis for stability of every society, and it is a fundamental pillar without which all sorts of excesses and negative situations and violations could become possible. But its existence and effectiveness is a source of progress and development. Let me move on to this some development norms, because I've submitted the text for publication. Let's look at the different criteria which I've selected within the purview of this theme. The first consists in a legislation which respects human dignity and development. In positive law of this nature, it is indispensable, after enabling justice, to have norms which are consistent with international law. The basics here in this aspect is the justiciability of this law. In principle, after its ratification, an international legal instrument, regional or even community legal instrument, has to be transposed or incorporated, domesticated in each state to make it part of positive law and make it applicable. However, even if it is not incorporated in the national legislative system, the international norm, regional norm, community norms, which are properly ratified, are incumbent on judges if the legislative and specific aspects of the law are not identified. most of our constitutions contain provisions according to which, for if the treaty is ratified, once it is ratified by superior authorities, it comes to force. From that moment, all conventions which are regular national and consequently could be constitutionally, administratively, and in families, and also in economic, social, and cultural rights. That is the first step. I've also chosen to say a few words on the second aspect, which concern the training of magistrates. Magistrates should be chosen following transparent procedures and criteria, which will lead to a selection which will contain moral, ethic, and intellectual qualities. Men and women who render justice must be competent, rigorous, and to be able to listen to their society. This training should be done naturally in a school, a specialized school for training, with modules which touch all sectors, especially the judicial deontology under the Bangalore Doctrine. But this should not only concern magistrates, it should also concern the registrar, who plays a very important role in our justice system. But good justice, proper justice, cannot function without laws which are respected and with lawyers who cover the entire territory of the nation, so that each citizen should have rights to ensure that he can be defended by a lawyer of his choice or an appointed lawyer. Thirdly, a third point on which I would want to insist is the fact that justice should never be under the control of the executive. It should have a management organ which is independent, which will be competent for all issues relating to justice, not only the career of magistrates, but discipline and all other issues which may enable justice to forge ahead within the purview of its independence. The fourth point on which I would like to speak to is that justice should not be far from litigants, and it should be quite close to the population, and there should be short procedure and acts of formalities which are reasonable. Within the same spirit, judicial assistance or legal aid should be developed and organized to ensure that it will be a tool for the benefit of those in need. The fifth point, which should require a bit of reflection, concerns the decision or judgments of the courts themselves. It should be the finality of the entire judicial process, and consequently, it should be an indispensable act where people can enjoy their rights. To that end, it should be drafted in a simple manner, a comprehensible manner, but it should be made available and accessible immediately after the judgment is rendered. Now, I would like to speak to a point which concerns corruption. The fight against corruption is a very important aspect of the independence of justice within the judicial institution itself, as well as from the global strategy to implement justice. Corrupt magistrates are indeed opposed to justice, and it is indeed a scourge which should be eradicated at all costs. We can develop these issues, especially in regard to the fight against corruption and the promotion of justice and public resources. These are all issues which are current, and we find them in all our societies when it comes to settling of accounts. Now let me go to my conclusion to move faster, to respect the time which you gave me. I would like to conclude on an important issue, to say simply that independent justice cannot be said to have been achieved easily, but it requires the vigilance of all forces to preserve what has been achieved. And I'll end by saying that it is man who is at the center of justice, because the magistrate is in charge of rendering justice. They are human beings, and by definition, man has weaknesses. They could be subject to all sorts of shortcomings, and from that point of view, those who are in charge of managing justice should be chosen from the very best, because that will lead to good justice, and good justice will be reflected by the men and women who rendered justice. Thank you. Thank you very much, George Malik Sow. It was deliberate that I did not want to from it, because I wanted to listen to the magistrate, and that is panel. But to be complete, so is currently the legal advisor, President of the Republic of Senegal, His Excellency Jawara, who gave him honor to recruit him in the cabinet so that he should give his opinion. It's a very high quality history. And from the quality of this presentation, you can see that this panel did not just invite any kind of person. Judge. Thank you very much. So I did not ask the hall to clap, but they just started clapping. So it is indeed an honor which we are rendering to you this afternoon. At the second level, I would like to give exactly 10 minutes to invite another high-grade magistrate. It is Judge Dominic J. He is a judge at the African Court on Human and People's Rights, and he works at the Court of Appeal. He's a judge of the Appeal Court of Ghana and a member of the advisory board of the International Criminal Court. This is another high caliber judge, strong arm of the judicial system, giving his opinion on this issue. Judge, you have 10 minutes.
Everybody, the African Court is pleased to be here and to take part in this important dialogue. When we talk about justice, what we are saying is that we the people are vested with power. And we are giving this power to the judiciary to administer on our behalf. And therefore, power belongs to us, and we give to the judiciary to administer on our behalf. And therefore, if we're giving power to the judiciary to exercise on our behalf, then we must get the judiciary, which is made up of persons of integrity, impartiality, prudence, boldness, because if you are a judge and you are not bold, you cannot shoot the gun. Where the law says you cannot be faithful to the law. And this topic is basically about how do we sustain justice the role of the court. How do we use the court to advance human rights? I will restrict myself to the international court because my previous speaker talked about the domestic court at large. Now, when we talk about justice and using it to enlarge the scope of human rights or promoting and protecting human rights, the law requires all bodies, such as international courts, to ensure that they give effect to the mandate on which they were established. Let me talk about the African court. The African court was established to perform a particular role. The African Charter has set up the Charter and has established the African Commission to protect, promote, enforce human rights, as well as to promote freedom and duties of the individuals. And there was a need to establish the court to complement the protective mandate of the commission. So the court's duty is to protect to complement the protective mandate of the commission. And we know the duty of the commission to protect human rights as well as freedom and liberty of the individual within the continent. And therefore, the court, as a judicial power, the court was given judicial power exercise and to exercise to ensure that specific objectives in improving the quality of life of the people, providing education, health, and living standards, reducing poverty and improve upon sustainability, economic development, and expanding equality, fairness, and social justice, taking into account enforcement or interpretation of human rights provision. So when we talk about the role of the court, it is very, very crucial. Now, let's look at what the court is supposed to do to advance human rights. That the court shall apply the provisions of the Charter, any human rights instrument by the court, any human rights provision a state by of human rights has that it has become national, international. It is not meant to be ratified, but it is all state. And in addition to this, anyone that country shall be enforced and applied against that country by the court. And so, let's look at those who can access the court. That is where we have a little bit of challenge. Accessibility to the court is limited. The first one is that a complaint may be lodged by the commission. If it is not the commission, the state party against which the complaint has been lodged at the commission. And the state party is a human rights violations and African intergovernmental organizations. Then a state party may also put in a request to join where that state party has interest in the matter before the court. When it comes to non-governmental organizations and the individuals, that is where we have problems. Individuals whose rights have been affected cannot access the court unless your state has deposited a declaration under Article 34.6 permitting individuals from that country to access the court. Then when it comes to NGO, the NGO must be recognized by the commission, and the Article 36.4 has been deposited to permit NGO. Otherwise, individuals and NGOs cannot access the court. Those who are in the court, they are bound by the rigid rules of jurisdiction and admissibility. They must satisfy all the grounds of the 4 rules on jurisdiction as well as admissibility. Having fulfilled these grounds, then we move on to what we mean by the protocol. the African Charter establishing the court, out of the 55 countries, as at now, only 34 of the states have ratified. 34 out of 55. When it comes to the deposit of declaration to enable individuals to access the court, 12 countries deposited, and now it has been reduced to 7. Tanzania has withdrawn, Rwanda has withdrawn, Benin, Cote d'Ivoire, and just last March, Tunisia. The reason is that the court is giving judgment against them. But it is the people who gave you that right, the mandate to represent them, and the charter was made, and you deposited the declaration. As a result of losing cases, then they come and withdraw. So as at now, apart from 7 countries, no individuals can access the court. Now, the court, let's look at what the court can do. And as at now, is the court able to achieve those objectives? The court has judicial power, and the judicial power, the court can make the following. The court can grant.
So let me, colleagues mentioned about access to justice, but let me illustrate what I consider as a denial of justice. Access to justice coupled with the rule of law necessitates the availability of effective legal remedies, which underscore the fundamental role of regional and international courts. Are these remedies available to African citizens? My colleague Bakar mentioned it here. Maybe it's available, but however, we see a contrast with the SDG goals and the Agenda 2060 aspiration. Colleagues mentioned here, for example, this commission has issued numerous progressive decisions regarding the right to development and protecting vulnerable communities, but we see slow rate of implementation of the decision. The apparent lack of implementation of these decisions suggests that states' priorities diverge actually from a right-based approach to development, clearly. So finally, colleagues mentioned here, we are concerned that there is a growing number of states, while giving possibility to people to access the African court on paper, in practice, we don't see it. And there's a growing number, it's concerning also that there's a growing number of people who enable them, their citizens under Article 34.6 are cited here to access court are withdrawing. So the question is, do you want still to advance Agenda 2063, or do you want to go back to the colonial eras? Thank you.
Merci Joseph d'avoir utilisé 8 minutes 20 pour votre intervention et je remercie la salle pour les applaudissements. Nous allons très rapidement passer à la partie interactive et comme je l'avais dit, nous n'avons pas beaucoup de temps.
Time is not on our side. Well, if my watch is correct, we have 20 minutes in our hands to close this panel. Well, let's say 15 minutes, because the last 5 minutes would be time to hand it over to the panelists. Actually, 10 minutes for Q&A, because thereafter there should be the closing remarks. Let me now ask the states who wish to make comments to do so, because the objective, the Agenda 2063, development objectives, Agenda 23, are incumbent on the states. Even the justice that we are talking about today is their prerogatives. No country in Africa could do without the institutions, without mentioning that this is a day-to-day attribute to us. This is one of the attributes to the states. We have heard all that the panelists said with respect to development. So can we hear your inputs? I can already see Ghana. Ghana? You know, I'm short-sighted. I hope I've not been betrayed by my eyesight. Is that Ghana?
International human rights instruments in order to make it possible for courts to apply, domestic courts. Then he went on to add that in the event that domestication is not done, courts must apply those instruments. Justice Ajay also reinforced the point made by Justice Su when he stated categorically that the African Court on Human and People's Rights would generally enforce human rights instruments ratified by states against them, whether they domesticate them or not. Now, the problem is with dualist states, and Ghana is one, where you have constitutions which are very explicit, that when treaties are ratified by the executive, they must, and there is an imperative that they must be ratified by Parliament. I want to ask you whether your emphasis shouldn't be on domestication rather than advocate for judicial activism in the absence of domestication, because in my view, you will require judges who are very bold and courageous to apply international instruments which have not been domesticated than if they were domesticated. Thank you.
Thank you, Excellency. Est-ce qu'il y a encore un État qui souhaite prendre la parole?
I would like to take the floor. I can't see any second request for the floor. I would also like to urge the Commissioner to be brief. Commissioner Sow. Thank you, Chairperson. I will be very brief. I just want to congratulate the panelists for the quality of their presentations. I would also like to come back to an important issue which was herein raised by the Honorable Judge Ajay, who, after having given an overview of the missions that have been assigned to the African Court as part of its mandate, he also talked about a threshold. The essential threshold is that the decisions are not always implemented. There is a problem when it comes to implementations of the rulings. This is not an African specificity. Implementation of justice rulings is the underbelly of international justice, because there is no mandatory implementation. When there is a litigation, this is not possible at the international level. Implementation is dependent on the goodwill of the states. But we also have a system to urge the states to implement the rulings. And I believe that this system today should be improved. This is my viewpoint. As long as we do not involve the policy organs of our international organizations in the application and implementations of justice of rulings, we will have problems. Now you can see what is happening at the ICJ to ensure that the rulings are implemented. What organs are involved? It is the United Nations Security Council. Now, with respect to the European Council, it is the Ministers' Committee which is charged with monitoring the implementations. I do know at the African Court there are provisions for you to submit an annual report to the Executive Council, but there is no monitoring mechanism to monitor the implementations of the rulings. So I believe we have to go towards that direction with a view to facilitating the implementations of rulings of the justice. I would like to add that today we can see a procedure which is essential, namely the recourse to when rulings are not implemented. This has to be implemented. So when a state does not implement a ruling, another state can use that possibility. I believe if you don't go towards that direction, we would still have to live with the same difficulties. Chairperson, that was my input, and I hand over the floor to you. Thank you. Thank you, Commissioner Sow, for that brilliant intervention on the issue of the implementation of the rulings. I have 10 minutes, 2 more interventions. If not, well, I will now proceed to kindly request the panelists to conclude. Let me start with the panelists on my extreme right.
The court and other human rights mechanisms are pivotal to the realization of sustainable development. We've never had any cause to doubt the fairness of the judgments and recommendations we've received from all the African regional human rights mechanisms, but then delay in the administration of justice is a problem that should be revisited. The issue of Article 34.6 declaration is a major clog for individuals and non-governmental organizations. The issue of capacity building it should be sustained for key stakeholders in the area. And lastly, the issue of implementation must be taken very seriously. And in the whole thing, the bulk lies with member states, and we urge member states to respect and honor the decision and recommendation of the court and the commission. Thank you so much.
Thank you very much, Professor. Now we'll give.
With the
I will
permission,
give you for that 1 minute and a half.
thank you. With the permission of the chair, I would like to respond to the question posed by Ghana. The dualism and the monism. If the general principle is that if you are a dualist country, once you ratify a protocol, you must domesticate it in your country before you can implement it. But once you ratify it, the international level, you are bound by it. Now, in Ghana, for instance, you were talking about human rights provision. Article 73 and 75 of Ghana's constitution provides that you shall domesticate. But that one excludes international human rights. That one comes under Article 33.5 of the Ghana's constitution, which says that any right that promotes dignity of man can be implemented by the Human Rights Court in Ghana. So in Ghana, whether it is domesticated or not, the Ghanaian court can enforce it under 33.5 once it is a human rights instrument. Now back to my my own conclusion. What I would say is that there was a comment about the fact that African court does not have default proceedings. Default clause has been part of the court's rule since 2010, and we make use of default clause and proceed to give judgment against countries who fail to defend their pleadings before the court. Thank you, President.
Merci beaucoup, Monsieur le juge, pour cette question technique. Je vous passe maintenant la parole.
Honorable Sow, I will now give you the floor. I will be very brief. Honorable representative of Ghana raised the issue of the justifiability he stipulated that judges have to be courageous to move accordingly. Well, in its own definition, a judge is a courageous individual. Now, the crux of the matter, it is not neither to have courageous judges or not. The essential issue is that when it comes to human rights, the state is incumbent. The convention was ratified, so one should go all the way, not only ratify it by the parliament, but also incorporate them in the in the system. If not, if a judge has the possibilities of applying that that standard, despite that shortcoming, this is good. Well, these are current examples, especially in Senegal. This is done. This is done most times in the Constitutional Council. Recently had used international conventions to hand over the ruling, whilst nothing existed in that regard at the national level. Yes, thank you, Joseph Biganda. You have the honor of concluding, and you have 1 minute. Thank you, Chairperson. By way of conclusion, let me say that African states do not have the real desire, political desire, to implement the rulings that from the mechanisms that they themselves have defined. Like I said, it's a manner of undermining these mechanisms. And as an African citizen, I would like to see Africa seize itself of its opportunity of the new geopolitical, new geoeconomic dynamisms and the global order with a view to protecting its citizens by using these mechanisms. Thank you, Joseph. Thank you, all the panelists. Now, for the remaining 5 minutes, I would like to conclude briefly so that we can respect the allocated time. We have already had a panel on sustainable development. This panel is sustainable, and let me say that the panelists are also here, and we would be a pleasure to invite you next year if we had a third edition of this forum. Now, three conclusions on your behalf. There is a nexus between justice and development, and this nexus is evident. So to ensure for this nexus to be consolidated, we have to have quality justice, sustainable justice, if I can say so, which not only englobes the criteria of independence, accessibility, and criteria of impartiality. This is a positive factor. The second factor is that the states, because it's incumbent on them, the states have to work. It is not an easy task. They have to work for the implementations. Let me use the adjective once again. For sustainable implementations of the rulings at all levels, not only at the national level, but also at the international level. Now, to achieve this, English has a very good expression for that matter, namely, lack of implementation of the rulings. Well, I like that phrase, lack of implementation of rulings. What we are submitting here, well, there is another expression close to my heart. You have to fight for the implementation. We do not really implement rulings, not only on the national plan, but the international plan. So we urge the states to ensure, because what is at stake is the development of a country. We believe that development is infrastructure, but then there are other factors that we can do, namely the monitoring or so. There is no mandatory way to implement. One has to be good fit to implement it. Like the judge said, it is a whole process. You sign, you ratify, and then it have to go all the way to the implementations of these conventions if they have been brought before the courts. And this leads me to the third conclusion, namely adherence to commitments, international commitments. The common denominator George Malik said this, is that actually Ghana also talked about it. Conventions that have been signed and ratified. You have this magic formula. What does it mean? They're high, I mean, more superior than law. It means that it are sources of law. So when the lawyers make their submissions on the basis of this convention, they should be taken seriously. And this the judge had said, the training of judges. And the judges have gone to old school. Those who have gone before 90, they did not benefit from human rights training. Now things have changed. You have a new generation. So they will take this into account. It is 13:50. That's the end of the panel. I have respected my commitment, and I now hand over the floor to the protocol.
And I believe that this session and our forum as a whole deserve another round of applause. Thank you very much. Thank you very much. So now I'm pleased to announce, merci beaucoup. I'm pleased to announce that we'll go for lunch break, 45 minutes, and we shall hopefully resume at, let's say at, is it 2:35? Yeah, 2:35. To address the two remaining or last sessions of our forum, the one dealing with migration and refugees, and finally session 10 on freedom of association, assembly, expression, and access to information. What? Yeah. We have an announcement also. Thank you for your attention. Yeah, there's a side event from 4 to 5:30 at room 1. There's an activity on the theme, leveraging rights-based approach to enhance accountability and promote dignified maternal health care. This event is organized by Center for Reproductive Rights, Legal and Human Rights, University of Pretoria. Thank you very much.
Yes, my name is Dr. Isaac Annan. I represent the Parliament of Ghana. In terms of what I can say about the forum so far, I can say it's been very, very insightful. It has been cross-fertilization of ideas from various organizations, including state and non-state actors. In terms of the mandate or the work of the commission, I think basically as a commission that promotes and protects human rights, it has become clear that it needs to do more in terms of trying to deepen the knowledge of various actors or various stakeholders in terms of human rights, promotion and protection, by making sure that the various countries that form the commission, the member states, in terms of their legal education and education to judicial officers, especially judges, are deepened so that it will enhance the promotion and protective mandate of the commission. Yes, my name is Dr. Isaac Annan.
I'm Eric Mundi, Policy and Advocacy Manager at ACHPR Africa Lands. We work to support women reproductive health rights in Africa.
Selma, celle-ci, ça fait que je suis de la République algérienne démocratique et populaire et je suis professeur de droit international à l'Université d'Alger. J'ai été élu membre de la Commission africaine des droits de l'homme et des peuples lors de la 43e session ordinaire du Conseil exécutif de l'Union africaine en juillet 2023 et j'ai pris une fonction en tant que commissaire lors de la 77e session ordinaire de la Commission africaine le 20 octobre 2023. En matière de mécanismes spéciaux, je suis le rapporteur spécial en charge des réfugiés, des demandeurs d'asile, des personnes déplacées en Afrique et des migrants. En ce qui concerne les pays dont je suis en charge, je suis responsable de la promotion et de la protection des droits de l'homme et du peuple dans 4 États africains qui sont l'État de la Libye, la République du Niger, la République du Sénégal et également la République tunisienne.
بمعية مجموعة من الشركاء في تتبع تنزيل السياسات العمومية ومدى مداخلتها مع التشريعات الوطنية وكذلك المواثيق الدولية. الملتقى يشكل فرصة فريدة من نوعها من أجل تبادل التجارب وكذلك يشكل فرصة للترافع عن قضايا حقوق الإنسان على مستوى جهوي ووطني ودولي.
I'm Eric Mundi, Policy and Advocacy Manager at ACHPR Africa Lands. We work to support women reproductive health rights in Africa. This session has been very good. It's the first joint session of the ACHPR. It has been an incredible 3 days sharing with the commissions, with other stakeholders, state parties, and like-minded CSOs. This has been a position of reflection on what needs to be done, what are the next steps, and also to look back at some of the great strides that we have made. We hope to see you next time in the next session where we shall share more and also deliberate on how to make African people's human rights situation better. Thank you.
Chers délégués, chers collègues, chers invités, je suis Atem Sayem, président du comité pour la prévention de la torture depuis l'année 2017. C'est avec une grande émotion que nous commémorons aujourd'hui le 20e anniversaire du comité pour la prévention de la torture en Afrique et le 40e anniversaire de la Convention des Nations Unies contre la torture et les autres peines ou traitements cruels, inhumains ou dégradants, l'UNCAT. En tant que président du comité pour la prévention de la torture en Afrique, c'est avec humilité que je saisis l'occasion de m'adresser à vous et de réaffirmer notre engagement inébranlable en faveur de la prévention de la torture et des mauvais traitements sur notre continent. Aujourd'hui, je suis fier de souligner l'importance de l'observation générale numéro 4 sur le droit à réparation des victimes de la torture et autres peines ou traitements cruels, inhumains ou dégradants, adopté en 2017. Ce document historique fournit des orientations cruciales pour garantir la justice et les réparations aux victimes en reconnaissant leur dignité et leur droit à réparation. En outre, je tiens à souligner l'importance des règles d'Abidjan sur l'établissement et le fonctionnement des mécanismes d'alerte de rapport à la Commission africaine des droits de l'homme et des peuples sur la situation de torture et autres peines ou traitements cruels, inhumains ou dégradants. Ces règles constituent un outil essentiel dans nos efforts collectifs pour renforcer les mécanismes de responsabilisation et prévenir la torture dans toute l'Afrique. Alors que nous commémorons ces anniversaires, nous devons également redoubler d'efforts pour renforcer l'état de droit et promouvoir les droits de l'homme sur notre continent. Grâce au plaidoyer pour renforcement des capacités et à la collaboration avec les gouvernements et la société civile, nous pouvons œuvrer à l'éradication de la torture sous toutes ses formes. Permettez-moi de partager avec vous une réflexion personnelle. Cette route que nous avons parcourue n'a pas été facile. C'est un honneur pour moi de continuer l'œuvre entamée par mes prédécesseurs qui avaient en charge ce comité. Les défis sont grands, sont multiples et sont difficiles et n'ont jamais été faciles à relever. Je voudrais prendre un moment pour rappeler et saluer la mémoire de feu Jean-Baptiste Nirongero, un collègue vénéré qui a joué un rôle essentiel dans la rédaction des lignes directrices de Robben Island. Son héritage continuera à nous inspirer dans notre quête de justice et de dignité pour tous. Je tiens à exprimer ma profonde gratitude à tous ceux qui ont contribué au succès du comité pour la prévention de la torture en Afrique au cours des 2 dernières décennies. Votre dévouement, votre passion et votre engagement nous inspirent à œuvrer pour un monde meilleur et plus juste. Je vous remercie.
Saudações aos estimados delegados, colegas e amigos. O meu nome é Maria Teresa Manuela. Sou relatora especial para as prisões, condições de detenção e policiamento em África e também membro do Comitê para a Prevenção da Tortura em África. Ao reunirmos-nos hoje aqui para celebrar momentos importantes na jornada rumo aos direitos humanos e à dignidade, é com profunda honra que me dirijo a vós como membro do Comitê para a Prevenção da Tortura em África. Ao longo das últimas 2 décadas, o CPTA tem estado na vanguarda da proteção dos direitos dos detidos em todo o mundo e no continente africano. Através do seu empenhamento inabalável na prevenção da tortura e na garantia de condições de detenção humanas, o CPTA tem desempenhado um papel essencial na promoção de uma cultura de respeito pelos direitos humanos nos sistemas prisionais. Do mesmo modo, a Convenção contra a Tortura é um farol de esperança e justiça, servindo de norma universal contra a tortura e outras formas de maus tratos. Durante 4 décadas, proporcionou um quadro para os Estados cumprirem as suas obrigações e responsabilizarem os autores de atos de tortura. No entanto, apesar dos progressos registrados, temos de reconhecer que ainda há muito a fazer. Demasiadas pessoas em África continuam a sofrer tratamento desumano nos centros de detenção, desde a sobrelotação aos cuidados de saúde inadequados, da violência, a falta de acesso à representação legal, os desafios são muito e complexos. Como relatora especial para as prisões e condições de detenção e policiamento em África, estou empenhada em trabalhar incansavelmente com os governos, as organizações da sociedade civil e os parceiros internacionais para resolver estas questões prementes. Temos de trabalhar no sentido da plena aplicação das diretrizes de Robben Island e de outros instrumentos relevantes, garantindo que todas as pessoas privadas de liberdade sejam tratadas com dignidade e respeito. Além disso, temos de redobrar os nossos esforços para erradicar a tortura em todas as suas formas e responsabilizar os seus atores. Isto exige não só uma reforma legislativa, mas também uma mudança nas atitudes sociais no sentido de uma tolerância zero em relação à tortura e aos maus tratos. Em conclusão, reafirmemos o nosso empenhamento na nobre causa da promoção e proteção dos direitos de todos os indivíduos, incluindo os que se encontram em situação de detenção. Juntos podemos construir um futuro em que todas as pessoas sejam tratadas com dignidade e sem exceção. Muito obrigada.
Bonjour, je m'appelle Idrissa Sow. Je suis président du groupe de travail sur la peine de mort, les exécutions extrajudiciaires, sommaires ou arbitraires et les disparitions forcées en Afrique. Je suis également vice-président du comité pour la prévention de la torture en Afrique. C'est pour moi un profond honneur de m'adresser à vous en cette occasion mémorable. Aujourd'hui, alors que nous célébrons le 20e anniversaire du comité pour la prévention de la torture en Afrique, et le 40e anniversaire de la Convention des Nations Unies contre la torture et autres peines ou traitements cruels, inhumains ou dégradants, c'est pour nous une grande opportunité de jeter un regard sur les étapes franchies et d'exprimer par la même occasion notre engagement renouvelé à relever les défis dans la noble cause de l'éradication de la torture sous toutes ses formes. Des progrès significatifs ont été réalisés dans nos efforts pour lutter contre la torture et défendre les droits de l'homme. Nous avons noté la mise en place de mécanismes nationaux de prévention dans plusieurs États africains, assurant une surveillance cruciale des lieux de détention et renforçant ainsi les mécanismes de responsabilisation. De plus, notre attention est portée sur le développement de la législation et des modèles visant à criminaliser la torture et à jeter les bases de réformes législatives promouvant l'interdiction et la prévention de la torture. Cependant, notre travail est loin d'être terminé. Nous devons continuer à plaider en faveur de la ratification de la Convention des Nations Unies contre la torture, ainsi que du protocole facultatif se rapportant à cette convention et aux autres peines ou traitements cruels, inhumains ou dégradants, par tous les États africains. Ces instruments sont des outils essentiels de notre point de vue dans l'arsenal destiné à combattre la torture et à garantir la protection des droits des détenus. De plus, la mise en œuvre des instruments de soft law relatifs à la torture, tels que les lignes directrices de Robben Island, reste pour nous une grande priorité. Nous sommes convaincus qu'en travaillant en étroite collaboration avec les États et les organisations de la société civile, nous pouvons promouvoir l'incorporation de ces lignes directrices dans la législation nationale et les pratiques en renforçant ainsi les protections qui sont dues aux détenus et en prévenant la torture. En regardant vers l'avenir, notre comité est résolument engagé à jouer un rôle de leader dans la lutte contre la torture. Cela implique des engagements plus étroits avec les États et les organisations de la société civile pour garantir que les voix des victimes soient entendues et que leurs droits soient respectés. En favorisant le dialogue et la coopération, nous pouvons développer des stratégies innovantes pour relever les défis émergents et promouvoir la responsabilité des auteurs de torture. Je vous remercie pour votre aimable attention.
Congratulations and a happy birthday to the Committee for the Prevention of Torture in Africa, the CPTA, on the occasion of its 20th anniversary. My name is Barbara Bernat. I'm the Secretary General of the Association for the Prevention of Torture, APT, an international non-governmental human rights organization based in Geneva, Switzerland, working worldwide to prevent torture. And we were closely associated to the CPTA from the beginning. Let me mention here 3 highlights. First, cooperation. It started back when the APT proposed to the African Commission at its 28th ordinary session to organize a joint workshop for the effective implementation of Article 5 of the African Charter on Human Rights, prohibiting all forms of torture and ill treatment. This workshop took place in February 2002 in Robben Island, and it drafted concrete guidelines on the prohibition and prevention of torture in Africa, the so-called Robben Island Guidelines. The guidelines were adopted by a resolution by the African Commission in 2002. This resolution also establishes a follow-up committee to support their implementation, composed of commissioners, the APT, and experts. It met for the first time in 2004 and was later renamed the CPTA. But behind institutions, there are persons. And my second highlight is paying tribute to one person who played a key role in this journey, my former colleague and friend, Jean-Baptiste Nizurugero, who so sadly passed away last November. He was one of the drafters of the Robben Island Guidelines, and he was also in the first meeting of the CPTA and was a member until 2019 when he retired. And we are also celebrating his legacy here today. The third highlight is the key role of the CPTA in implementing the vision of torture prevention in Africa enshrined in the Robben Island Guidelines. For example, on the first hours of detention, it mentions the importance of basic safeguards such as access to lawyers, and these safeguards are now integrated in the principles on effective interviewing for investigations and information gathering known as the Mendes Principles. The CPTA has been a leading actor on the promotion of the Mendes Principles in Africa. Thanks to the CPTA, there is a standalone resolution adopted by the African Commission in 2022, welcoming the Mendes Principles and calling on states to implement them. And the CPTA is also now leading on the implementation of the Mendes Principles and is organizing the first sub-regional workshop to discuss the Mendes Principles with police officers of Southern Africa in June this year. Prevention of torture and ill treatment is an ongoing task, but also a shared responsibility. Together, we can prevent torture.
My name is Faiza Badmos Busari. I'm the Regional Program Manager at CHPR Network, the Strategic Initiative for Women in the Horn of Africa. This joint forum has been very, informative, educative, and has provided a platform for, good discussion and good engagement across all levels. The past 3 days have involved, looking at different types of the AU instruments, looking at the reporting mechanism, and really trying to get, good recommendations on how we can intervene or get state parties to be more committed, or what the AU can do better. A key recommendation for me, and one of the things that stood out of this meeting, was the need to engage, grassroots, between the AU and the grassroots, the increased engagement among both parties. It's important that their voices are heard, and it's important that their voices are heard at the places that matter. So I think going out of this, state parties should consider engaging them when drafting reports, state reports, and then also CSO engaging them, in the process of submitting reports as well. Thank you.
Yes, my name is Dr. Isaac Annan. I represent the Parliament of Ghana. In terms of what I can say about the forum so far, I can say it's been very, very insightful. It has been cross-fertilization of ideas from various organizations, including state and non-state actors. In terms of the mandate or the work of the Commission, I think basically as a commission that promotes and protects human rights, it has become clear that it needs to do more in terms of trying to deepen the knowledge of various actors or various stakeholders in terms of human rights, promotion and protection, by making sure that the various countries that form the Commission, the member states, in terms of their legal education and education to judicial officers, especially judges, are deepened so that it will enhance the promotion and protective mandate of the Commission.
My name is Chiriche Osei. I'm head of programs at the African Union Economic, Social and Cultural Council, ECOSOC. And I'm really happy to be here representing ECOSOC at this important forum. I think one of the key takeaways is really how important it is to take the whole African Union human rights infrastructure, including the soft law, to the people. So there's more popular understanding. People know at the community level the existence and relevance of these instruments and how it applies to their day-to-day life. So I think we have an opportunity here to really strengthen our partnership with the Commission to make sure that we are working together to reach as many African people as possible to get them to understand the overall framework that governs human rights on the continent. Thank you.
Maximilienne Gombe, c'est mon nom. Je suis la directrice exécutive du réseau des défenseurs des droits humains en Afrique centrale, le REDAC. On couvre 8 pays de l'Afrique centrale, en dehors du Burundi et du Rwanda. Alors, pour nous, la Commission africaine des droits de l'homme et des peuples, c'est un instrument efficace pour la protection et la promotion des droits humains qui a donné un espace, n'est-ce pas, aux OSC, aux ONG. Et nous sommes très, très, très fiers aujourd'hui d'être là pour le premier forum. Ce que nous recommandons, c'est que les États partis donnent un peu plus de moyens, rendent la Commission indépendante, un peu plus de moyens financiers, parce que sans moyens financiers, il n'est pas possible de continuer, n'est-ce pas, d'aller dans toute l'Afrique pour promouvoir et protéger les droits humains. Merci.
Je suis professeur Hajar Geldish, je suis la conseillère juridique de l'Union africaine. J'ai le grand honneur et le plaisir de participer à ce premier forum sur les mécanismes spéciaux de la Commission de Banjul. Je les félicite pour cette belle initiative, pour avoir amené autour de la table des personnes qui sont de backgrounds différents, à la fois des académiques, à la fois des organes de l'Union africaine, à la fois des défenseurs des droits humains en Afrique, mais aussi les États membres. Nous avons fait l'état des lieux, des instruments. Qu'est-ce qui n'a pas été ratifié encore pour pouvoir encourager les États à le faire? On avait mis en exergue le rôle de l'éducation, le rôle de la société civile, le rôle des associations, le rôle de la femme et de la jeunesse. Et on a fini par mettre en exergue pas seulement que les défis, mais surtout les solutions, les recommandations, comment aller de l'avant. Nous pensons que par rapport aux recommandations, il faudra peut-être dans les prochains forums se focaliser sur un seul aspect des droits humains. C'est vrai que les droits humains, c'est notre affaire à tous, mais il est important aussi de se focaliser sur un seul vecteur, un seul secteur pour pouvoir bien le prendre en main. Mais en tout cas, ça a été une véritable réussite. J'ai personnellement beaucoup appris dans ce forum. Je vous souhaite beaucoup de succès dans l'avenir. Merci.
Yeah, my name is Harry Oguche Obe. I'm a lawyer, a director with the National Human Rights Commission of Nigeria, and I head the Department of Economic, Social and Cultural Rights. It's a pleasure to be part of this very important initiative of the African Commission to bring together stakeholders to discuss on how to actualize the mandate of the Commission and also provide a platform for the different stakeholders to connect with a view to promoting and entrenching the culture of human rights in Africa. For me, it's been a phenomenal experience, and I believe that going back home, there will be a lot of changes with the way I view my work as a human rights advocate and a human rights worker. Thank you, African Human Rights Commission, for this opportunity.
My name is Wangeshi Grace Kahuria. I'm the Executive Director of the Independent Medical Legal Unit, which is a national civil society organization based in Kenya. I am attending the first joint session of the African Commission on Peoples and Human Rights, and it is indeed a great opportunity for the Commission, for civil society, for governments to sit and talk around issues pertaining to human rights and the status of human rights in Africa. I do want to acknowledge that this has been a great space to share our thoughts, to share our experiences, to share and articulate issues around the status of human rights in Africa. Now, what I'm taking home is the importance of leveraging on the different mandates of the different levels of governance within the Africa Commission, but also the relationship between civil society, the academia, and the Commission. Of great importance is a convening space that the Commission brings, the fact that it is able to gather all of us from Africa to a session where we can discuss without fear, we can discuss without any form of intimidation, we can discuss from the realities of the organizations and the spaces that we serve. And we do realize that the provisions of the different international instruments, the different protocols provide for us the legal impetus on how to manage, to monitor, to report on human rights in Africa. Now, coming from Kenya, I really are delighted that Kenya is one of the countries that has submitted its reports, the state reports on human rights, and I think that is a fundamental, that's fundamental progress that the country has made. However, it's not just about submission of reports, it's about articulation of human rights in the country. IMLU is an organization that focuses on issues around torture, on issues around the right to picket, the right to assembly, the right to association, the right to expression. And from our work and from the conversations that we've had, from the monitoring that we have had, we note that this is a space that requires a lot more work. And so the question is, how do we get the support of the Commission to make sure that these issues are brought to the fore and to the light of the country so that commitments are made to address this issue? And so this is an important space, and I do want to appreciate that a lot of progress has been realized, and we can take it forth in the next session.
I am Honorable Farah Maalim from the Kenyan National Assembly. I attended the African Commission for Human and People's Rights conference in Dakar, Senegal. It's important for us to face some of these challenges of the modern days as a continent together. It's very important that the continent that moves together. We don't want to get into a situation in which certain parts or regions of the continent make leaps and strides in attaining human and people's rights, and certain parts also suffering the scourges of the extreme violations of their basic human and people's rights. So I think this conference was very good, and we have agreed on a number of things. And one of it is to domesticate the Commission's work so that they work with very grassroots-based people, rural folks. This does not have to become an elitist kind of a body where people meet only in capital cities and where lawyers, engineers, and doctors are the ones who contribute. It's important for them to understand the problems, the human rights problems of the peoples in the very, very, simple and very humble rural settings. It's also important that Africa wakes up to the realization that we have historical injustices that were done to us. Injustices in the form of slavery, colonization, and neo-colonization, the extraction and exploitation of the raw minerals and resources of the African continent. And the people who are responsible for that are known. It's the first world. They must be able to prepare themselves for reparations as well as compensation. Thank you.
My name is Daniele Teccarelli. I work at the European Union delegation to the African Union in Addis Ababa, attending this forum organized by the African Commission for Human People Rights. It's been a good opportunity to exchange with the Commission, with the court, with other human rights and democracy organs, and also with especially with African Union member states, representatives from national human rights institutions, CSOs, on positive aspects, negative aspects, things that could be improved for us as a European Union, which are a partner to the African Union in general, and specifically to the African and Governance Architecture platform organs. It's important to hear those voices, and especially in a context where the current situation worldwide is not that positive on democratic trends. So we build upon the continental norms and treaties approved by member states, and their obligations or lack of obligations to report against, to be committed towards those treaties. And for us as a partner, again, we stand always ready to support those human rights and governance organs. We have a privileged relation with the Commission, with the court in Arusha, the Commission in Banjul, the APRM, the PAP, the Committee of the Child, the AGA Secretariat in Addis Ababa, the Political and Peace and Security Department at the African Union Commission, and it's a common agreement that governance and human rights are strictly interconnected with peace and security dimension, especially when it comes to conflict prevention, conflict resolution, and investing in the soft power, though could be a bit more lengthy, but in the end of the day, it's more effective and efficient to prevent conflicts. Thank you.
Merci. Je m'appelle Julien Gandour, je suis le directeur des droits humains au ministère de la Justice du Sénégal. Alors, cette session, ce forum que nous organisons, que la Commission africaine des droits de l'homme et des peuples organise ici au Sénégal pour 3 jours, c'est un forum de réflexion sur les droits de l'homme en Afrique pour voir comment les experts qui se sont rassemblés ici peuvent voir des voies et moyens d'améliorer la situation des droits de l'homme en Afrique. Il s'agit d'un forum qui concerne les différents mécanismes qui sont instaurés par la Commission africaine des droits de l'homme, qui promeuvent les droits de l'homme en Afrique, qui protègent les droits de l'homme en Afrique. Donc, il était très utile aujourd'hui de réunir une rencontre de ce genre pour essayer de voir l'expertise africaine, comment elle peut contribuer à améliorer la situation en Afrique. Et le Sénégal est très content de l'accueillir dans son territoire. Je vous remercie.
Mon nom est Selma Sessi Safer, je suis de la République algérienne démocratique et populaire et je suis professeur de droit international à l'Université d'Alger. J'ai été élu membre de la Commission africaine des droits de l'homme et des peuples lors de la 43e session ordinaire du Conseil exécutif de l'Union africaine en juillet 2023 et j'ai pris mes fonctions en tant que commissaire lors de la 77e session ordinaire de la Commission africaine le 20 octobre 2023. En matière de mécanismes spéciaux, je suis le rapporteur spécial en charge des réfugiés, des demandeurs d'asile, des personnes déplacées en Afrique et des migrants. En ce qui concerne les pays dont je suis en charge, je suis responsable de la promotion et de la protection des droits de l'homme et des peuples dans 4 États africains qui sont l'État de la Libye, la République du Niger, la République du Sénégal et également la République tunisienne.
ميمونة السيد رئيسة اللجنة الجهوية لحقوق الإنسان بجهة الداخلة وادي الذهب. نحن اليوم نشارك في الملتقى الأول للآليات الخاصة بحقوق الإنسان كمجلس وطني لحقوق الإنسان باعتباره مؤسسة وطنية تعنى بحماية والنهوض بثقافة حقوق الإنسان على المستوى الوطني وعلى المستوى كذلك الدولي. إذن باعتباره كذلك آلية تساهم بمعية مجموعة من الشركاء في التتبع تنزيل السياسات العمومية ومدى ملائمتها مع التشريعات الوطنية وكذلك المواثيق الدولية. الملتقى يشكل فرصة يعني فريدة من نوعها من أجل تبادل التجارب من طرف كل الفاعلين في مجال حقوق الإنسان من مختلف دول القارة الإفريقية. وهو كذلك يشكل فرصة للترافع عن قضايا حقوق الإنسان إما على المستوى الجهوي الوطني أو الدولي.
I'm Eric Mundia, Policy and Advocacy Manager at ACHPR Africa Lands. We work to support women reproductive health rights in Africa. This session has been very good. It's the first joint session of the ACHPR. It has been an incredible 3 days sharing with the commissioners, with other stakeholders, state parties, and like-minded CSOs. This has been a position of reflection on what needs to be done, what are the next steps, and also to look back at some of the great strides that we have made. We hope to see you next time in the next session where we shall share more and also deliberate on how to make African people's human rights situation better. Thank you.
Chers délégués, chers collègues, chers invités, je suis Atem Sayem, président du comité pour la prévention de la torture depuis l'année 2017. C'est avec une grande émotion que nous commémorons aujourd'hui le 20e anniversaire du comité pour la prévention de la torture en Afrique et le 40e anniversaire de la Convention des Nations Unies contre la torture et les autres peines ou traitements cruels, inhumains ou dégradants, l'UNCAT. En tant que président du Comité pour la prévention de la torture en Afrique, c'est avec humilité que je saisis l'occasion de m'adresser à vous et de réaffirmer notre engagement inébranlable en faveur de la prévention de la torture et des mauvais traitements sur notre continent. Aujourd'hui, je suis fier de souligner l'importance de l'observation générale numéro 4 sur le droit à réparation des victimes de la torture et autres peines ou traitements cruels, inhumains ou dégradants, adopté en 2017. Ce document historique fournit des orientations cruciales pour garantir la justice et les réparations aux victimes en reconnaissant leur dignité et leur droit à réparation. En outre, je tiens à souligner l'importance des règles d'Abidjan sur l'établissement et le fonctionnement des mécanismes d'alerte et de rapport à la Commission africaine des droits de l'homme et des peuples sur la situation de torture et autres peines ou traitements cruels, inhumains ou dégradants. Ces règles constituent un outil essentiel dans nos efforts collectifs pour renforcer les mécanismes de responsabilisation et prévenir la torture dans toute l'Afrique. Alors que nous commémorons ces anniversaires, nous devons également redoubler d'efforts pour renforcer l'état de droit et promouvoir les droits de l'homme sur notre continent. Grâce au plaidoyer pour renforcement des capacités et à la collaboration avec les gouvernements et la société civile, nous pouvons œuvrer à l'éradication de la torture sous toutes ses formes. Permettez-moi de partager avec vous une réflexion personnelle. Cette route que nous avons parcourue n'a pas été facile. C'est un honneur pour moi de continuer l'œuvre entamée par mes prédécesseurs qui avaient en charge ce comité. Les défis sont grands, sont multiples et sont difficiles et n'ont jamais été faciles à relever. Je voudrais prendre un moment pour rappeler et saluer la mémoire de feu Jean-Baptiste Nirongero, un collègue vénéré qui a joué un rôle essentiel dans la rédaction des lignes directrices de Robben Island. Son héritage continuera à nous inspirer dans notre quête de justice et de dignité pour tous. Je tiens à exprimer ma profonde gratitude à tous ceux qui ont contribué au succès du Comité pour la prévention de la torture en Afrique au cours des 2 dernières décennies. Votre dévouement, votre passion et votre engagement nous inspirent à œuvrer pour un monde meilleur et plus juste. Je vous remercie.
Saudações aos estimados delegados, colegas e amigos. O meu nome é Maria Teresa Manuela. Sou relatora especial para as prisões, condições de detenção e policiamento em África e também membro do Comitê para a Prevenção da Tortura em África. Ao reunirmos-nos hoje aqui para celebrar momentos importantes na jornada rumo aos direitos humanos e à dignidade, é com profunda honra que me dirijo a vós como membro do Comitê para a Prevenção da Tortura em África. Ao longo das últimas 2 décadas, o CPTA tem estado na vanguarda da proteção dos direitos dos detidos em todo o mundo e no continente africano. Através do seu empenhamento inabalável na prevenção da tortura e na garantia de condições de detenção humanas, o CPTA tem desempenhado um papel essencial na promoção de uma cultura de respeito pelos direitos humanos nos sistemas prisionais. Do mesmo modo, a Convenção contra a Tortura é um farol de esperança e justiça, servindo de norma universal contra a tortura e outras formas de maus tratos. Durante 4 décadas, proporcionou um quadro para os Estados cumprirem as suas obrigações e responsabilizarem os autores de atos de tortura. No entanto, apesar dos progressos registrados, temos de reconhecer que ainda há muito a fazer. Demasiadas pessoas em África continuam a sofrer tratamentos desumanos nos centros de detenção, desde a sobrelotação aos cuidados de saúde inadequados, da violência à falta de acesso à representação legal. Os desafios são muitos e complexos. Como relatora especial para as prisões e condições de detenção e policiamento em África, estou empenhada em trabalhar incansavelmente com os governos, as organizações da sociedade civil e os parceiros internacionais para resolver estas questões prementes. Temos de trabalhar no sentido da plena aplicação das diretrizes de Robben Island e de outros instrumentos relevantes, garantindo que todas as pessoas privadas de liberdade sejam tratadas com dignidade e respeito. Além disso, temos de redobrar os nossos esforços para erradicar a tortura em todas as suas formas e responsabilizar os seus atores. Isto exige não só uma reforma legislativa, mas também uma mudança nas atitudes sociais no sentido de uma tolerância zero em relação à tortura e aos maus tratos. Em conclusão, reafirmemos o nosso empenhamento na nobre causa da promoção e proteção dos direitos de todos os indivíduos, incluindo os que se encontram em situação de detenção. Juntos podemos construir um futuro em que todas as pessoas sejam tratadas com dignidade e sem exceção. Muito obrigada.
Bonjour, je m'appelle Idrissa Sow. Je suis président du groupe de travail sur la peine de mort, les exécutions extrajudiciaires, sommaires ou arbitraires et les disparitions forcées en Afrique. Je suis également vice-président du comité pour la prévention de la torture en Afrique. C'est pour moi un profond honneur de m'adresser à vous en cette occasion mémorable. Aujourd'hui, alors que nous célébrons le 20e anniversaire du comité pour la prévention de la torture en Afrique et le 40e anniversaire de la Convention des Nations Unies contre la torture et autres peines ou traitements cruels, inhumains ou dégradants, c'est pour nous une grande opportunité de jeter un regard sur les étapes franchies et d'exprimer par la même occasion notre engagement renouvelé à relever les défis dans la noble cause de l'éradication de la torture sous toutes ses formes. Des progrès significatifs ont été réalisés dans nos efforts pour lutter contre la torture et défendre les droits de l'homme. Nous avons noté la mise en place de mécanismes nationaux de prévention dans plusieurs États africains, assurant une surveillance cruciale des lieux de détention et renforçant ainsi les mécanismes de responsabilisation. De plus, notre attention est portée sur le développement de la législation et des modèles visant à criminaliser la torture et à jeter les bases de réformes législatives promouvant l'interdiction et la prévention de la torture. Cependant, notre travail est loin d'être terminé. Nous devons continuer à plaider en faveur de la ratification de la Convention des Nations Unies contre la torture, ainsi que du protocole facultatif se rapportant à cette convention et aux autres peines ou traitements cruels, inhumains ou dégradants, par tous les États africains. Ces instruments sont des outils essentiels de notre point de vue dans l'arsenal destiné à combattre la torture et à garantir la protection des droits des détenus. De plus, la mise en œuvre des instruments de soft law relatifs à la torture, tels que les lignes directrices de Robben Island, reste pour nous une grande priorité. Nous sommes convaincus qu'en travaillant en étroite collaboration avec les États et les organisations de la société civile, nous pouvons promouvoir l'incorporation de ces lignes directrices dans la législation nationale et les pratiques en renforçant ainsi les protections qui sont dues aux détenus et en prévenant la torture. En regardant vers l'avenir, notre comité est résolument engagé à jouer un rôle de leader dans la lutte contre la torture. Cela implique des engagements plus étroits avec les États et les organisations de la société civile pour garantir que les voix des victimes soient entendues et que leurs droits soient respectés. En favorisant le dialogue et la coopération, nous pouvons développer des stratégies innovantes pour relever les défis émergents et promouvoir la responsabilité des auteurs de torture. Je vous remercie pour votre aimable attention.
Congratulations and a happy birthday to the Committee for the Prevention of Torture in Africa, the CPTA, on the occasion of its 20th anniversary. My name is Barbara Bernat. I'm the Secretary General of the Association for the Prevention of Torture, APT, an international non-governmental human rights organization based in Geneva, Switzerland, working worldwide to prevent torture. And we were closely associated to the CPTA from the beginning. Let me mention here 3 highlights. First, cooperation. It started back when the APT proposed to the African Commission at its 28th ordinary session to organize a joint workshop for the effective implementation of Article 5 of the African Charter on Human Rights, prohibiting all forms of torture and ill treatment. This workshop took place in February 2002 in Robben Island, and it drafted concrete guidelines on the prohibition and prevention of torture in Africa, the so-called Robben Island Guidelines. The guidelines were adopted by a resolution by the African Commission in 2002. This resolution also establishes a follow-up committee to support their implementation, composed of commissioners, the APT, and experts. It met for the first time in 2004 and was later renamed the CPTA. But behind institutions, there are persons. And my second highlight is paying tribute to one person who played a key role in this journey, my former colleague and friend, Jean-Baptiste Nizurugero, who so sadly passed away last November. He was one of the drafters of the Robben Island Guidelines, and he was also in the first meeting of the CPTA and was a member until 2019 when he retired. And we are also celebrating his legacy here today. The third highlight is the key role of the CPTA in implementing the vision of torture prevention in Africa enshrined in the Robben Island Guidelines. For example, on the first hours of detention, it mentions the importance of basic safeguards such as access to lawyers, and these safeguards are now integrated in the principles on effective interviewing for investigations and information gathering known as the Mendes Principles. The CPTA has been a leading actor on the promotion of the Mendes Principles in Africa. Thanks to the CPTA, there is a standalone resolution adopted by the African Commission in 2022, welcoming the Mendes Principles and calling on states to implement them. And the CPTA is also now leading on the implementation of the Mendes Principles and is organizing the first sub-regional workshop to discuss the Mendes Principles with police officers of Southern Africa in June this year. Prevention of torture and ill treatment is an ongoing task, but also a shared responsibility. Together, we can prevent torture.
My name is Faiza Badmos-Busari. I'm the Regional Program Manager at ACHPR Network, the Strategic Initiative for Women in the Horn of Africa. This joint forum has been very, informative, educative, and has provided a platform for, good discussion and good engagement across all levels. The past 3 days have involved, looking at different types of the AU instruments, looking at the reporting mechanism, and really trying to get, good recommendations on how we can intervene or get state parties to be more committed, or what the AU can do better. A key recommendation for me, and one of the things that stood out of this meeting, was the need to engage, grassroots, between the AU and the grassroots, the increased engagement among both parties. It's important that their voices are heard, and it's important that their voices are heard at the places that matter. So I think going out of this, state parties should consider engaging them when drafting reports, state reports, and then also CSO engaging them, in the process of submitting reports as well. Thank you.
Yes, my name is Dr. Isaac Annan. I represent the Parliament of Ghana. In terms of what I can say about the forum so far, I can say it's been very, very insightful. It has been cross-fertilization of ideas from various organizations, including state and non-state actors. In terms of the mandate or the work of the Commission, I think basically as a commission that promotes and protects human rights, it has become clear that it needs to do more in terms of trying to deepen the knowledge of various actors or various stakeholders in terms of human rights, promotion and protection, by making sure that the various countries that form the commission, the member states, in terms of their legal education and education to judicial officers, especially judges, are deepened so that it will enhance the promotion and protective mandate of the Commission.
My name is Chirike Osei. I'm head of programs at the African Union Economic, Social and Cultural Council, ECOSOC. And I'm really happy to be here representing ECOSOC at this important forum. I think one of the key takeaways is really how important it is to take the whole African Union human rights infrastructure, including the soft law, to the people. So there's more popular understanding. People know at the community level the existence and relevance of these instruments and how it applies to their day-to-day life. So I think we have an opportunity here to really strengthen our partnership with the Commission to make sure that we are working together to reach as many African people as possible to get them to understand the overall framework that governs human rights on the continent. Thank you.
Maximilienne Gombe, c'est mon nom. Je suis la directrice exécutive du réseau des défenseurs des droits humains en Afrique centrale, le REDAC. On couvre 8 pays de l'Afrique centrale, en dehors du Burundi et du Rwanda. Alors, pour nous, la Commission africaine des droits de l'homme et des peuples, c'est un instrument efficace pour la protection et la promotion des droits humains qui a donné un espace, n'est-ce pas, aux OSC, aux ONG. Et nous sommes très, très, très fiers aujourd'hui d'être là pour le premier forum. Ce que nous recommandons, c'est que les États partis donnent un peu plus de moyens, rendent la Commission indépendante, un peu plus de moyens financiers, parce que sans moyens financiers, il n'est pas possible de continuer, n'est-ce pas, d'aller dans toute l'Afrique pour promouvoir et protéger les droits humains. Merci.
Je suis professeur Hajar Geldish, je suis la conseillère juridique de l'Union africaine. J'ai le grand honneur et le plaisir de participer à ce premier forum sur les mécanismes spéciaux de la commission de Banjul. Je les félicite pour cette belle initiative, pour avoir amené autour de la table des personnes qui sont de backgrounds différents, à la fois des académiques, à la fois des organes de l'Union africaine, à la fois des défenseurs des droits humains en Afrique, mais aussi les États membres. Nous avons fait l'état des lieux, des instruments. Qu'est-ce qui n'a pas été ratifié encore pour pouvoir encourager les États à le faire? On avait mis en exergue le rôle de l'éducation, le rôle de la société civile, le rôle des associations, le rôle de la femme et de la jeunesse. Et on a fini par mettre en exergue pas seulement que les défis, mais surtout les solutions, les recommandations, comment aller de l'avant. Nous pensons que par rapport aux recommandations, il faudra peut-être dans les prochains forums se focaliser sur un seul aspect des droits humains. C'est vrai que les droits humains, c'est notre affaire à tous, mais il est important aussi de se focaliser sur un seul vecteur, un seul secteur pour pouvoir bien le prendre en main. Mais en tout cas, ça a été une véritable réussite. J'ai personnellement beaucoup appris dans ce forum. Je vous souhaite beaucoup de succès dans l'avenir. Merci.
Yeah, my name is Harry Oguche-Obe. I'm a lawyer, a director with the National Human Rights Commission of Nigeria, and I head the Department of Economic, Social, and Cultural Rights. It's a pleasure to be part of this very important initiative of the African Commission to bring together stakeholders to discuss on how to actualize the mandate of the Commission and also provide a platform for the different stakeholders to connect with a view to promoting and entrenching the culture of human rights in Africa. For me, it's been a phenomenal experience, and I believe that going back home, there will be a lot of changes with the way I view my work as a human rights advocate and a human rights worker. Thank you, African Human Rights Commission, for this opportunity.
My name is Wangeshi Grace Kahuria. I'm the Executive Director of the Independent Medical Legal Unit. which is a national civil society organization based in Kenya. I am attending the first joint session of the African Commission on Peoples and Human Rights, and it is indeed a great opportunity for the Commission, for civil society, for governments to sit and talk around issues pertaining to human rights and the status of human rights in Africa. I do want to acknowledge that this has been a great space to share our thoughts, to share our experiences, to share and articulate issues around the status of human rights in Africa. Now, what I'm taking home is the importance of leveraging on the different mandates of the different levels of governance within the Africa Commission, but also the relationship between civil society, the academia, and the Commission. Of great importance is a convening space that the Commission brings, the fact that it is able to gather all of us from Africa to a session where we can discuss without fear, we can discuss without any form of intimidation, we can discuss from the realities of the organizations and the spaces that we serve. And we do realize that the provisions of the different international instruments, the different protocols provide for us the legal impetus on how to manage, to monitor, to report on human rights in Africa. Now, coming from Kenya, I really are delighted that Kenya is one of the countries that has submitted its reports, the state reports on human rights, and I think that is a fundamental, that's fundamental progress that the country has made. However, it's not just about submission of reports, it's about articulation of human rights in the country. IMLU is an organization that focuses on issues around torture, on issues around the right to picket, the right to assembly, the right to association, the right to expression. And from our work and from the conversations that we've had, from the monitoring that we have had, we note that this is a space that requires a lot more work. And so the question is, how do we get the support of the Commission to make sure that these issues are brought to the fore and to the light of the country so that commitments are made to address this issue? And so this is an important space, and I do want to appreciate that a lot of progress has been realized, and we can take it forth in the next session.
I am Honorable Farah Maalim from the Kenyan National Assembly. I attended the African Commission for Human and People's Rights conference in Dakar, Senegal. It's important for us to face some of these challenges of the modern days as a continent together. It's very important that the continent moves together. We don't want to get into a situation in which certain parts or regions of the continent make leaps and strides in attaining human and people's rights, and certain parts also suffering the scourges of the extreme violations of their basic human and people's rights. So I think this conference was very good, and we have agreed on a number of things. And one of it is to domesticate the Commission's work so that they work with very grassroots-based people, the rural folks. This does not have to become an elitist kind of a body where people meet only in capital cities and where lawyers, engineers, and doctors are the ones who contribute. It's important for them to understand the problems, the human rights problems of the peoples in the very, very, simple and very humble rural settings. It's also important that Africa wakes up to the realization that we have historical injustices that were done to us. Injustices in the form of slavery, colonization, and neo-colonization, the extraction and exploitation of the raw minerals and resources of the African continent. And the people who are responsible for that are known. It's the first world. They must be able to prepare themselves for reparations as well as compensation. Thank you.
My name is Daniele Tecrelli. I work at the European Union delegation to the African Union in Addis Ababa, attending this forum organized by the African Commission for Human People Rights. It's been a good opportunity to exchange with the Commission, with the court, with other human rights and democracy organs, and also with especially with African Union member states, representatives from national human rights institutions, CSOs, on positive aspects, negative aspects, things that could be improved for us as a European Union, which are a partner to the African Union in general, and specifically to the African and governance architecture platform organs. It's important to hear those voices, and especially in a context where the current situation worldwide is not that positive on democratic trends. So we build upon the continental norms and treaties approved by member states, and their obligations or lack of obligations to report against, to be committed towards those treaties. And for us as a partner, again, we stand always ready to support those human rights and governance organs. We have a privileged relation with the Commission, with the court in Arusha, the Commission in Banjul, the APRM, the PAP, the Committee of the Child, the AGA Secretariat in Addis Ababa, the Political and Peace and Security Department at the African Union Commission, and it's a common agreement that governance and human rights are strictly interconnected with peace and security dimension, especially when it comes to conflict prevention, conflict resolution, and investing in the soft power, though could be a bit more lengthy, but in the end of the day, it's more effective and efficient to prevent conflicts. Thank you.
Merci. Je m'appelle Julien Gandour, je suis le directeur des droits humains au ministère de la Justice du Sénégal. Alors, cette session, ce forum que nous organisons, que la Commission africaine des droits de l'homme et des peuples organise ici au Sénégal pour 3 jours, c'est un forum de réflexion sur les droits de l'homme en Afrique pour voir comment les experts qui se sont rassemblés ici peuvent voir les voies et moyens d'améliorer la situation des droits de l'homme en Afrique. Il s'agit d'un forum qui concerne les différents mécanismes qui sont instaurés par la Commission africaine des droits de l'homme, qui promeuvent les droits de l'homme en Afrique, qui protègent les droits de l'homme en Afrique. Donc, il était très utile aujourd'hui de réunir une rencontre de ce genre pour essayer de voir l'expertise africaine, comment elle peut contribuer à améliorer la situation en Afrique. Et le Sénégal est très content de l'accueillir dans son territoire. Je vous remercie.
Mon nom est Selma Sessi Safer, je suis de la République algérienne démocratique et populaire et je suis professeure de droit international à l'Université d'Alger. J'ai été élue membre de la Commission africaine des droits de l'homme et des peuples lors de la 43e session ordinaire du Conseil exécutif de l'Union africaine en juillet 2023 et j'ai pris mes fonctions en tant que commissaire lors de la 77e session ordinaire de la Commission africaine le 20 octobre 2023. En matière de mécanismes spéciaux, je suis le rapporteur spécial en charge des réfugiés, des demandeurs d'asile, des personnes déplacées en Afrique et des migrants. En ce qui concerne les pays dont je suis en charge, je suis responsable de la promotion et de la protection des droits de l'homme et des peuples dans 4 États africains qui sont l'État de la Libye, la République du Niger, la République du Sénégal et également la République tunisienne.
ميمونة السيد رئيسة اللجنة الجهوية لحقوق الإنسان بجهة الداخلة وادي الذهب. نحن اليوم نشارك في الملتقى الأول للآليات الخاصة بحقوق الإنسان كمجلس وطني لحقوق الإنسان باعتباره مؤسسة وطنية تعنى بحماية والنهوض بثقافة حقوق الإنسان على المستوى الوطني وعلى المستوى كذلك الدولي. إذن باعتباره كذلك آلية تساهم بمعية مجموعة من الشركاء في التتبع تنزيل السياسات العمومية ومدى ملائمتها مع التشريعات الوطنية وكذلك المواثيق الدولية. الملتقى يشكل فرصة يعني فريدة من نوعها من أجل تبادل التجارب من طرف كل الفاعلين في مجال حقوق الإنسان من مختلف دول القارة الإفريقية. وهو كذلك يشكل فرصة للترافع عن قضايا حقوق الإنسان إما على المستوى الجهوي الوطني أو الدولي.
I'm Eric Mundia, Policy and Advocacy Manager at ACHPR Africa Lands. We work to support women reproductive health rights in Africa. This session has been very good. It's the first joint session of the ACHPR. It has been an incredible 3 days sharing with the commissioners, with other stakeholders, state parties, and like-minded CSOs. This has been a position of reflection on what needs to be done, what are the next steps, and also to look back at some of the great strides that we have made. We hope to see you next time in the next session where we shall share more and also deliberate on how to make African people's human rights situation better. Thank you.
Chers délégués, chers collègues, chers invités, je suis Atem Sayem, président du comité pour la prévention de la torture depuis l'année 2017. C'est avec une grande émotion que nous commémorons aujourd'hui le 20e anniversaire du comité pour la prévention de la torture en Afrique et le 40e anniversaire de la Convention des Nations Unies contre la torture et les autres peines ou traitements cruels, inhumains ou dégradants, l'UNCAT. En tant que président du comité pour la prévention de la torture en Afrique, c'est avec humilité que je saisis l'occasion de m'adresser à vous et de réaffirmer notre engagement inébranlable en faveur de la prévention de la torture et des mauvais traitements sur notre continent. Aujourd'hui, je suis fier de souligner l'importance de l'observation générale numéro 4 sur le droit à réparation des victimes de la torture et autres peines ou traitements cruels, inhumains ou dégradants, adopté en 2017. Ce document historique fournit des orientations cruciales pour garantir la justice et les réparations aux victimes en reconnaissant leur dignité et leur droit à réparation. En outre, je tiens à souligner l'importance des règles d'Abidjan sur l'établissement et le fonctionnement des mécanismes d'alerte et de rapport à la Commission africaine des droits de l'homme et des peuples sur la situation de torture et autres peines ou traitements cruels, inhumains ou dégradants. Ces règles constituent un outil essentiel dans nos efforts collectifs pour renforcer les mécanismes de responsabilisation et prévenir la torture dans toute l'Afrique. Alors que nous commémorons ces anniversaires, Nous devons également redoubler d'efforts pour renforcer l'état de droit et promouvoir les droits de l'homme sur notre continent. Grâce au plaidoyer pour renforcement des capacités et à la collaboration avec les gouvernements et la société civile, nous pouvons œuvrer à l'éradication de la torture sous toutes ses formes. Permettez-moi de partager avec vous une réflexion personnelle. Cette route que nous avons parcourue n'a pas été facile. C'est un honneur pour moi de continuer l'œuvre entamée par mes prédécesseurs qui avaient en charge ce comité. Les défis sont grands, sont multiples, ils sont difficiles et n'ont jamais été faciles à relever. Je voudrais prendre un moment pour rappeler et saluer la mémoire de feu Jean-Baptiste Nirongero, un collègue vénéré qui a joué un rôle essentiel dans la rédaction des lignes directrices de Robben Island. Son héritage continuera à nous inspirer dans notre quête de justice et de dignité pour tous. Je tiens à exprimer ma profonde gratitude à tous ceux qui ont contribué au succès du Comité pour la prévention de la torture en Afrique au cours des 2 dernières décennies. Votre dévouement, votre passion et votre engagement nous inspirent à œuvrer pour un monde meilleur et plus juste. Je vous remercie.
Saudações aos estimados delegados, colegas e amigos. O meu nome é Maria Teresa Manuela. Sou relatora especial para as prisões, condições de detenção e policiamento em África e também membro do Comitê para a Prevenção da Tortura em África. Ao reunirmos-nos hoje aqui para celebrar momentos importantes na jornada rumo aos direitos humanos e à dignidade, é com profunda honra que me dirijo a vós como membro do Comitê para a Prevenção da Tortura em África. Ao longo das últimas 2 décadas, o CPTA tem estado na vanguarda da proteção dos direitos dos detidos em todo o mundo e no continente africano. Através do seu empenhamento inabalável na prevenção da tortura e na garantia de condições de detenção humanas, o CPTA tem desempenhado um papel essencial na promoção de uma cultura de respeito pelos direitos humanos nos sistemas prisionais. Do mesmo modo, a Convenção contra a Tortura é um farol de esperança e justiça, servindo de norma universal contra a tortura e outras formas de maus tratos. Durante 4 décadas, proporcionou um quadro para os Estados cumprirem as suas obrigações e responsabilizarem os autores de atos de tortura. No entanto, apesar dos progressos registrados, temos de reconhecer que ainda há muito a fazer. Demasiadas pessoas em África continuam a sofrer tratamento desumano nos centros de detenção, desde a sobrelotação aos cuidados de saúde inadequados, da violência à falta de acesso à representação legal. Os desafios são muito e complexos. Como relatora especial para as prisões e condições de detenção e policiamento em África, estou empenhada em trabalhar incansavelmente com os governos, as organizações da sociedade civil e os parceiros internacionais para resolver estas questões prementes. Temos de trabalhar no sentido da plena aplicação das diretrizes de Robben Island e de outros instrumentos relevantes, garantindo que todas as pessoas privadas de liberdade sejam tratadas com dignidade e respeito. Além disso, temos de redobrar os nossos esforços para erradicar a tortura em todas as suas formas e responsabilizar os seus atores. Isto exige não só uma reforma legislativa, mas também uma mudança nas atitudes sociais no sentido de uma tolerância zero em relação à tortura e aos maus tratos. Em conclusão, reafirmemos o nosso empenhamento na nobre causa da promoção e proteção dos direitos de todos os indivíduos, incluindo os que se encontram em situação de detenção. Juntos podemos construir um futuro em que todas as pessoas sejam tratadas com dignidade e sem exceção. Muito obrigada.
Bonjour, je m'appelle Idrissa Sow. Je suis président du groupe de travail sur la peine de mort, les exécutions extrajudiciaires, sommaires ou arbitraires et les disparitions forcées en Afrique. Je suis également vice-président du comité pour la prévention de la torture en Afrique. C'est pour moi un profond honneur de m'adresser à vous en cette occasion mémorable. Aujourd'hui, alors que nous célébrons le 20e anniversaire du comité pour la prévention de la torture en Afrique et le 40e anniversaire de la Convention des Nations Unies contre la torture et autres peines ou traitements cruels, inhumains ou dégradants, C'est pour nous une grande opportunité de jeter un regard sur les étapes franchies et d'exprimer par la même occasion notre engagement renouvelé à relever les défis dans la noble cause de l'éradication de la torture sous toutes ses formes. Des progrès significatifs ont été réalisés dans nos efforts pour lutter contre la torture et défendre les droits de l'homme. Nous avons noté la mise en place de mécanismes nationaux de prévention dans plusieurs États africains, assurant une surveillance cruciale des lieux de détention et renforçant ainsi les mécanismes de responsabilisation. De plus, notre attention est portée sur le développement de la législation et des modèles visant à criminaliser la torture et à jeter les bases de réformes législatives promouvant l'interdiction et la prévention de la torture. Cependant, notre travail est loin d'être terminé. Nous devons continuer à plaider en faveur de la ratification de la Convention des Nations Unies contre la torture, ainsi que du protocole facultatif se rapportant à cette convention et aux autres peines ou traitements cruels, inhumains ou dégradants par tous les États africains. Ces instruments sont des outils essentiels de notre point de vue dans l'arsenal destiné à combattre la torture et à garantir la protection des droits des détenus. De plus, la mise en œuvre des instruments de soft law relatifs à la torture, tels que les lignes directrices de Robben Island, reste pour nous une grande priorité. Nous sommes convaincus qu'en travaillant en étroite collaboration avec les États et les organisations de la société civile, nous pouvons promouvoir l'incorporation de ces lignes directrices dans la législation nationale et les pratiques en renforçant ainsi les protections qui sont dues aux détenus et en prévenant la torture. En regardant vers l'avenir, notre comité est résolument engagé à jouer un rôle de leader dans la lutte contre la torture. Cela implique des engagements plus étroits avec les États et les organisations de la société civile pour garantir que les voix des victimes soient entendues et que leurs droits soient respectés. En favorisant le dialogue et la coopération, nous pouvons développer des stratégies innovantes pour relever les défis émergents et promouvoir la responsabilité des auteurs de torture. Je vous remercie pour votre aimable attention.
Congratulations and a happy birthday to the Committee for the Prevention of Torture in Africa, the CPTA, on the occasion of its 20th anniversary. My name is Barbara Bernat. I'm the Secretary General of the Association for the Prevention of Torture, APT, an international non-governmental human rights organization based in Geneva, Switzerland, working worldwide to prevent torture. And we were closely associated to the CPTA from the beginning. Let me mention here 3 highlights. First, cooperation. It started back when the APT proposed to the African Commission at its 28th ordinary session to organize a joint workshop for the effective implementation of Article 5 of the African Charter on Human Rights, prohibiting all forms of torture and ill treatment. This workshop took place in February 2002 in Robben Island, and it drafted concrete guidelines on the prohibition and prevention of torture in Africa, the so-called Robben Island Guidelines. The guidelines were adopted by a resolution by the African Commission in 2002. This resolution also establishes a follow-up committee to support their implementation, composed of commissioners, the APT, and experts. It met for the first time in 2004 and was later renamed the CPTA. But behind institutions, there are persons. And my second highlight is paying tribute to one person who played a key role in this journey, my former colleague and friend, Jean-Baptiste Nizuru-Beho, who so sadly passed away last November. He was one of the drafters of the Robben Island Guidelines, and he was also in the first meeting of the CPTA and was a member until 2019 when he retired. And we are also celebrating his legacy here today. The third highlight is the key role of the CPTA in implementing the vision of torture prevention in Africa enshrined in the Robben Island Guidelines. For example, on the first hours of detention, it mentions the importance of basic safeguards such as access to lawyers, and these safeguards are now integrated in the principles on effective interviewing for investigations and information gathering known as the Mendes Principles. The CPTA has been a leading actor on the promotion of the Mendes Principles in Africa. Thanks to the CPTA, there is a standalone resolution adopted by the African Commission in 2022 welcoming the Mendes Principles and calling on states to implement them. And the CPTA is also now leading on the implementation of the Mendes Principles and is organizing the first sub-regional workshop to discuss the Mendes Principles with police officers of Southern Africa in June this year. Prevention of torture and ill treatment is an ongoing task, but also a shared responsibility. Together, we can prevent torture.
My name is Faiza Badmos-Busari. I'm the Regional Program Manager at CHPR Network, the Strategic Initiative for Women in the Horn of Africa. This joint forum has been very, informative, educative, and has provided a platform for, good discussion and good engagement across all levels. The past 3 days have involved, looking at different types of the AU instruments, looking at the reporting mechanism, and really trying to get, good recommendations on how we can intervene or get state parties to be more committed, or what the AU can do better. A key recommendation for me, and one of the things that stood out of this meeting, was the need to engage, grassroots, between the AU and the grassroots, the increased engagement among both parties. It's important that their voices are heard, and it's important that their voices are heard at the places that matter. So I think going out of this, state parties should consider engaging them when drafting reports, state reports, and then also CSO engaging them, in the process of submitting reports as well. Thank you.
My name is Dr. Isaac Annan. I represent the Parliament of Ghana. In terms of what I can say about the forum so far, I can say it's been very, very insightful. It has been cross-fertilization of ideas from various organizations, including state and non-state actors. In terms of the mandate or the work of the Commission, I think basically as a commission that promotes and protects human rights, it has become clear that it needs to do more in terms of trying to deepen the knowledge of various actors or various stakeholders in terms of human rights, promotion and protection, by making sure that the various countries that form the commission, the member states, in terms of their legal education and education to judicial officers, especially judges, are deepened so that it will enhance the promotion and protective mandate of the Commission.
My name is Chiriche Osei. I'm head of programs at the African Union Economic, Social and Cultural Council, ECOSOC. And I'm really happy to be here representing ECOSOC at this important forum. I think one of the key takeaways is really how important it is to take the whole African Union human rights infrastructure, including the soft law, to the people. So there's more popular understanding. People know at the community level the existence and relevance of these instruments and how it applies to their day-to-day life. So I think we have an opportunity here to really strengthen our partnership with the Commission to make sure that we are working together to reach as many African people as possible to get them to understand the overall framework that governs human rights on the continent. Thank you.
Maximilienne Gambé, c'est mon nom. Je suis la directrice exécutive du réseau des défenseurs des droits humains en Afrique centrale, le REDAC. On couvre 8 pays de l'Afrique centrale, en dehors du Burundi et du Rwanda. Alors, pour nous, la Commission africaine des droits de l'homme et des peuples, c'est un instrument efficace pour la protection et la promotion des droits humains qui a donné un espace, n'est-ce pas, aux OSC, aux ONG. Et nous sommes très, très, très fiers aujourd'hui d'être là pour le premier forum. Ce que nous recommandons, c'est que les États parties donnent un peu plus de moyens, rendent la commission indépendante un peu plus de moyens financiers, parce que sans moyens financiers, il n'est pas possible de continuer, n'est-ce pas, d'aller dans toute l'Afrique pour promouvoir et protéger les droits humains. Merci.
Je suis professeur Hajar Geldish, je suis la conseillère juridique de l'Union africaine. J'ai le grand honneur et le plaisir de participer à ce premier forum sur les mécanismes spéciaux de la commission de Banjul. Je les félicite pour cette belle initiative, pour avoir amené autour de la table des personnes qui sont de backgrounds différents, à la fois des académiques, à la fois des organes de l'Union africaine, à la fois des défenseurs des droits humains en Afrique, mais aussi les États membres. Nous avons fait l'état des lieux, des instruments. Qu'est-ce qui n'a pas été ratifié encore pour pouvoir encourager les États à le faire? On avait mis en exergue le rôle de l'éducation, le rôle de la société civile, le rôle des associations, le rôle de la femme et de la jeunesse. Et on a fini par mettre en exergue pas seulement que les défis, mais surtout les solutions, les recommandations, comment aller de l'avant. Nous pensons que par rapport aux recommandations, il faudra peut-être dans les prochains forums se focaliser sur un seul aspect des droits humains. C'est vrai que les droits humains, c'est notre affaire à tous, mais il est important aussi de se focaliser sur un seul vecteur, un seul secteur, pour pouvoir bien le prendre en main. Mais en tout cas, ça a été une véritable réussite. J'ai personnellement beaucoup appris dans ce forum. Je vous souhaite beaucoup de succès dans l'avenir. Merci.
Yeah, my name is Harry Oguche-Obe. I'm a lawyer, a director with the National Human Rights Commission of Nigeria, and I head the Department of Economic, Social, and Cultural Rights. It's a pleasure to be part of this very important initiative of the African Commission to bring together stakeholders to discuss on how to actualize the mandate of the Commission and also provide a platform for the different stakeholders to connect with a view to promoting and entrenching the culture of human rights in Africa. For me, it's been a phenomenal experience, and I believe that going back home, there will be the way I as a human rights advocate and a human rights worker. Thank you, African Human Rights Commission, for this opportunity.
My name is Wangeshi Grace Kahuria. I'm the Executive Director of the Independent Medical Legal Unit, which is a national civil society organization based in Kenya. I am attending the first joint session of the African Commission on Peoples and Human Rights. And it is indeed a great opportunity for the Commission, for civil society, for governments to sit and talk around issues to human rights and the status of human rights in Africa. I do want to acknowledge that this has been a great space to share our thoughts, to share our experiences, to share and articulate issues around the status of human rights in Africa. Now, what I'm taking home is the importance of leveraging on the different mandates of the different levels of governance within the Africa Commission, but also the relationship between civil society, the academia, and the Commission. Of great importance is a convening space that the Commission brings, the fact that it is able to gather all of us from Africa to a session where we can discuss without fear, we can discuss without any form of intimidation, we can discuss from the realities of the organizations and the spaces that we serve. And we do realize that the provisions of the different international instruments, the different protocols provide for us the legal impetus on how to manage, to monitor, to report on human rights in Africa. Now, coming from Kenya, I really are delighted that Kenya is one of the countries that has submitted its reports, the state reports on human rights, and I think that is a fundamental, that's fundamental progress that the country has made. However, it's not just about submission of reports, it's about articulation of human rights in the country. IMLU is an organization that focuses on issues around torture, on issues around the right to picket, the right to assembly, the right to association, the right to expression. And from our work and from the conversations that we've had, from the monitoring that we have had, we note that this is a space that requires a lot more work. And so the question is, how do we get the support of the Commission to make sure that these issues are brought to the fore and to the light of the country so that commitments are made to address this issue? And so this is an important space, and I do want to appreciate that a lot of progress has been realized, and we can take it forth in the next session.
I am Honorable Farah Maalim from the Kenyan National Assembly. I attended the African Commission for Human and People's Rights conference in Dakar, Senegal. It's important for us to face some of these challenges of the modern days as a continent together. It's very important that the continent that moves together. We don't want to get into a situation in which certain parts or regions of the continent make leaps and strides in attaining human and people's rights, and certain parts also suffering the scourges of the extreme violations of their basic human and people's rights. So I think this conference was very good, and we have agreed on a number of things. And one of it is to domesticate the Commission's work so that they work with the very grassroots-based people, the rural folks. This does not have to become an elitist kind of a body where people meet only in capital cities and where lawyers, engineers, and doctors are the ones who contribute. It's important for them to understand the problems, the human rights problems of the peoples in the very, very, simple and very humble rural settings. It's also important that Africa wakes up to the realization that we have historical injustices that were done to us. Injustices in the form of slavery, colonization, and neo-colonization, the extraction and exploitation of the raw minerals and resources of the African continent. And the people who are responsible for that are known. It's the first world. They must be able to prepare themselves for reparations as well as compensation. Thank you.
My name is Daniele Teccarelli. I work at the European Union delegation to the African Union in Addis Ababa, attending this forum organized by the African Commission for Human People Rights. It's been a good opportunity to exchange with the Commission, with the court, with other human rights and democracy organs, and also with especially with African Union member states, representatives from national human rights institutions, CSOs, on positive aspects, negative aspects, things that could be improved for us as a European Union, which are a partner to the African Union in general, and specifically to the African and governance architecture platform organs. It's important to hear those voices.
On commence? Oui. Bonjour, bon après-midi, honorable commissaire, Excellences.
Commissioners, Excellency, dear participants. Here we are again, back from lunch. We're here for the second edition of a joint special mechanism forum for the African Court on Human People's Rights. We're going to start a new session and a new theme, session 9, which is on how to deal with the movement of population due to conflicts, climate change. This in relation with development. To this end, I would like to invite Honorable Kose, the moderator of the panel, Sisafe. Commissaire Sisafe will be accompanied by Mrs. Sipra Ajas, who is in charge of the IOM in Gambia, International Organization of National Office for Migration. Mr. Jean-Nicolas Mati for the International Committee of the Red Cross, the Dakar office, as well as Honorable Mrs. Vimbai Nyemba, the Permanent Secretary of the Ministry of Justice of Zimbabwe. Please, can you come up to the podium? With the participation of Kineti Beb Kasa of Crisis Action, and she will be doing that online. Now, with regard to the theme of this panel, we can say the displacement and migration prompted by conflicts, climate change, and environmental degradation expose affected individuals and communities to high levels of risk. They erode fragile livelihoods and ecosystems, aggravate existing vulnerabilities, and undermine resilience. This hinders many of the Charter protected human rights and sustainable development goals, including ending poverty, Goal 1, ending hunger, Goal 2, and good health and well-being, Goal 3. The panel reflects on averting, mitigating, and responding to conflict, climate, and development-induced migration. The panel will also address the structural causes of conflicts and how human rights can address these. Without further ado, then, I'm going to give the floor to Honorable Commissioner Selma Sassi Sefa. Thank you very much. Thank you, Dr. Mohammed. Allow me, in turn, to be welcome to the chairs of the Human Rights Commission and honorable delegates and the representatives of regional organizations, as well as the representatives of NHRIs and the civil society that have been supporting us since this session started. As Dr. Mohammed was saying, this 9th session will be devoted to prevention against enforced migration, also provoked by conflict, climate, and their consequences on sustainable development. Allow me, first of all, before I proceed with the deliberation of this panel, to introduce the experts and the representatives of some organizations and states that are with me on this panel. I would like to start with Mrs. Sibka Ahaz from the IOM. Madam Sibka Ajaz is the coordinator of the program for managing migration, and she's also the officer in charge of IOM Gambia since September 2024. Allow me also to introduce to you Mrs. Vimba Nyemba. We would like to bid her a warm welcome. Mrs. Nyemba is a permanent secretary of the Ministry of Justice, of Legal Affairs and Parliamentary Affairs of the Republic of Zimbabwe. I also have with me here Mr. Jean-Nicolas Marty, who's a delegation head of the International Committee of Red Cross in Dakar, that covers Morocco, Mauritania, Gambia, Guinea-Bissau, and Cabo Verde, Liberia, and Sierra Leone. We also, for this session, a participant online who will join us in a few moments. That is Mr. Kineti Beb Kassa of Crisis Action. He will join us in a few minutes online. Before I give the floor to our honorable panel members to propose or provide some introductory remarks on this theme that has been proposed to us for this session. You're all well aware that, and more than ever before, that the African continent is faced with enforced or massive forced displacements caused by a complex combination and interconnected factors, armed conflicts, political violence, as well as natural disasters, often caused by climate change that is increasingly violent on Africa. All of these lead to a degradation of socioeconomic conditions, as well as worsen food security and water security in our continent. So migration becomes then not a choice, but a need, and sometimes even the only survival solution. And according to statistics from international organizations and from the IOM, the ACHPR, and many African and foreign research centers, close to 45 million Africans were forced to travel or to be displaced in 2024. Forced displacements are often in the Sahel region and in the Horn of Africa and the Great Lakes region. Forced displacements that's going to worsen pressure on the host communities and population growth that is unplanned, and sprawling urbanization with restrictions of access to basic services such as health, accommodation, lodging, and labor. This forced displacement that's going to exert pressure on natural resources, and these are factors that compound the conflict. All these realities that we've just mentioned will also inevitably impede the achievement of the Sustainable Development Goals provided for by Agenda 2030 of the United Nations and Agenda 2063 of the African Union. Many sustainable development goals will be impacted. For example, SDG 1 and 2 on poverty and hunger, 3 on good health, 4 on access to education, 11 on sprawling urbanization, 12 on scarcity of resources, and what have you. All these happen despite the number of states. I'm thinking specifically of the Kampala Convention or the OAU Convention on Refugees in Africa. All these challenges actually compel us to think of how to help African states to mitigate these forced displacements caused by climate change and conflicts in Africa. And without further ado, I'm going to give the floor to our members of our panel members so they can share with us what they think about these issues raised in this session. I'll start by giving the floor to Mrs. Sibiga Ajaz, who's from the IOM, who's going to talk about the prospects and strategies of the IOM faced with the increase of international IDPs due to climate change. Madam, you have 10 minutes. Thank you for your point of view. Thank you.
Madame la modératrice.
To the organization, to the organizers for giving the floor and the opportunity to IOM to be at this panel session. A topic which is very, very relevant and extremely pertinent for the continent, and something which is very close to the work of the International Organization for Migration, not just here on the continent, but also globally. So for those of you who are not familiar with IOM, so the International Organization for Migration, or IOM, we're a related UN organization, and climate action is one of the key areas in which we support member states. The impact of climate change on human mobility, that's something that we're witnessing quite a lot, and the moderator, she also mentioned about in terms of numbers, how many people have been displaced as of 2024. So just to quote a few more numbers, so globally, as per a World Bank report, it is estimated that about 216 million people will be displaced as a consequence of or as a result of climate change by the year 2050. And of these 216 million, it's 86 million are just from the sub-Saharan Africa, which are expected to be displaced by 2050. And most of these displacements are expected to take place within the region, which is also, it's a call for timely action by all actors at this point in time to ensure preparedness for these changes. When, in terms of the work that IOM does globally, so IOM's work on this thematic area, it's driven by our strategy on migration, environment, and climate change. And our role is basically driven by three, you can say, thematic pillars. One aspect is on the migration policy side. So I think legislation and policy around this aspect is something that we consider extremely, extremely critical. So including, so for example, supporting the governments with making sure that there are climate adaptation plans, also mainstreaming climate change as a topic in, for example, national migration policies, also respective development policies, really to see that the legislation and the policy framework is there. So that's one area of interventions that IOM does. Another role is on the very, very operational level, that IOM works directly with migrant communities or with displaced population to provide adequate protection services, preventative measures. A very concrete example of this I can give you, for example, for the Gambia's case, we're supporting communities as well as vulnerable populations with, let's say, trainings on climate-smart agricultural practices. And that's one of the ways that we are teaching them how to mitigate the impact of climate change. And then also helping them set up small businesses so they can generate livelihood opportunities. The third pillar on which we work is on the knowledge generation side.
For those of you who are familiar with IOM's work, data is something that's very core to our work, and also because you mentioned the SDGs, another framework that I would also like to mention, which is for which most of the countries they have strong commitment towards, is the Global Compact for Safe, Orderly, and Regular Migration. And climate change is something that is very well mainstreamed into the entire GCM agenda. And if action is not taken timely, it also impacts the government's progress on GCM implementation on the continent. And also to point out that there are specific GCM champion countries which have shown significant progress in achieving the GCM. And I think 8 of the countries, they are from the continent, which also really signifies the importance that the continent is giving towards migration issues. So the very first objective of the Global Compact for Safe, Orderly, and Regular Migration is developing evidence-based solutions, so the data. And that's where IOM strongly, we intervene and we provide not just technical support to the government to develop evidence-based solutions, but also there's a lot of research that IOM has been doing and continues to do. For example, we do climate vulnerability assessments. We also have another tool which is called the Transhumans Tracking Tool, which is also, transhumans is something that I would really like to point out, which is very relevant for the continent, and also it is something that can be also now seen, the changing transhumans patterns as a result of climate change. That is also emerging as a driver of conflict, because you also spoke about structural issues. And the last area on which IOM, or we strongly work, is our role as a convening agency. So for us, climate action cannot be achieved if there is no partnerships and engagement between different partners. And that's where I know you also referenced the Kampala Declaration, and those are existing platforms on which IOM can also provide technical support for, but also convening at the very local level, for example, CSOs, academia, public-private partnerships. So that's the fourth pillar on which we provide support. But the areas on which we work, I think the key messages that from my end or from IOM's perspective that I want to share is that any intervention, it has to be people-centered. So that's something that we strongly emphasize on. Localization, that's another very important aspect, because any solutions that we're developing or devising, they really have to meet the local priorities. So community-based approaches to livelihood generating, for example, opportunities, and really localized activities, how to mainstream migration and climate change, for example, into local governance planning frameworks. So it doesn't just remain at the national level, but also at the very local level, then you're able to see change in terms of policy as well as programmatic. Then also evidence-based, which I've already spoken about, but also making sure there is strong advocacy around this subject, which is still much needed, even as we're talking about it. There's still not a lot of knowledge around this subject, so that's something that we strongly advocate for. So I will stop here, and I will hand over back to you, and if there are questions, then follow-up questions, I can respond. Thank you so much.
Merci beaucoup, Madame Sigba.
Madame Sigba, for your intervention. That was very brief and very clear as well. So thank you once again. You recall the strategies and the policies of the IOM, the pillars on which you base yourself to establish the relation between climate change and forced displacements, and you recall that in all your strategies and policies, the human being has to be at the center. So I think you establish the relation between forced displacement and climate change, as well as the sustainable development goals. Thank you very much. And now I am going to give the floor to, if you allow, sir, Mr. Mati, I'm going to give the floor to the representative of Zimbabwe. I'm going to We'll give the floor to Mrs. Vimba Nyemba, the Permanent Secretary of the Ministry of Justice and Legal and Parliamentary Affairs of the Republic of Zimbabwe, who is going to talk to us about migration and displacement induced by migration and development in Zimbabwe, and will also discuss with us the measures and national strategies that seeks to mitigate and tackle the challenges that ensue from this. Thank you very much. You've got 10 minutes, ma'am.
To be part of this crucial discussion on addressing climate and development-induced migration and displacement. As a nation experiencing firsthand the impacts of a changing climate and the pressures of development, let me pick up from where I had ended. I had ended where I was talking about my country as a nation experiencing firsthand the impacts of a changing climate and the pressures of climate change. We recognize the profound human rights implications of these interconnected challenges. Although climate migration is broad in context, it has manifested itself in internal and cross-border migration is no longer a novel crisis, but it has become a lived reality for Africa and beyond. It is evident that environmental degradation driven by climate change and certain development pathways is increasingly becoming a significant driver of migration and displacement across our continent. This movement of people is not merely a shift in demographics. It represents a direct threat to the enjoyment of fundamental human rights enshrined in the African Charter. Livelihoods are eroded, access to food and water becomes precarious, and the very fabric of communities is disrupted, directly undermining our collective progress towards the Sustainable Development Goal 10, Target 7, concerning safe, orderly, and accountable mobility and migration. According to the International Organization for Migration and the Internal Displaced Monitoring Center, in the last decade, 208 million people have been displaced. Of that total, 5.9 million people were displaced internally, and of that number, 7.7 million people were moved due to climate factors. For Zimbabwe, the devastating impact of Cyclone Idai, Freddy, and Filippo serves as a reminder of the destructive power of extreme weather events. Zimbabwe, along with neighboring countries, witnessed the widespread destruction, displacement, and loss of life on unprecedented scales due to the recurring El Nino and La Nina phenomenon. These events underscore the urgent need for proactive measures to address climate-related displacement and build resilience within our communities. In Zimbabwe, in 2019, Cyclone Idai displaced more than 270 people, with at least 340 reported dead and hundreds more missing. Over 90,000 children experienced the interruptions in their education due to the destruction of school and educational facilities. Esteemed colleagues, it is imperative for the continent to develop a matrix of both preventive and migratory measures to reduce the impact of climate change on migration. Some of the structural causes that exacerbate vulnerability to climate and development-induced displacement, including issues of inequality, resource scarcity, and conflict, must be addressed. Integrating a human rights perspective into our analysis of these drivers is also essential by addressing issues of marginalization, promoting inclusive governance through participation of vulnerable populations, and ensuring equitable access to resources, we can build more resilient communities, less susceptible to displacement. On its part, Zimbabwe is actively implementing climate change prevention measures to build resilience and reduce the risk of climate-induced displacement and migration as recognized in the National Migration Policy. The policy acknowledges that environmental factors such as droughts, floods, and land degradation are driven internal and cross-border migration. In response, the government has established a disaster risk reduction strategy, which recognizes adoption of early warning systems coupled with adherence and enforcement of an environmental impact assessment to avert climate-induced migration. The strategies include the Fumbudza in Twasa, a conservative farming program helping farmers in vulnerable dry and arid regions experiencing erratic rainfall and floods. Solar mini grids in remote regions are promoting clean energy access, reducing pressure on forests, and supporting rural development, while reforestation projects in Chimanimani are reversing environmental damage from disasters such as Cyclone Idai. Additionally, small dams and solar-powered irrigation systems in dry regions are enhancing water access and agricultural productivity. These prevention strategies, aligned with the migration policy, aim to address the root cause of climate-related migration by building community resilience and safeguarding sustainable development. A key example of integrated approaches climate proofing and development was the construction of Tugwi Mukosi Dam, which to date is Zimbabwe's largest inland dam. The construction of the dam relocated over 20,000 people who in turn benefited from improved agricultural productivity through irrigation mechanization, which has reduced the need for out-migration by creating sustainable livelihoods. This development also supports aquaculture and has become a focal point for tourism activities and downstream industries, offering alternative sources of income to local communities. Whilst the Kampala Convention adequately provides for climate-induced internal displacement, the 1951 Geneva Refugee Convention and the 1967 Protocol do not cover climate-induced displacement as basis for the granting of refugee status. Zimbabwe therefore strongly advocates for the expansion of the legal definition under existing global frameworks to guarantee protection of the rights of persons displaced by climate change. Ladies and gentlemen, international cooperation, deployment of technology and interventions, commitment to reduction of greenhouse emissions and climate adaptation and mitigation strategies to minimize climate-induced migration is necessary. There must be a mix of approaches involving transition to cleaner and renewable energy. Distinguished delegates, allow me to conclude by reiterating that climate-induced migration should not be relegated to an academic discourse, but must solicit urgent, domestic, and sustainable solutions which foster endurance and resilience. I thank you.
Merci beaucoup, Madame, pour votre...
Madam, for your presentation and for having stuck to the time given to you. Indeed, you have shared with us, you have shared with all participants here present, the strategies that are being put in place by the Republic of Zimbabwe. Preventive policies. Can you confirm if you can hear the interpreters? Can you hear the interpreters? Can you hear the interpreters, ma'am? Yes, madam, I was saying, the permanent secretary, I was thanking you. Can you hear me now? Can you hear the interpreters? Very well. I would like to thank you, the permanent secretary, for your presentations and for sharing with us the experience of the Republic of Zimbabwe, which is confronted with several challenges due to climate change. You have shared with us the strategies relating to migration, preventive policies, and you have also talked about an important issue, namely under the docket of the African Commission. You talked about the need to fill a legal vacuum on IDPs because of climate change. And I would like to seize that opportunity to inform you that the African Commission on Human and People's Rights has adopted a resolution during its previous session with a view to initiating a study aimed at proposing a legal framework for all individuals who are forced to cross borders sometimes because of climate change. So this is indeed a concern which is taken on board at the level of the African Commission on Human and People's Rights. Once again, Permanent Secretary, I would like to thank you. Now, let me turn to Mr. Jean-Nicolas Marty, the head of the ICRC delegations, and who would share with us the viewpoint of the ICRC when it comes to the fight against forced displacement due to conflict and in relations with climate change. You have the floor. Thank you. It is a pleasure to take the floor for the second year in a row at the forum of this specialized mechanism. I would like to thank Commissioner Salma for your kind words for the ICRC as a chairperson of this panel. Initially, it is important for me to state that migration cannot be pushed under the carpet. The situation of migrants found in armed conflicts. This has forced the migrants to look for new opportunities, and they take dangerous routes by the road and sometimes transits in areas that are prone to conflict. The case of Libya, Mali, or Sudan. This situation is aggravating the risk of death, and here I would like to congratulate the African Commission through the adoption of 2021 Resolution 486 on migrants who disappeared, and called upon the states to protect the fundamental rights of those individuals and to include this issue in their policies. Furthermore, in a context where figures of IDPs are constantly increasing, our response in line with this displacement linked to armed conflict and climate change is crucial. At the end of 2023, the continent had 35 million people who are displaced in their own country. This is half of the world total and 3 times compared to 2019. Conflict, violence are the main factors leading to the displacement of these people. Furthermore, several individuals have been displaced on several occasions or over long periods. Conflict, violence are cross-cutting and in most cases repeat themselves. They make this crisis even more exacerbated. ICRC, what can we do in such a situation? Well, we have a preventive approach. In our quality as custodians of international law, we work towards enhancing the respect of human rights in armed conflicts by stopping from the onset the apparition of conditions that will enable people to leave their households, especially when it comes to the Kampala Convention that was mentioned previously. Our work would reinforce this preventive work. Those who support ratification of the convention and who have not yet become parties to this treaty, and the domestication and operationalization of this convention. In this regard, we can name the examples of laws adopted in Niger and Chad, respectively in 2018 and 2023. When it comes to the operational response of the ICRC, as soon as displacement took place, we mainstream the specific needs and the vulnerability of displaced individuals within the country, and in its analysis and response, pluridisciplinary response, with a view to enhancing protection, access to basic care, and their resilience, just like the other parts of the population. The continent also promotes the respect of international obligations and to call upon all parties to be involved. And we commit ourselves with the states, the stakeholders concerned, on the issues and sustainable solutions for displaced persons. ICRC has participated from the onset with the Interorganizational Permanent Committee, under the acronym YAS, on humanitarian response for internally displaced peoples. As a member of the reference group, which has supported the work of the team charged with this task, we have contributed on the basis of our long-term practice when it comes to response to displacement situation. We have seen that internally displacement is exacerbating, whilst the humanitarian system, which, as you know, is under constant financial situation. We will come back to the Q&A. And this humanitarian system cannot respond effectively to the crisis, or sometimes they respond late because there is a penchant on internal matters, and it is difficult for displaced persons to adopt a normal life. The recommendations of ICRC, now for us the responsibility of states and specifically parties to conflicts is primordial. The states have to adhere, they have to respect and ensure on behalf of Article 1 of the Geneva Convention, the humanitarian international law, and they have to respect the prohibition of space displacement and respect the conditions so that the displacements that take place be done under the conditions of security for civilians, and also to protect the civilians against the hostilities that can lead to displacement. But then the parties to the conflict have to respond to the needs of the civilian population and also to guarantee, facilitate the rapid relief and without any impediments. This respect of international law would reduce the damages, and in effect, repeated violation of international humanitarian law can lead to high-scale displacement within a country or beyond the international borders. The national authorities, therefore, have the responsibility to provide sustainable solutions to displaced persons, internally displaced persons, by guaranteeing the necessary conditions, especially security, and by providing the wherewithal so that the displaced persons either go back to their countries through a voluntary repatriation to their areas of origin, or integrate them locally in the areas where they find refuge, or the reinstallation in another part of the country. It is crucial for the IDPs have the choice to voluntarily choose and in all knowledge the sustainable solution which will be convenient to them, and also to participate in its planning and management. The search for solutions for IDPs should avoid the return ticket, which because some authorities in default think that is this better solution to the detriment of other actions. The displaced persons in urban areas outside the camps are invisible among the poor populations, and they do not have access to help. Now, to find sustainable solutions to urban displacement, it is crucial to work at several levels in collaborations with humanitarian relief workers, development actors, and also to involve the local authorities so that you can respond to the individual needs and also to fill the gaps relating to security and the self-sufficiency of internally displaced people. Mitigation funds have to take into account the vulnerable nature of IDPs who due to climate change. At the same time, it is important to acknowledge that mobility can be a crucial mechanism for adaptation or survival of individuals who bear the brunt of armed conflict, and that they should be supported, especially when alternative solutions will lead to a prejudiciable adaptation mechanism. This support should be based on the priorities and the concerns of the populations. In conclusion, I would like to remind you the next point, the following items. It is extremely crucial to adhere to international humanitarian law with a view to contributing to reducing the situation of internally displaced because of armed conflict. It is also important to ratify and fully implement the Kampala Conventions and also to enhance the understanding of the cumulative impact of conflict and climate change on displaced people with a view to adapting and proposing a holistic solution. Finally, given that this phenomenon is still continuing, there is need to put in place sustainable solutions to overcome this situation. We are convinced that the initiatives that are looked at by this panel are fundamental to respond to these challenges, and we commend you to continue discussions in that particular field. I thank you for your kind attention. Thank you, Mr. Jean-Nicolas Marty, having shared with us the viewpoint of ICRC on this phenomenon. You have underscored the various actions and activities and strategies of the ICRC for the benefit of IDPs due to climate change, but also due to armed conflicts in Africa. You have proposed several recommendations for these states. As a reminder, to remind them of their responsibilities emanating from their international and regional commitments. And Mr. Martin, you did right to throw light on a dramatic situation that we experience in Africa, namely the disappeared migrants and the consequences on their respective families. And indeed, this indeed is a drama. This is how I would qualify it. That is of concern not only to the ICRC, but the African Commission. You have reminded of Resolution 486, which actually should be implemented by several states, and also it should be operationalized by the various stakeholders. So I thank you, sir, with your proposal. I am told that the panelist online is not yet connected. So I will now move to the interactive portion of this panel, and I will therefore hand over the floor to members, to participants here present for their inputs. Let me start with state delegates. I can see Algeria. You have the floor. Thank you, Honorable Commissioner. Thank you for giving me the floor. I would also like to express my thanks to panelists for their brilliant interventions and the quality of their inputs. My delegation is of the opinion that the dynamics of migration in Africa can only be analyzed by taking into account structural factors which are underpin especially historical heritage of colonialism and its global asymmetry, north and south, and the impact on climate change. For example, Algeria, as a country of transit and destination, is in the front line of this flow. We do, however, assume our responsibilities in line with international law, and through active collaboration with the neighboring states and IOM to ensure voluntary return with dignity. So it is crucial to look at the migratory issue not under the prism of unilateral responsibility, but in a systemic reading, integrated and solidary. And in that regard, African policies, when it comes to migration, should be based on a holistic understanding of the profound causes with a view to avoiding any fragmented approach or based on stigma. In that regard, I would like to ask the following question. What is the intellectual and narrative role that the African Commission can play to feed in the authentic African narration on immigration, enshrined in historical justice based on African solidarity, and resisting to the instrumentalized reading of the migratory phenomenon? I thank you. South Africa.
I thank the panel members for sharing their insights on this important topic. We are encouraged that Africa continues to add its voice to this growing concern about the effects of climate change on migration. While we continue to talk about this important issue, it is important to note that there is more that needs to be done on this topic, in particular in the continent, which is why I have the following questions and comments for the panelists. The panelists have briefly touched on data collection. However, my delegation is wondering if we have accurate data of the number of climate-induced migrants or displaced persons in Africa. Accurate data becomes very important in attempting to find evidence-based solutions to problems. Taking into account the many challenges that the climate-induced migrants face when they move from one place to another, as a short-term solution, shouldn't we also be thinking of developing regional guidelines that can assist policymakers within the region on addressing this challenge? And as a long-term strategy, we were thinking that we should develop protocols that will protect specifically climate-induced migrants and persons displaced by climate change. In this regard, I was happy to hear from the moderator that there is a study that was conducted towards a legal instrument. On that, we would like to know if the study that was done by the Commission was presented to member states. If it was presented, can you highlight what were the key outcomes of the study? I thank you, moderator.
C'est moi qui vous remercie, Madame la représentante de l'État. Est-ce qu'il y a encore des délégations? Malawi, oui, vous avez la parole.
The floor.
Presentations that have been run, and I just want to share that the same disasters that were happening in Zimbabwe, we are neighbors with Zimbabwe, and it also affected Malawi. But I want to ask two questions from the peers. We had two challenges that were very critical during the disaster, especially when it came to the IDPs, where we put the children in the camps, where you find that families of a mother and a father, and then the youth, and then the children, they would be, lumped together. I think one thing that we had an issue was how we could separate the children from the youth, and also the dignity of these youth, because at times, because the numbers were just too overwhelming, that sometimes you find that we use the classrooms of schools to accommodate the youth. And as a result, we could, sometimes the children that are males and the children that are females had problems where to sleep and where. So I was trying to find out these challenges that are there regarding the children. In terms of the numbers that overall you have given unto us, is it possible to have segregated data where we have also the children, that are also affected so much? They are the most vulnerable group. But during the disasters with the humanitarian response, sometimes it's very late. You find that the children are clumped together in terms of nutrition, in terms of their early childhood development, school centers, they can't be there. So is there anything or any strategies that you could actually propose? Thank you very much.
Je vous remercie. Est-ce qu'il y a encore des délégations des États qui...
Any more state delegates would like to intervene at this juncture? I can't see any. So let me now move on to the NHRIs or civil society organizations. Yes? Kindly introduce yourself and say which organization you represent.
Amnesty International, and I work as a climate justice advisor in our East and Southern African regional office. So for the last 2 years, we have been documenting violations that climate-induced internally displaced persons have been undergoing in countries such as Madagascar and Somalia. And we've been really covering cases of human rights violations, families being forced to sell their children just to get some money to afford transportation cost, some form of slavery. Women being forced to somehow sell their bodies, again, in exchange of transportation cost, thousands left homeless, and hundreds being exposed to brutal forced evictions by the government in Madagascar, for example. And the major problem has been this question of remedies. When we talk to government authorities, the card has been, we did not cause climate change, and there's some truth in that. But really, when we speak of remedies, this has been bringing us back to the Kampala Convention on Internally Displaced Persons, which recognizes that people internally displaced by climate change are entitled to remedies. But the convention goes further as well to also provide for a compliance mechanism. And here it really empowers the African Union to be regularly convening a conference of the parties to come up with solutions regarding the crisis that we're having of internal displacement. But since 2009, we have not had this conference of the parties organized by the African Union. There was just one in 2017, and it didn't touch on climate change-induced internal displacement. And this brings me now to my question. Can the conference of the parties under the Kampala Convention be an opportunity for African states to really come together and try to devise solutions to see how they can bring about the accountability for climate-induced internal displacement on the part of global North countries. Thank you very much.
Oui, merci monsieur pour la...
Thank you, sir, for your question. Please go ahead.
My name is Masoud and I work for the consortium of Ethiopian human rights organizations. Thank you for this very important panel where we have been doing a lot of advocacy on durable solution, especially for conflict-induced displacement in Ethiopia, where we have right now more than 3 million people displaced, mainly because of conflict, but also because of climate shock, flood, and other disasters. So on the current situation of the IDPs in Ethiopia, there have been a lot of efforts by the government, including the durable solution strategies that has been piloted in Somalia and also nationally. Last year, the government has started that strategy. But unfortunately, the migration policy, which includes other forms of human movement, is not yet adopted, and the domestication of the Kampala Convention has not been also finalized, and it took more than almost 2 years. And the challenges that are persisting on the ground include that there has been protracted displacements where people displaced are not either back to their places or not integrated or not resettled, and it has created a lot of challenges for the protection of the rights of IDPs, where there is limited access to basic services, livelihood, and education. There is also no binding legal framework, as I already mentioned, and most importantly, all the actions that concern IDPs should be guided and led by the full participation of IDPs in the durable solution or in any solution that are placed. And this participation of IDPs is also very limited in the decision-making process, including the national dialogue process, which has been started. We have been advocating a lot, and they have been recognized and one segmented as participants in the process. But we believe, as those people who are out of the camp but displaced for many reasons are not meaningfully engaged. So, Your Honor, we encourage the government to expedite the adoption of the migration policy and also domesticating fully the Kampala Convention, as well as lifting the reservations on the Kampala Convention, especially for those conflict-induced displacements. It is also very important to strengthen the community engagement to ensure voices of IDPs are meaningfully included in the political process, including the upcoming election, the transitional justice process, and also in the national dialogue process. I also urge the Commission and Your Honor yourself, your mandate, for having a country visit, engagement with key stakeholders working on IDPs issues, and also local civil society, so that all the decisions are inclusive of the voices of IDPs. And we as a consortium remain to be contributing in any capacity we can do. Thank you very much.
Je vous remercie, monsieur. Est-ce qu'il y a encore des demandes de parole?
Any other person who would like to take the floor? I can't see any flag raised. I'm going to turn to the panel members and give them an opportunity to answer the various questions and remarks that were made by the audience. I'll start with you, madam.
child protection, in terms of child protection for the children that have got different ages, maybe less than 5, and young people who are teenagers. But then the accommodation where you are accommodating them is very difficult sometimes to do it. That was one of the challenges that we had when we had this Idaya, that, you know, so many children were there, but they could not go to school, they could not get their nutrition and so forth. The humanitarian response was very also late. So what strategies would you actually advocate?
Thank you. I don't think the problem is really the voice, but the problem is that from here, all English speaking who are not being translated here, we can't hear them. But when anybody speaks and we have the translation, we get them. There are echoes to such an extent that I couldn't get the question very well. But I will attempt to answer what I think I heard. You were indicating that the children must be separated, but you were also worried that if it's a family, it cannot then be separated from each other. You know, when disasters strike, sometimes people are lumped together, but we take cognizance of the fact that the interests of the children are of paramount importance. They are taken care of as much as is possible, together with women. Men are usually very strong, but they are not ignored in the process. Like when Cyclone Idai struck in Zimbabwe, there was a whole village that was swept away, and a river was formed on those places. People who tried to go, run away, and seek refuge at a police camp, that camp was also destroyed. Those that tried to go to a growth point where they could seek shelter, that growth point was taken away, to the extent that most of those people who died, some could not be found. They were all, they all ended up in Mozambique, in the Atlantic Ocean. And that was, I think, that was too bad. It was really a catastrophe. It's something that was not expected. There were no preparations for that. So at the time that people were taken, I will agree with you that people were put in the same place just to get them to be together, while accommodation, food, clothing was being brought from somewhere. But like I have reiterated, I think it is important for African countries to just be proactive. In my country, we had not had these disasters. And our people as well are not very eager to move from their premises. Even if you tell them that a disaster is coming, they don't want to leave the graves of their ancestors. They don't want to leave their surroundings. So there is also resistance even when they are informed in advance. So when these catastrophes then strike, sometimes they will have run away from help, trying to continue to live in the premise, on the areas of their heritage. I thank you.
C'est moi qui vous remercie, Madame. Je vais vous passer la parole, Madame Sibga, aussi pour...
The floor, Madam Sibga, so that you can answer the questions that were put to you regarding the IOM data and your conclusions as well.
Were more to address to governments and also, of course, the African Union. So I will just pick up on a few things that I think are relevant to IOM specifically. Starting with the point that was raised by Algeria, I know it was addressed to the AU, and when you brought about the topic of addressing structural factors, from our perspective, of course, addressing structural factors That is something that is critical. And one example I can also give you is the work, for example, you spoke about how colonialism and those older structures, they are still very much used in the region. And that's where the role of governments comes in. For example, if you're revising or updating land-related policies, that is addressing a structural factor. So we also see that when because we're talking about human rights violations here also, some of the land policies that we're using, they're some of the most outdated versions that limit rights of certain people. And also here, I would like to also bring the gender lens to it. So women are some of the most impacted vulnerable groups who do not often our land policies in the region, and specifically ones that are older versions of land policies and countries that do not have policies that align with the international standards. That's where women are the most advantaged. And for example, when you have disaster strike, where you have communities that have to move, women often do not even have access to resources, and they are impacted. So certainly for us, addressing structural factors and looking at the policy and legal landscape is certainly that's something that is of importance. And the other part, I think there was some, again, I could not really hear all the questions, but there was also some question around IDPs having access to resources and having access to justice and protection systems. And that's where also, again, the role of, and one of the key reasons, it's not just for IDPs, but we also see for vulnerable migrant populations, having access to legal identity documents. That is something that often prevents these people from getting protection services. And that's something where also it's a collective role, but also the role of the governments comes in quite strongly, that often legal identity access, it's something that also often prevents people from accessing justice mechanisms. But we do also, and there was also one comment about the policies and how they integrate migration as an agenda for the I would also like to refer to the Agenda 2063, and I think that very nicely covers migration issues. They're very well mainstreamed into the Agenda 2063, but also if you also speak about some specific frameworks for example, the AU integrated border management strategy, that also talks about, it references climate change, it also references conflict that's arising as a result of climate change. So there are some very, very good practices that are existing on the continent level, but the role of governments in really making sure that these are implemented, that is something that we emphasize upon. But last but not the least, again, just to reiterate that for us as IOM, migration has to be really viewed as a part of a solution and not to be viewed as a challenge. People will continue to move. From us, we need to ensure that they move in a safe, orderly, regular manner, and the vulnerable ones are protected. So I will stop here. Thank you very much.
Merci beaucoup, Madame Sibga. Monsieur Marty, vous prenez.
Please, can you answer the questions that were put to you? Thank you. Well, not so many questions were directed to the ICRC, so I'm going to focus on 2 points. The first is that the appeals that were made so many times regarding the relevance of the operationalization and the domestication of the Kampala Convention. For us, that is quite important, like I underscored in my presentation. I also like to end with notes that is not exactly negative, but a request for awareness on what is happening, the war that is having regarding the reduction of financial resources to development and humanitarian aid. Today we are already feeling some impact. Yesterday I was with the Red Cross. I was discussing this with the Senegalese Red Cross last week, and in other regions. What is happening today at the international level is very worrying, and there will be humanitarian consequences that we can actually predict at this juncture. But I'd like to underscore the fact that we are going to have to collectively find solutions to meet the increasing needs in the crisis that I mentioned earlier in my intervention. Thank you once again. Before I conclude this session, I'd like to very briefly come back to some observations and answer some questions that were put directly to the African Commission on Human and People's Rights. I'd like to start with the first comment made by the delegate from Algeria, who recalled and focused on the colonial heritage as one of the causes, the root causes, of migration on the African continent, and he wanted to know the position or the stance of the African Commission on Human and People's Rights in the management of migration. So what I can say on this question is that the African Commission is aware, is conscious that the management of migration cannot be incumbent on one state only, but this issue has to be managed in a holistic manner, in an integrated manner, based on the principles of solidarity. And so many resolutions that were adopted by the African Commission on Human and People's Rights, and I'm going to mention just the last one, that's 582, that was adopted in 2024. The African Commission of Human and People's Rights recall the need to tackle the root causes of forced displacement on the African continent, but with a global management of migration. We know that at the Commission, this issue cannot be unilaterally managed by one state. So all our activities, all our solutions, all our decisions are geared towards that direction. So the question put by South Africa on a study, if I'm not mistaken, that I mentioned, that's in relation to the intervention made by the delegate from Zimbabwe, who talked about the proposal of a legal definition. Am I right, madam? On which we can provide legal protection to force people who have been displaced outside their state. I was mentioning a study that was adopted recently by the African Commission, and you wanted to know why states were involved in this study. It is a resolution that has just been adopted on the need to develop a study. This study has not been developed yet. We have not actually published a call for communication, so this study hasn't started yet, but when we start it, we're going to consult states. Very quickly, regard to the questions or remarks that were made by the representative of NGOs. First, on the issue of the Conference of State Parties, that's the Kampala Convention. I'd like to let you know that this issue is going to be taken care of. We, the African Commission, we're going to come up with an advocacy with the bodies concerned. And to wrap up very briefly as well, the last speaker from Ethiopia on the issue of the domestication of the Kampala Convention and the need to involve internally displaced persons on all the solutions that concern them. So all these will be taken into account by our commission. Now, to conclude and to give the floor to leave to the last session, I think what we can retain from this section and the discussions that followed, the prevention of forced displacements caused by conflicts in Africa, armed conflicts in Africa, as well as climate change, require an integrated approach based on sustainable development, and that's centered, also people-centered. If we really want to want to achieve the Africa that we want, and Africa doesn't leave anybody behind. I think we've come to the end of this session. Once again, I'd like to thank all the panel members for their contributions, as well as all the participants who enriched this discussion. Give a round of applause once again to our members of panel. Thank you. Well, thank you very much, Mohammed Ben Atnoun, for this 10th session that you're going to have on the freedom of association, assembly, freedom of expression, and access to information with regard to human and sustainable development. And as you well, I'd like to bid you warm welcome for those who are already lost after these 2 intensive days of work in this joint forum. We this is the very last stage of our exercise with this 10th panel that will go as fast as it can, very fast, so that we don't make you very tired, and wrap up with today's working session. Freedom of association, assembly, expression, rights that are protected by the African Charter on Human and People's Rights. Needless to say, to give you the titles and of rules of the provisions that protect these laws, but I can mention the legal basis, especially Article 9, Article 10, and Article 9, 10, as well as Article 11. As you are all well aware, without freedom of expression, without freedom of assembly, and without freedom of association, our common convention, known as the African Charter on Human and People's Rights, will not be a concrete and living instrument. I always say that it will be a dead instrument without, because it is thanks to these three articles 9, 10, 11 that Africa and human rights can Africans can express themselves, can assemble, can meet. Because if the other laws are not implemented, there should be a mechanism for expression, for assembly, and for association. We should also say that these are these three articles that help to make democracy alive in a country. A country without freedom of expression, without freedom of assembly, without freedom of association is a country that is not alive at the democratic level. It will be a particular model, and states are well placed to know that if in their respective countries people cannot freely express themselves as they want, if they cannot freely meet or associate and come and conduct meetings, then that country is classified as a non-democratic country. I always say, don't forget that we are in Africa. We all know that the right to freedom of expression, I find its fundamental character in the way in which we all behave in our respective traditions. When we were in nursery school, no, rather, in maternity, when a child is born, the midwives give them a small tap, because the child doesn't have to be dumped. The child has to shout, it has to cry, it has to bring out its voice. It's a legitimate reason for pride and for parents. In Africa, sometimes we keep parents out of the maternity, which is not a good thing. We have to allow parents to go and see how the children are born. See, there's few rituals that happen. When that happens, there's small friendly tap to awaken its senses. But when we grow up, this freedom of expression becomes a problem, and at some particular time we start wondering. Once the person is 18 years, they start asking for their rights. They can't say no. Things are not working. Is not in this country. This government is not functioning well. Well, whereas we expected this child to express themselves freely, it's a natural right. It's not a right that is owned by a government or text. It's not an African charter that gave us the right to freedom of expression. It's a natural right, and that is what I think. The same thing applies to the freedom of assembly or association. When children are born, or those who already have children, we all know that after 6 months, the parents are worried if they don't start showing signs of speech. If at 6 months the child is not struggling to walk, we start wondering that maybe something is not right. They should be able to start walking. So it's one way of the child of expressing themselves. When the child becomes an active individual in the society, even walk will mean walk even. So it could be on the streets, but things are regulated increasingly in the society. Sometimes they are prevented to walk just for the right reasons. Information system today, everything, information authorization, everything has been authorized. You have to inform the regime that you are going to walk or you're going to protest rather. So we feel that we have had information that there will be upheavals so you're not going to protest or go walk. So I think it's a very contradictory phenomenon. The little experience I have in the commission, I've been here since 2017. Some countries, and it's not no need mentioning them, and it's the last session, we're not going to start pointing fingers at people. We have countries after they tell us that we don't have any problems if people want to protest. If you want to protest, do so after working hours, after 5 o'clock or even after 6 o'clock. But what's the aim of protesting after 5 or 6 p.m.? So the African states that tell us that, and some also say we don't allow protests unless it's during public holidays. When everybody's at home, you can protest all you want. Some even go as far as saying do so during the weekend, whereas when everybody has a weekly holiday. So it's somewhat complicated. The last country that I like to mention, they think that when individuals are on the streets for up to 10 people, it is illegal. You don't even need to inform or ask for restoration. When there are 10 people on the street, it is illegal. And when there's an 11th person, they just arrest all of you. So where is Africa headed with the freedom of expression and association? And I said, human rights defenders who are trying to freely express themselves are also agents of development. So I'd like to come back to this adjective, sustainable freedom of expression, right to sustainable assembly, sustainable protest. We would like to invite, we thought we should invite prominent experts in the area. Clement Volo to my left. He was a human rights defender who has contributed to this system. He has finished his mandate of Special Rapporteur on the Freedom of Association and Assembly in the United Nations. He's one of the guests that we have to my left. Then after that, we'll have Mr. Andrew Songa that I'm going to introduce very, very quickly. Andrew Songa is an advocate. They are also human rights defenders, just like the other public servants. The Special Rapporteur of the African Commission on Human and People's Rights, Honorable Commissioner Girisha Topsy-Sono, is also a member of this panel, but he will intervene online. I'm going to start with him, by the way.
Start with a quote. If you cannot enfranchise poor people, if they do not have a right to expression, if there is no searchlight on corruption and inequitable practices, you cannot build the public consensus needed to bring about change. That's a quote from James Wolfenson, Voices for the Poor, from the Washington Post of the 10th of November 1999. So freedom of expression is an essential enabler of sustainable development. In addition to empowering individuals, communities, and civil society, it facilitates a wide range of other rights, including those underpinning sustainable development, such as the right to health, education, water, and a clean environment. It allows governments to be better informed and more responsive to the needs of their people. It enables civil society, the media, and citizens to hold governments and corporate power accountable and making democracy meaningful. It also generates economic dividends. Freedom of the press is also fundamental to sustainable development. The press has a specific task of informing the public, ensuring the free flow of information and ideas to individuals. Meaningful access to information.
Please raise up the voice, please, of Commissioner Topsy. Tu peux continuer, collègue.
Okay. A meaningful access to information is also a key dimension of development. As an indicator and driver of development, access to information supports and enables a wide range of human rights, including freedom of expression and the right to take part in government, the right to health and education, as well as cultural rights. Through access to information, the public is empowered to make informed choices, to effectively monitor and hold their government accountable. Measures that foster meaningful access to information includes the adoption of national legislation. Let me quote the African Charter on Human and People's Rights. In its preamble, it states, and I quote, "Convinced that it is henceforth essential to pay a particular attention to the right to development and that civil and political rights cannot be dissociated from economic, social, and cultural rights in their conception, as well as universality, and that the satisfaction of economic, social, and cultural rights is a guarantee for the enjoyment of civil and political rights." Chair, you have already mentioned Articles 9, 10, and 11 of the Charter. We also have the Declaration of Principles on Freedom of Expression and Access to Information in Africa, which dates back to 2019, which states in its preamble that reaffirming the fundamental importance of freedom of expression and access to information as individual human rights, as cornerstones of democracy, and as means of ensuring respect for other rights. Also, conscious that freedom of expression and access to information are cross-cutting rights that are important for the realization of all other human rights, including socio-economic rights, and of the potential of both rights to contribute to the socio-economic transformation of the continent. We have Principle 1, that is the importance of the rights of freedom of expression and access to information. Freedom of expression and access to information are fundamental rights protected under the African Charter and other international human rights laws and standards. The respect, protection, and fulfillment of these rights is crucial and indispensable for the free development of a human person, the creation and nurturing of democratic societies, and for enabling the exercise of other rights. We also have Principle 2, which is on the non-interference with the freedom of opinion. And as Principle 9, we have justifiable limitations. States may only limit the exercise of a right of freedom of expression and access to information if the limitation is firstly prescribed by law, serves a legitimate purpose, and is necessary and proportionate. We also have a model law on access to information, which was passed by the Commission in 2013. A properly implemented access to information legislation holds the promise of fostering good governance by improving information management and enhancing transparency, accountability, and greater participation of the populace in public affairs. By exposing corruption, maladministration, and mismanagement of resources, increased transparency and accountability is likely to lead to better management of public resources, improvements in the enjoyment of socio-economic rights, and to contribute to the eradication of underdevelopment on the continent. We also have the UN Declaration on the Right to Development in 1986, which in Article 6 states that state parties should take steps to eliminate obstacles to development resulting from failure to observe civil and political rights, as well as economic, social, and cultural rights. The decisions of a communication have noted the importance of freedom of expression. I'd cite the Communication on Constitutional Rights Project, Civil Liberties Organization, and Media Rights Agenda against Nigeria, in which there were allegations that decrees issued in 1994 by the military power of Nigeria prescribed certain newspapers, namely The Guardian, The Punch, and the Concord newspapers, from publishing and circulating in Nigeria. It further alleged that the federal government of Nigeria, through Decrees number 678 of 1994, restrained and restricted the right of Nigerians to receive information and to express and disseminate their opinions. In its decision, the communication held that freedom of expression is a basic human right, vital to an individual's personal development and political consciousness, and to his participation in the conduct of public affairs in his country. Under the African Charter, this right comprises the right to receive information and to express one's opinion. We also have Communication 275 of 2003, Article 19 against Eritrea, communication concerning the continued detention incommunicado without trial of at least 18 journalists in Eritrea since September 2001. By applying norms of international rights law, the Commission has previously found and finds in this case that the imprisonment of journalists, and I quote, deprives not only the journalists of their rights to freely express and disseminate their opinions, but also the public of the right to information. Therefore, the action of imprisonment of journalists is in breach of Article 9 of the Charter. Moreover, the Commission held that the banning of the entire private press on the grounds that it constitutes a threat to the incumbent government is a violation of the right to freedom of expression and is the type of action that Article 9 is intended to prescribe. A free press is one of the tenets of a democratic society and a valuable check on potential excesses by government. Therefore, Chair, if development is to be realized, people need the freedom to participate in public life, to put forward ideas, and to potentially have these realized, and to demand, without fear or recrimination or discrimination, that governments uphold their obligations. The knowledge and experience of people living in poverty is often undervalued, and their perspectives on their needs and on solutions to their problems are often ignored. The free flow of information strengthens accountability and transparency, prevents corruption, and increases the capacity of community groups to participate in policy making. It is those communities most affected by poverty which are least able to impart and obtain information, especially relating to basic services. As a result, they are excluded from public debate, unable to influence decisions that have a profound impact on their everyday lives. The media has a specific task of informing the public. It can enhance the free flow of information and ideas to individuals and communities, which in turn can help them to make informed choices for their lives. The poor bear the greatest burden of corruption, due in part to the lack of access to information about the acquisition and use of public funds, which allows malpractice to continue unchecked. The meaningful engagement of the poor and marginalized communities is essential for good development. When people are informed and consultant, and when they can express their views freely and take part in decision-making that affects their lives and livelihoods, we are better able to overcome deprivation, exclusion, and insecurity. By enabling people to be active participants rather than passive recipients of development, freedom of expression promotes voice and agency and improves the quality and sustainability of development outcomes. Therefore, universal access to information is an essential human right with profound implications for the development of a more just, equitable, and transparent society. Closely linked to other fundamental rights, such as freedom of expression, is the right to education and participation in public and political life. There is also the fundamental power to have civil and political rights. These contribute to the plurality and democratization of communication in societies and promotes transparency in governmental access. Access to information is a cross-cutting factor in the SDG framework, but becomes particularly relevant in SDG 16, which, and I quote, seeks to promote peaceful and inclusive societies for sustainable development, facilitate access to justice for all, and build effective, accountable, and inclusive institutions at all levels. Target 16.10 calls for ensuring public access to information and the protection of fundamental freedoms in accordance with national laws and international agreements. Universal access to information not only promotes transparency and accountability, but also enables informed citizen participation. For example, access to information on environmental policies, infrastructure decisions, or economic development plans allows affected communities to express their views and to participate in decision-making processes that affect their lives. While the right of access to information is widely recognized, its efficient and effective implementation remains a challenge for many African countries. For this right to be fully and truly effective, it is not enough to guarantee its legal existence. Governments, institutions, and organizations need to create efficient, accessible, and understandable mechanisms for information to reach all citizens, regardless of their socio-economic needs, status, geographical location, or technological skills. Universal access to information is therefore a fundamental right that not only strengthens transparency and accountability, but also empowers citizens to actively participate in decision-making process. As we move towards a more interconnected and digitalized world, it is crucial that governments and institutions work together to overcome challenges and ensure that this right is accessible to all, regardless of socio-economic status or geographic location. Only in this way can we build a more just, equitable, and sustainable society where information flows freely and contributes to the well-being and development of all people. Thank you, Chair.
Merci beaucoup, Commissaire.
Commissioner Topsi-Sono, thank you for that brilliant intervention. You have showed the nexus between sustainable development and the freedom of expression in democratic countries. We have taken due note of your proposals and recommendations. I will now turn to the Special Rapporteur, Clément Voulet, to take the floor. You have 15 minutes. If you spend 10 minutes, just like Commissioner Topsi-Sono, that will be really appreciated. And it will allow us to move on to the closing ceremony, which also will be very brief.
The Secretary of the Commission, but also fellow comrades from the civil society for attending this session. I think this forum, as I was told, is the second one, but I think it's a good space to continue to support, because it also provides us some time also to discuss on some of issues that cannot be put on the Commission agenda during the public session. So I would like also, in my capacity as a former special rapporteur, to encourage such forum to also, because it's also a space to have certain discussion and also to ensure also that states and civil society and other stakeholders understand that the protection of human rights is, as Commission used to say, is our common responsibility. And no matter where you stand from, defending human rights is fundamental for everyone. And we should continue to create this type of dialogue. I want also to dig a little bit. I know you already mentioned, I will say that you already summarized some of the main issues in relation to the right to freedom of association, peaceful assembly, access to information, as an enabler for the sustainable development. And I want to dig a little bit on this issue because in 2018, when I was appointed as a special rapporteur on the right to freedom of peaceful assembly and association, one of my first reports to the General Assembly was focused on the linkage between the exercise of the freedom of peaceful assembly and association and the implementation of the 2030 Agenda for Sustainable Development. Why I chose this theme at the beginning? Because in my first 6 years, when I engaged with states, regional group at the UN, one of the things that I realized is that there is, in most cases, misconception or misunderstanding about why states should protect these fundamental freedoms. The first thing that I hear from the room when I was sitting with the states, it was always in relation freedom of association, peaceful assembly. They were always seen as a right that enabled political parties. And they were all, every time, opposed to the national security. So this report was really kind of, for me to build an argument that when we talk about the freedom of peaceful assembly, association, and access to the information, we are talking about a right that is in the foundation of any democratic, inclusive, peaceful society. That this right is not just there to give a privilege for a certain group, but is there to enable the society to be able to participate in the public affair and to be able also to challenge and to become the agent of their own development. And most of the cases you will see in some places and some discourse where, for example, these rights is also look at the length of the security issue and sometimes also seen as this is the right that should be opposed to the development. And I think this is really where our discussion should be focused on. And states should be also, and delegates should be also honest to also expose some of their fear. Look back at our history. The struggle for liberation, decolonization, to end apartheid. All of this happened thanks to the use of all people being able to use this fundamental freedom to try to show to the masters that whatever you are imposing to us today is against dignity and is against the Universal Declaration that yourself you adopted. So it's thanks to this right that people, as you and me, communities, were able to stand up and to defend their right and to defend their future. So let me first to dig a little bit on the importance when we come to the development area, and also, but also to, at the second stage, tell you a little bit about some of the challenges that I observed in relation to the enforcement of this right or enjoyment of this right, and probably make some recommendation. How do we move forward? How do we improve this fund? How do we improve the understanding of the essence of these rights, and also how do we improve also the implementation of these rights? We know that when we talk about the peaceful assembly and peaceful and also association, we are talking about the right that enable citizens, either they can be from the community, they can be marginalized community, they can be people that are in margin of the society, to come together in a society where it's important also for them to be able to expose what they are facing and what they are living. And these rights also, what these rights is trying to do also, is that it also mitigating conflict within the society. Because you provide avenue for other people, for marginalized group, those who are not happy, to use peaceful means to come either on the street or to organize themselves to express their view, you are also telling citizens that you don't need to go for the violence means, because we have means that will allow you also to expose your grievance against government, against institution, but also to call for solidarity within the society. Because a society where other aspects of the society is not or do not even think about how others are feeling, is a society that is already building conflict and growing conflict within the society. So it is important. And also when we come to the development, to development sector, we all know how some of the development policy are implemented in our continent, where you have companies coming in one community, decide with the authorities, and then adopt development policy or project and implement them, sometimes without even consulting with communities. So what this right is doing in a community where there is a guarantee of these rights is that civil society then will organize community, helping them also to be able to participate in the design of this project, but also to be able to raise their concern whenever they think that this project is not in their interest. We saw in many countries, for example, where there have been a project implemented and that destroy the ancestral mountain in the country or destroy the community land. Without a guarantee of these rights, which will allow the community then to be able to expose their grievance, sometimes the harm will be done even before the state or some institution will be aware. That's how choosing to protect these rights is not just it's not just a pleasure for any country, but it's the choice of good governance. What you are doing is that you are telling your society that I want you to be able to participate. I want you to be able to help to come together to construct this country. What it does also is that because of the protection of these fundamental rights, because people have access to the information to understand what is this project about, they can go to the Minister of the Environment, they can go to the Minister of Development and receive information without any restriction about why, who is funding this project, why this project, what is the impact assessment that happened. People are able also to become the agent of development because no one then designed the development and come to impose to them. When we talk about the sustainable development, this is a development that puts in the core of the project people. That's exactly what 2030 agenda and also the African Union agenda 2063 is doing, putting people at the center of the development, ensuring that in the process of the development, no one is left behind. It is important to emphasize that. But also one thing that also is important here is also the accountability. One of the challenges we are seeing around Africa is that there's so many projects today. If you look at the development funding, if you look at the aid, how many projects are funded today? And you go to some country, and I was myself, I witnessed some of this in some country that I went, and when I met with the minister, I said, I want to see the communities, I want to see the mining site to discuss with community. And then one minister told me, no, your job is to meet with political party. As freedom of association and assembly is about the politics. It's not about the politics. Because we have seen also many of these projects that was funded by the international community, were funded by the donor with a huge amount of money, and at the end you arrive and you don't see anything. Or you start asking the communities, and community will tell you, we never see anything here. There is no school, there is no water, there is nothing. But when you ensure that community are organized, you ensure so that they have access to information, they are able also to hold accountable those who are implementing this project. They are able also to hold accountable the government and also those who are designing this policy. That's why it's important. So look at this fundamental freedom at the perspective of a better choice of development. If your objective is to ensure that your community to fight against discrimination, to fight against inequality, to fight against poverty, then you need to ensure also that those who are concerned about the design of this policy have tools, peaceful tools, to participate in the design of this policy. But unfortunately, as Chair, you mentioned them, what we are seeing today around the world, and in particular in Africa here, is that the exercise of this fundamental freedom face huge restrictions. And in the name of the same development, in the name of the national security, many states adopt restrictive laws, preventing community to organize themselves, preventing community to be able to come forward to denounce corruption, to denounce capital illicit flight, to denounce mismanagement. And what do you end by saying today is that we invest every year in the project and we are not seeing the light. We are not seeing the end. It is also important that. And also we have also the issue of in many spaces, and this is what we witnessed recently, that human rights defenders that are challenging companies behavior. Communities leaders, social movement leaders that are challenging, what they are facing today is a strategic lawsuits because they denounce mismanagement, they denounce, for example, the destruction environment. They are facing now an ever-ended lawsuit before the court, and sometimes than them being able to continue to support those communities, to continue to deliver service to this community, they end by spending all of their time at the court. And we call also state to say that those strategic lawsuits that usually are handled by or are pushed by companies are against development because they now prevent citizens, communities leaders to denounce the mismanagement and to denounce corruption within those societies. We need also to see some of these strategic lawsuits as a way for the companies also to put on, to take resources without any accountability. That's also important. And then I want to also, I can see that the chair is looking at it more. We need also to reiterate this. And I reiterate it from my 9-country visit that I went in all countries. Development cannot be opposed to human rights. Development itself is about human rights. That's exactly what the agenda, African Union Agenda 2063, and also the Sustainable Development, UN Sustainable Development 2030 is doing. That's exactly development. The goal 16 reiterates that, access to justice, ensuring that communities are able to participate, communities are able to challenge, communities are able to input in development projects are important. And then what we need to do. So my call today, and the call that I have been made as a special rapporteur, the first thing is that restrictive law that is going on around the continent are penalizing development in the continent. It is important to lift some of those restrictive laws. The second thing that is important also, the partnership with civil society. And you will probably agree with me that we are seeing in this returns here the decrease in communication between the states and civil society. Why? Well, civil society is there to serve communities, to deliver service to the community, to complement what states cannot do. We are seeing that it becomes very hard for many civil society to communicate with state. We need to deal with that. And some of the conflict, emerging conflict we are seeing around the continent, is because there is no conversation anymore. There is no conversation on development. There is no conversation in fight against terrorism. There is no conversation. So we need to see the foundation of this fundamental right. Guaranteeing freedom of association, I will end there, Chair. Guaranteeing the peaceful assembly and ensuring access to information as the foundation for building sustainable development. Thank you very much, Chair, and sorry for taking some time.
Thank you. Still useful time. You used like 15 minutes. I'm going to turn towards the third speaker. Mr. Andrew Songa, when you argue a case, sometimes the judges ask you to be brief. Am I lying? When you're in court, the judges usually ask you to be brief. So I'm going to really ask you to be brief, not without comparing you to Clement, who sometimes is difficult to stop. So please, 10 minutes.
Especially after the two esteemed panelists before me have set the stage accordingly. I had hoped that my presentation would be displayed, but I will still be able to continue nonetheless in the hope that eventually it will be able to be seen. So without belaboring the points that have already been highlighted and appreciating the foundation that had been laid by both Clement and Commissioner before him, I think we've entered a point where we can concede and agree about the interdependence and indivisibility of the rights under discussion, whether it's freedom of expression, access, information, and generally broadly the rights enshrined within the African Charter when it comes to also reflecting on the right to development. And for me, it's to then lend my voice to the connectedness between the right to development and the right to participation, as envisioned under Article 13 of the African Charter, and then make the case for digital civic space as a facilitator for that public participation to then bring meaning and enhancement to the right to development. And you will see there, I borrow from the language of the African Commission's resolution that sets the stage for them to develop a general comment on the right to development in Africa, where it consistently emphasizes that persons are entitled to participate and contribute to the envisionment of development and sustainable development at that, and that connectedly the enjoyment of the right to development requires the full enjoyment of all human rights, as Clement was trying to effectively lead us through in his presentation. Then coming on to what would be considered the development blueprint for Africa, which is Agenda 2063, again, you will see the emphasis of a people-driven development agenda. And as I mentioned already within Article 13 of the African Charter, the right to participate again echoes the importance of citizen involvement within the different facets of governance, which would include development. And then I would only add the African Charter on Democracy, Elections and Governance, where at Article 30, it emphasizes the promotion of citizen participation as part of the development process. So that then you could say summarizes a series of constitutive elements to public participation. And that is the fact that we should have inclusive policy making, which again I think was highlighted by the previous speakers, in that citizens must be availed with opportunities to contribute to policy discussions or legislative processes that are the pathway to articulating developmental agendas and plans. Again, no need to belabor the emphasis on access to information, because access to information ensures that informed contributions are made by citizens towards their perspectives on developmental agendas, and then being able to impact government at the most local levels, and again, as was raised by previous speakers, being able to hold policymakers accountable for the decisions that are made within articulating developmental agendas. And so where would digital engagement and civic technology fit in all this? Again, you could turn to the guidance that is already in existence through various aspects of the African Union. Digital transformation strategy for 2020 to 2030 actually looks at technology and digital engagement as a bridge to inclusive and integrated societies. So that when we're thinking about economic integration, when we're thinking about other facets of social development, as I'll highlight shortly, and also as a factor of development, you will see that, again, technology and the aspects of digital platforms are at the centerpiece of strategies that governments are beginning to embrace. And then, of course, there's the notion of e-governance, where governments in themselves are embracing online platforms, and digital tools to be able to provide both information and services to its citizens, and also providing facilities through which citizens can provide input and perspectives on different policies and government actions. But it's not only from the government side. There's also a pull factor from citizens and civil society at large, and that's the aspect of civic technology, where civil society in itself is innovating and creating tools or utilizing digital tools to strengthen how they engage in governance affairs, in how they're able to organize and mobilize, as Clement was suggesting, to be able to agitate and raise demands or speak out against things they feel are going wrong. And that connects to the notion of a digital civic space and activism, where then you're using these civic tech tools to maybe even counter aspects of democratic deficits, where perhaps there's a disconnect between the people and their representatives, finding aspects to take up your own agency and speak up and articulate what your demands would be for development, and to just directly participate in the discourse. But then also to be able to mobilize towards a common action or a common agenda that can then be used to influence decision makers. And therefore, you would have two approaches to digital civic engagement. That would be one that is interactive, that invites people to be able to access information and data so that they can be able to understand complex development processes or policy discourses, or it could be action-oriented, designed to drive people to act and make demands or contribute very directly in governance processes. I won't go into too much detail, but this, I would speak from direct experiences that we've had as the European Partnership for Democracy in implementing a project known as the Charter Project Africa that was emphasizing the amplification of citizen engagement in democratic governance through the use of civic technology. And just to quickly show, in a span of 2 years when we implemented this project, the good news is there's a lot of innovation and proactiveness that exists within African civil society when it comes to utilizing digital civic space and civic technology tools to elevate public voices or citizen voices when it comes to matters of governance, including development. We had 29 innovative projects that we were able to support across 9 African Union member states, and some of them were about knowledge generation, some of them were about amplifying voices into policy-making processes, and some of them were also about creating accountability platforms where people could understand and follow up and hold their governments accountable. And these are just some of the examples very quickly. Innovative projects, for example, that would be used to trace development projects on the ground and be able to feed in direct inputs from citizens on the ground as to whether these projects are being implemented or whether money is being lost, demystifying parliamentary or other policy development processes that are connected to developmental agendas that would then allow citizens to provide inputs. And based on that experience, we are actually currently implementing another project called Digitalize Youth Project, because another element of the digital civic space is to also duly note and amplify the most potent voices, which is the youth voices, and how they're innovatively using this space to raise the prospects of their participation in political discourse within their respective countries, and therefore contribute to developmental discourses as well. This project will then be covering at least 14 countries around the continent, and the emphasis is to then look at some of the contemporary challenges, like addressing misinformation and disinformation, and addressing the shrinking civic space that also actually does apply to the digital space. And this is what I will begin to quickly turn to as I start to close. The existing challenges, which are not unfamiliar to many of us. The fact that just as we talk about shrinking civic space in the physical sphere, we also now have shrinking civic space in the digital sphere, whether it's in terms of internet shutdowns, as a backlash to some aspects of activism, cyber surveillance, and also, as Clement highlighted, the use of punitive or restrictive laws. So we've seen variations of laws around information, around media laws, and also cybersecurity that are used in a very punitive way to then act as a backlash to those who engage in activism through these tools. There is an ambiguity in aspects of regulating the digital space. And one of the interesting aspects that has emerged is the roles that multinational companies who own these platforms, what roles can they play in terms of self-regulation, because they have a lot of authority in terms of how those platforms are operated and controlled. So therefore, there's an incumbent obligation on them to be able to also self-regulate and regulate those spaces to ensure there's no infringement of rights. But then also, how do our governments regulate those institutions, especially from the way they operate, domiciled elsewhere, but having very clear impacts on how our democratic contexts operate? Gender-based digital harassment is a very clear and present danger that continues to unfold within that space. And then there's the reality of the polarization, disinformation, and hate speech that has been accentuated on social media platforms. Vulnerabilities of cybersecurity and limited internet access are also clear present dangers. So I will still 1 minute, Chair, just to touch on some series of recommendations. Based on that backdrop and the potential that digital civic space holds to enhancing public participation and therefore enforcing the right to development, I think there is a series of measures that can be undertaken to strengthen the prospects and reduce the perils of digital engagement. And so obviously one of the primary responsibilities for the state would be to make it more accessible, as Commissioner in the very initial remarks raised. So let's improve the infrastructure for internet accessibility. Let's make it more affordable for citizens. And then let's continue to develop the normative frameworks and guidelines around key pillars like cybersecurity, artificial intelligence, and open governance. And I'm pleased to note the African Commission is taking the lead, particularly on artificial intelligence, with a study that's bound to be able to make these issues clearer and therefore create the stage for better elaboration of normative guidance to states. Coordinate with other organs within the African Union to be able to drive this agenda and to harness the potentials of digital engagement, and then increase the support that can go to innovation by citizens by creating more platforms such as the African Union Civic Tech Fund and the kind of grants and fellowships that can go to young innovators. Thank you very much, Chair.
Thank you very much, Andrew, for this good statement and the recommendations that have been made. Thank you very much. Nous allons maintenant nous tourner vers notre...
Our very kind audience and find out if they've got some input, some quick comments to make. As a moderator, I think I'm going to limit the number of people who have to, the number of speakers. Time is against us at it's 17:43, and they have just been informed that by 18 hours we have to wrap up the session. Is there any state delegation that would like to make any contribution? Yes. Any? Yes, we have Côte d'Ivoire. Please, delegates from states, use just 1 minute because we also have the closing ceremony. Straight to the question, please. Thank you, Honorable Chair. I'm going to be very brief. I'd like to greet all the panel members for their enlightening presentation. I agree with everything that has been said, especially the importance of this right, access to information, freedom of expression. These are fundamental rights. One of the challenges that we face, it is true that we talked about the laws that restrict the civil space. We know that the channels used today to exercise these rights, among others, we've got the social media. I'd like to also say something about the responsible use of these channels. That's what I have as import. Thank you for having been very brief. Do we have any delegates, any more delegates? Eritrea?
Panelists and the Honorable Commissioner for excellently organizing this panel discussion, which was very insightful and informative. To go straight to my point, I just wanted to explain on the basis of the responding on the explanation given by Her Excellency Commissioner Topsy Sono regarding Eritrea about the freedom of expression. There was an issue in 2003, and that issue has been responded by the state of Eritrea many times, but just for the record, to make it clear again, those who are detained were not detained for being journalists, but for other crimes committed through the cover of journalism and communication. I want to make this clear. I thank you.
Thank you very much to the representative of Eritrea. Est-ce qu'il y a encore un État qui souhaite? Yes. No, NHRI after. Member state first. If there is no member state who is requesting the floor, then you can give the mic to the NHRI for 1 minute. Not more than 1 minute, please. You have the floor.
Thank you. All protocol observed. Thank you, Chair. My name is Ms. Jessie Majoma. I'm the chairperson of the Zimbabwe Human Rights Commission. And I have a question to our special rapporteur that given the security jitters that states usually have around the right to freedom of assembly and expression, do you think there could be some assistance given in terms of building the capacity of states for them to better manage crowds and crowds control and demonstrations so that maybe they would also feel confident that they can manage any security threats? And also, on the other hand, do you think it would help to also maybe redouble training for, or just information around the right to freedom of expression? Because sometimes violence does occur where certain maybe political activists also wish to have other means, but they can also recruit how can I say, unwitting or sometimes unsuspecting members of the public to join the fray when, peace isn't at stake. What can be done about that? Thank you.
Yes, we thank you very much. Is there another NHRI who want to take the floor? Another NHRI who want to take the floor? I don't see anybody. Civil society organizations. Civil society organizations. Nobody want to take the floor. Thank you very much. Who want to take the floor? Il y a quelqu'un? Yes, civil society organizations. You have 1 minute also for your inputs.
Yeah, thank you so much. My name is Justin Hamera. I'm the acting director for Child Affairs in Malawi. I wanted to make this contribution yesterday, but I think some of the issues have come out today as we're talking about the freedom of expression regarding to issues of cybersecurity as well as how children need to be protected. I'm seeing that these platform owners, I think they were more responsible previously, such that they created portals to control some sensitive, kind of information and images. And that, I think, worked well for us. And when African Union recommended to countries to come up with action points for addressing issues of cyber and whatever, I think we are in the same line. But lately, particularly from last year to date, it appears like these platform owners are no longer being held responsible, such that we're seeing a lot of sensitive kind of images that are also affecting the children. I don't know whether the African Union and the team can have special guidance and recommendations to such. I think that's the area of my interest. Thank you, Chair.
Yes, thank you very much. Okay, now I come back to the podium. No, I want to ask to member state again, if there is any member state who want to make an extra comment. Member state? Nobody wants to take the floor. Thank you very much. So we come back to the podium so that we can make final observations. I will start with you, Commissioner Girisha Topisono from Mauritius. If you are online, yes, I will give you just 2 minutes maximum, 2 minutes.
Yes, Chair, I'd just like to mention, to respond to the NGO, to tell him that the Commission has just passed two resolutions, that is 630 and 631, wherein the Commission has mandated me to produce guidelines for tech companies. So if he can look these up, and we will be asking contributions for the development of these guidelines. So he can see, he will be able to see from the website of the Commission. The lady from NHRIs, we can help globally to look at the laws and help that particular, any particular country. But as she realized, we cannot get involved in day-to-day management. Thank you, Chair.
Yes.
Issues that were raised by the NHRIs and as well as the NGO. Thank you.
Yes, thank you very much, Commissioner Girisha Topisono, for your contribution and for your commitment for the successful of this panel. Clément, you have 2 minutes also?
Yes, I can take this one. So thank you very much. I think regarding the question on the cybersecurity, I will leave it to you. But I want also to say from the Zimbabwe NHRIs that I agree with you. Most of the cases, at least during my mandate, one of the challenge really that we saw and that we raised with country is really to finding the balance between the security imperative and protection of the rights. And this is where most of the states will balance more on the security, and then some will also show through the study that when you protect, when the balance is more from the right, then you protect more the security, because at the end, the security is about the people, it's about also making sure that marginalized people, those who are not feeling, they can have access to justice and all of those things. So I think this is the main problem. That's why when I was leaving the mandate, one of my main contribution, and which also was requested by the Human Rights Council, is to find a way to ensure that law enforcement, one of the pillars of democracy and one of the pillars when we talk about the protection of these rights, can protect these rights in accordance with international norms. So what I did is consulting law enforcement around the world and coming up with what we call today UN model protocol on law enforcement to protect human rights within, in the context of peaceful protest. And this model protocol is there, asking law enforcement, asking state, you need to change the way and the protocol that is in place. You need to understand this fundamental freedom that is not about the right that law enforcement can decide how people can exercise this right, but the duty which is in the Constitution, which is under the international norm, is that the duty of the state is to facilitate the enjoyment of the rights. So this protocol is there, and within the UN spaces, the protocol now we are using it for training, and I want also to be able to call all the states, because it's in the interest of the state to understand what are the new methods and the new way that we can, new strategy that we can provide to law enforcement to facilitate peaceful protests without resorting to the restriction and in accordance with international norms. So yes, we can discuss more of that after this, sorry.
Yes, thank you very much. So just a precision that Clement is talking about the protocol, additional protocol on the International Covenant of Civil and Political Rights in the context of UN. Am I right? The UN, yes, the one you left to the UN as a legacy. We'll continue to make the advocacy so that this protocol can be adopted by member states. Now I give you the floor.
Okay, thank you very much. Just very briefly and quickly, I think the contribution from Malawi was correct. There is a deterioration with regards to some of the controls. And at the heart of it is the deterioration in content moderation. And I think one of the things that should be done is there should be more robust engagement between our governments and these companies with regards to requiring them to uphold their obligations on content moderation, ensuring that there's a requisite framework behind content moderation, perhaps also reinforcing the self-regulation obligation by requiring a very robust and elaborate code of ethics that they voluntarily subscribe to. And if that doesn't work, then we also must begin to conceive some elements of punitive action with regards to the failure to live up to those obligations and those ethics. And just to close with an example, there's very interesting case law that is beginning to emerge in that regard, where there's aspects of civic action being taken against some of these companies. If you look at the Meta particularly, they are beginning to face more and more litigation across different jurisdictions with respect to these issues of them failing to uphold their obligations. And it would be interesting to see the kind of jurisprudence that emerges from that and whether it can then inform some of the frameworks and the guidelines that we can put with regards to regulation. But then to just close, as with all forms of regulation, there must be an aspect of balance so that we don't also overcorrect and get to a point where it stifles innovation or stifles civic space, but then we must have those necessary safeguards. Thank you, Chair.
Yes, thank you very much. Le modérateur va conclure aussi en 2 minutes. Je voudrais simplement, c'est difficile de résumer des experts aussi compétents que les 3 panélistes que j'ai eus, mais je peux vous proposer provisoirement, et comme on le fait dans les dispositifs de jugement, par ou pour ces motifs, nous pouvons considérer que, comme l'a dit la commissaire Topsy, la réalisation de tous les droits de l'homme, et les droits de l'homme, ce sont les objectifs de développement durable, n'est pas envisageable sans une liberté d'expression. Ça, c'est une certitude, et toutes ces idées ont tourné autour de ça. Deuxièmement, et comme l'a dit le rapporteur spécial, l'ancien rapporteur spécial Clément, le Freedom of Association and Assembly a un impact certain. D'ailleurs, il a commencé par là son mandat, comme il a dit, sur l'agenda 2063. Pour ça aussi, je veux te remercier, Clément. Nous avons besoin de...
We need all those ideas. And like Andrew said, the interdependence and the indivisibility between the freedom of expression and freedom of association, of meetings with respect to the sustainable development objectives is quite important. It is important for the states, and there is need to operationalize digital space to allow the civil society to express itself freely so that it can deliver the message. Anytime that they have the impression that the SDGs are violated and that they are off tracking from the trajectory which leads us to development. Without this, we cannot develop. I would conclude by telling the states, reminding them of this recommendation. If it is difficult for you to civil society to demonstrate, take the example of Switzerland. For all those who go to Switzerland, before the Palace of Nations, you have a place meant for demonstrations. No violence. They go to a specific area. People have banners. People have grievances. They go there from the morning to the evening, and then they will submit the memos to the authorities. It is a type of manifestation, type of demonstrations, which will help you to go ahead. So this is a good practice. So this is what I can say by way of conclusions. On that note, I thank all the panelists, and I therefore put an end to this panel. We deserve a round of applause, I believe. I would now hand over the floor to the protocol for today's closing ceremony.
Thank you, Chair, and thank you for all your guests, and very thank you to everyone in this room. We come to the end of this second version of our our dialogue. Let me allow to ask my colleague Bruno to present the final part of this event. Thank you very much.
Chairperson of the Commission, honorable commissioners, dear member state, excellencies, greetings. I have the assignment to moderate this closing ceremony of the second joint forum of special mechanisms. It is an arduous task because I do not have the wherewithal to give any instruction because they are all my bosses. I cannot stop them, so I would urge them to be brief. It has been a long day and we are all tired. 2 days of deliberations, more than 10 hours of deliberations, 47 people who intervened and several moderators. Now, when you count the 10th session that we have and 11th will be the closing ceremony, then the total would be nearly 5 interactions on the part of the public. Well, my arithmetics is not very brilliant, but then this activity has been crowned with success, with excellent participation. We would like to thank you. The closing ceremony would be very brief. Let me share with you the contents. 4 main interventions. The first intervention is the one that would give you the deliverables that we have for these 2 days, namely the declaration which we read by Commissioner Sassi. Thereafter, we will hear the declaration of state parties which would be assigned to the Democratic Republic of Congo. I greet Professor Mulumba Mate, who would do the declaration of state parties. Thereafter, we would have what the English speakers would say, vote of thanks. It is a vote of thanks on the part of the Commission for all the participants. Ladies and gentlemen, this will be catered for by Commissioner Derso. Thereafter, the closing remarks of the Honorable Chairperson of the African Commission on Human and People's Rights. In a nutshell, that is how the closing ceremony would be rolled out. Without much ado, I will call to the podium Honorable Sassi to read out the declaration under a round of applause, obviously. Thank you, Mr. Bruno. Distinguished ladies and gentlemen, honorable state delegates, representatives of international and regional organizations, representatives in NHRI, civil society, please allow me to read the final declaration of the second joint forum on the special mechanisms of the African Commission on Human and People's Rights. Considering that the African Commission on Human and People's Rights had convened the second joint forum of the special mechanisms of the African Commission on People's Rights, considering that the objectives of this forum are as follows. Number 1, to strengthen multi-stakeholder dialogue, enhance institutional capacities, encourage collaborative partnerships, and develop concrete policy recommendations. Considering that there were 239 participants in this joint forum, including 11 commissioners, 70 representatives from state parties, 4 representatives of the AU organ, Department and Specialized Institutions of the African Union, 2 representatives of international organizations, 7 representatives from national human rights institutions, 105 representatives from the civil society organizations, 5 representatives from the media, and finally, more than 35 staff members from the Commission Secretariat. Considering that discussions during these sessions centered on 8 main items. Number 1, align development assistance and investment with socio-economic rights and sustainable development obligations under the African Charter, the promotion and protection of the right to health as a prerequisite for sustainable development in Africa, promote inclusivity in development by protecting the rights of vulnerable groups, respect for life and human dignity, for harmonious and inclusive development, balancing prosperity and equity for social justice in Africa, justice as a pillar of sustainability, the fight against conflict, climate and development-induced migration, and finally, freedom of association, assembly, expression, and access to information as enablers of human and sustainable development in Africa. Considering that the participants have underscored the fields of concern, areas of concern, such as, number one, extreme poverty in many African countries, limited access to food, healthcare, education, and clean water, development partners prioritizing civil, illicit financial flows, rather, disparity in access to education, limited access to financial capital, absence of universal health coverage, lack of collaboration among states when it comes to building strong health systems, lack of disaggregated data on child protection, extrajudicial executions in the fight against terrorism, enforced disappearances, marginalization of indigenous people, the low number of states that have deposited declarations allowing for direct access to the African court and people's rights, and the need to tackle the reasons behind forced displacement linked to conflicts and climate change. The state now, to gain time, these are the following recommendations. Please allow me to just read 2 or 3 recommendations for state parties, because the other recommendations have been published on the in the site of the Commission. Let me start with the recommendations made by the foreign to state parties. And here also, I would go by session. The first one is devoted to the first session, that is to say, aligning development assistance and investment on economic and social rights. The forum recommends to the state parties, number one, to reimagine development not just as a technical goal, but as a moral and political imperative rooted in dignity, agency, and well-being of citizens. Make socio-economic rights justiciable and decline assistance that does not align with national priorities, with respect to the promotion and protection of the right to health as a prerequisite for sustainable development in Africa. The forum recommends to the state parties, number one, to adopt legislative and policy regulations which enhance access to healthcare, to tackle the issue of brain drain to ensure retention of doctors and other healthcare workers in Africa by creating a conducive environment for them. And finally, in the national budget, to allocate financial resources for quality health service in accordance with the Abuja Declaration. Now, on the issues relating to the promotion of inclusivity in development for vulnerable groups, inter alia, prisoners, persons with disabilities, older persons, women, refugees, and IDPs, as well as for children. The forum recommends to the state parties to include vulnerable groups in development frameworks and other public national policies, and also to adopt an approach based on human rights in budget preparation. With respect to human life and dignity for harmonious and inclusive development, the Forum of the Special Mechanisms recommend to the state parties to strengthen international cooperation in the fight against terrorism, to take the necessary measures to establish or re-establish a moratorium on death penalty and to move towards its adoption, and to adopt independent national mechanism for prevention of torture. Now, with respect to the issue of balancing prosperity and equity of social justice in Africa, the forum recommends to the state parties to issue collective line certificates in appropriate cases in order to guarantee security of tenure and prevent forced displacement, and also to integrate the rights of indigenous people and other marginalized communities into their development plans. With respect to justice as a pillar of sustainability, the forum recommends to the state parties to ratify the protocol establishing the African Court on Human and People's Rights, and to deposit the declaration allowing individuals and non-governmental organizations direct access to the said court. And also, the judges should use the international convention ratified by the states in their rulings and decisions. With respect to the issue of combating migration caused by conflict, climate and development, sustainable development, the forum recommends to look at the profound causes and to immigration, and to ratify and fully implement the Kampala Convention, and also to have a comprehensive and coordinated response to strengthen the protection of displaced persons and migrants by attacking the root causes of this migration. Now, with respect to the last panel that was devoted to freedom of association, assembly, expression, and access to information as catalysts for human and sustainable development, the forum recommends to the state parties to use social networks and to increase the use of civic technology and digital engagement within citizen engagement strategies, inter alia in the arenas of citizen mobilization, learning, and knowledge management. Furthermore, the forum would like to address some recommendations to the African Commission on Human and People's Rights. Inter alia, establish a comprehensive framework on the implementation of the right to development, to continue to advocate for the ratification of all human rights treaties of the African Union, and also to mobilize the development partners and the private sector players to ensure that economic growth respects human rights. The forum recommends also to the organs and the departments of the African Union which have a human rights mandate, number one, to promote inter-African trade and free movement of people, establish within the Executive Council a committee to implement the decisions of the judicial and quasi-judicial bodies in Africa, and finally to establish an action for failure to enforce. Now, to the civil society organizations, the Forum of Special Mechanisms recommend to the civil society organization to cooperate with states to ensure the realization and effective application of the right to health, and support the efforts deployed by the government, and to provide training in human rights and access to regional justice. Now, to the judicial and quasi-judicial bodies, the forum recommends that judges should use international conventions that the state have ratified by the state in their rulings and judgments, that the court should also promote and encourage the implementation of human rights treaties and human rights decisions of the Commission on Human and People's Rights, as well as other human rights mechanisms. Finally, to national human rights institutions, NHRIs, the Forum of the Special Mechanism recommends to popularize and disseminate the human rights instrument of the African Union, inter alia, on the right, and popularize the human rights approach to development based on human rights, and to support the implementation of decisions and recommendations of the human rights organs of the African Union, particularly when it comes to socio-economic rights. I thank you, ladies and gentlemen, for your kind attention. Thank you, Honorable Commissioner Sassi. We have the roadmap of the 2 days of this deliberation. The state parties, non-government organizations, as well as all the other parties, national human rights institutions, organs of the African Union, all of the above are now aware of what the recommendations are. And the idea here is to concentrate on 2 recommendations of each, but then the recommendations are diverse and they would be in due course at deliberations of in private session. You have received a brochure with a code, a QR code. This is a code that you can scan and then give us a feedback on this activity. The idea will enable the Commission Secretariat to serve you as much as possible for the next forum. We would kindly request you to fill this feedback form. It will go a long way in improving the performance of the Commission. Now, without much ado, I will call upon the head of delegation of the DRC, Professor Mulumba Mate. He is the advisor to his president, His Excellency Felix Tshisekedi, main legal advisor of His Excellency the President, and he will come here to the podium to deliver the closing remarks for the state parties. Thank you, Excellency. I do know that we are all tired, and Professor, you have the floor for exactly 5 minutes. Excellency, distinguished participants, distinguished ladies and gentlemen, it is for us an honor bestowed to the Democratic Republic of Congo to take the floor on behalf of the state parties who are participating in this second joint forum of the special mechanisms of the African Commission on Human and People's Rights. Under the theme, Human Rights, an imperative for sustainable development based on populations in Africa. Thanks to this theme, we have particularly listened for these last 2 days. We have listened to the relevance of this theme through the discussions, fruitful discussions, crowned with practical recommendations, functional recommendations, and consensual recommendations. Indeed, Article 22 of the African Charter on Human and People's Rights places the basis for any economic development, social development, cultural development. A state has no raison d'etre if it does not aim to ensure that it does not roll out these development policies for their populations. This is what each of the state parties to the Charter should do. And now, this Charter, the founding fathers of the African Union and the African doctrine have, and in their wisdom and future looking, they have included the right to development. Once again, they should pay tribute to them before this vision that arrives before time, and which enable us today to look at all the values in human rights and development, peace and development, because sustainable development and also there is need to promote human rights. This is only possible a peaceful atmosphere. Let the weapons not be silent. Our population desire peace. This is not negotiable. We should establish a conducive atmosphere so that the enormous potentialities of our populations can benefit from our natural resources with a view to ensuring sustainable development. We can absorb our differences in a civilized manner through discussions without resorting to violence, whether it is physical or other types of violence. the various panels have affirmed that sustainable development of the African states is inextricably to promotion and protection of rights. The panelists have very need to put in place in a holistic manner to look at issues of human rights with particular attention for the most vulnerable sectors of our society. Africa is fundamentally community-based, and this is why we are unique. We go ahead with our strengths and our weaknesses, and we remain an entity which has to, it goes without saying, we have to come back to our steps so that we will bring along our sisters and brothers who have been left behind. Thank you to the commissioners. Thank you to the panelists. Thank you to participants for your brilliant ideas and recommendations. We would like to encourage and urge the Commission to continue on this initiative in which our state parties are involved, as well as any other stakeholders, with a view to putting in place the necessary correlations between special mechanisms of the Commission and also with the various stakeholders. We will urge member states of the African Union to work more to ensure adherence to human rights and to participate in the deliberations organized by the African Commission on Human and People's Rights. Africa has made a strategic choice in its policy, in its vision as enshrined in Agenda 2062 by placing. Now, we have to give ourselves the wherewithal and work resolutely towards this end with a spirit of optimism of people who know their fate bound on their resources, human soil resources, natural resources, and the desire to be united and to do better, to come up with a realistic future. So the concretizations of this agenda, it goes without saying, goes around the benefits by our population in each member states, and not only in policy discourse. Very soon, the third forum of special mechanisms will see the light of day, and we hope that it will throw light on the inroads that have been made when it comes to the implementation of recommendations coming from this present edition, which is concluding on a good note of optimism and a real desire to promote and to protect as much as possible human rights, which is a sine qua non for development of all and sundry in a sustainable manner. Long live the African Commission of Human and People's Rights, and thank you for your kind attention. Thank you, Professor, for the poignant discourse on the part of the member states party to the Charter. So, thanks to a round of applause. African Commission, we acknowledge your support, and this would be through a vote of thanks to be pronounced by Commissioner Haile Elemon Dorso, who at one time was the chairperson of the African Commission on Human and People's Rights. Honorable Commissioner, you will say the vote of thanks to everybody, including to my good self. I thank you.
indignity that millions of people on the African continent suffer, you would realize how pressing this quest for development is in Africa. I will just mention one statistics. 1 in 5 people in Africa, 1 in 5 people in Africa are faced with hunger. And this is more than double the global average, which is 1 in 11 people. We are talking about millions of people here in hunger. In 2022 alone, just in a single year, over 20 million more people have been pushed into severe hunger. Now we are going into the extreme end. 20 million people into severe hunger. You know what this is? This is basically the sum total of the entire population of Botswana, Namibia, and Zimbabwe. Just let this sink in. The entire population of Namibia, Botswana, and Zimbabwe. Over 20 million people, just in 1 year. And you can look at the statistics for health, you can look at the statistics for education, you can look at the statistics for other issues. All right? Now, the final point that I wish to make, basically the essence of what I'm saying is, this is the most as pressing as it has ever been for Africa. And this is also the continent that is said to be endowed with immense natural resources, yet this is the poorest in the world. And therefore, the subject matter that we have been dealing with during the past 2 days is the subject matter that speaks to the woman who loses her life while giving birth because she couldn't be provided with medical assistance. It speaks to the displaced person who couldn't have access to food and therefore is starving to death. It speaks to the millions of unemployed youths on this continent. And this is one of the issues which is the litmus test of whether or not this human rights system is relevant to the lived realities and experiences of people on the African continent. So, what are we talking about? We are talking about, when we talk about the right to development, 4 things. I will say those 4 things and conclude. The first one is development is about creating the conditions for enabling people to live a life of dignity. It is about creating those conditions necessary for enabling people to live a life of dignity, having access to the essential, the basic necessities that make a dignified life possible. That is the first one. The right to development, second, is about the means for creating these conditions. That a dignified life through access to basic necessities possible. That is why talking about natural resources, talking about policy space, autonomous policy space, talking about the international economic relations of Africa is so critical. Do African countries have the policy space to tax economic activities that are undertaken within their jurisdiction? And how much money is actually taken out of this continent. 90 billion each year from illicit financial flows, bleeding the continent. So, the second is the means. When we talk about the means, it is about the resources. And that is where much of the contestation lies. That is why the reform of the international financial institutions, the reform of international tax cooperation, mobilization, the regulation of businesses, including their compliance with human rights standards, is a prerequisite for us, including ensuring that natural resources are made to benefit first and foremost the people, because that is the promise of Article 21(1) of the African Charter on Human and People's Rights. 3, the right to development is about the process for creating these conditions that make living a life of dignity possible. What is the process? Are people participating? The right to participation that you mentioned. What are the obligations of the state? Of society. Fourth and finally, the right to development is the accountability mechanisms that are put in place in order to ensure that the resources of a country, the laws of a country are put in place in such a way that they are actually deployed for creating these conditions that make a life of dignity possible for ordinary men and women. Where accountability is lacking, it is not possible to have any of the three. That is why the role of this commission and institutions like it so important. And it is for this reason that I stand before you to say to each and every one of you, thank you very much for making this a subject of our deliberation for 2 days. But please remember that this is not the beginning. The struggle for development in Africa is a long struggle, but we have to be, each and every one of us, an agency for realizing the success of that struggle. Thank you all very much for your kind attention.
Merci, honorable commissaire Derso. Et vous l'aurez compris, à la commission, nous avons de véritables passionnés, des professionnels. Il a rempli son cahier de charges, mais
He has, though he exceeded the time through passion, to remind you that these 2 days were very important. Once again, let's give it up for him. We're going to pass, going on now to the last act of days, and this will be the closing speech of Honorable Commissioner Professor Remy Lumbu, who's going to give us his closing speech. A round of applause for him. You have 6 minutes, Honorable Chair.
Delegation of member states, NHRIs, civil society organization. This is the end of our 2 business days, during which we have put it together, our mind, our ideas to help our beloved continent to face the right to development. Having in mind the Common Agenda 2063 and the UN Sustainable Development. The final communiqué have been presented by Commissioner Selma Sassi, And all your recommendations are inside. I want to thank Commissioner Selma Sassi, Professor Selma Sassi, for this paper that she has read. Allow me also to thank Professor Martin Mulumba, who is the legal advisor of the President of the Democratic Republic of Congo, His Excellency President Félix Antoine Tshisekedi Mulumba, who spoke on behalf of all the member states here. I thank you, Professor Martin Mulumba. Our former chairperson and Commissioner Solomon Ayele Dosso is also given some key lessons during the vote of thanks. I want also for him, thank him for those elements that are also very, very important. Now I will just commend all my colleague commissioners who participated to this joint forum, those who are physically here in Banjul, and those who could not attend this forum, my vice chairperson, Honorable Ramatoulaye Salanjai, Commissioner Gerisha Topsi Sonu. We have also Mwandenga and Commissioner Maria Teresa from Angola. They have participated to this joint forum virtually according to our rules of procedure. I want to thank Madam Abiola Ido Ojo and all the teams of our inside our secretariat, because they worked a lot for this second joint forum. And I wish to them all the best. I know that as far as we are going to finish this, they will start to prepare the third edition that we are going to have in 2026. In my capacity as the chairperson of the African Commission of Human and People's Rights, on your behalf, dear colleague commissioner, I declare close the joint forum, and I want to thank you all for your participation. Thank you very much.
Merci beaucoup, professeur. Merci, mesdames et messieurs. Et c'est ainsi que prend fin la deuxième édition du Forum des mécanismes spéciaux de la Commission africaine des droits de l'homme et des peuples. Et rendez-vous à la troisième édition avec des informations qui vous seront communiquées en temps opportun. Mesdames et messieurs, avec la permission de Madame la secrétaire qui est la maîtresse de cérémonie de cette session globalement, je...
Masters of Ceremony, I'd like to wish you a good evening, and let's reconvene tomorrow at 9 a.m. And please do not forget to fill out your experience, your feedback on the form that was submitted to you. Thank you very much and goodbye.